Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, February 10th, 2026. We have 11 bills on the docket, and we're going to start off with Senator Hettleman, and then we'll go to Senate Bill 391. But Senator Hettleman with Senate Bill 472. Welcome back.
And members of Judicial Proceedings, I'm Shelley Hettleman, District 11 Senator. This is a really brief bill, Senate Bill 472. All it does is, it's a technical bill. Every 10 years, Baltimore County has to update its local code, and because it's a charter county, there are express powers delegated to them by the General Assembly. And because their code and any supplements contain laws enacted by us, when they update their code every 10 years, we have to approve the updated code. Senate Bill 472 provides that approval and reflects the same language and action taken in 10 years ago when we last updated the code. I will tell you that the delegation, Senate delegation, considered and voted on this bill yesterday, and you should have in your possession a letter from the delegation indicating as such. That is all.
Thank you very much, Senator. Questions from the committee? All right, seeing none.
Thanks so much.
Easy. All right. With that, that'll conclude the hearing for Senate Bill 472. We'll now move on to Senator Mouts with Senate Bill 391.
Thank you, Mr. Chairman, Mr. Vice Chair, distinguished committee members. It's an honor to be able to present Senate Bill 391. This bill was unanimously approved by the committee. Thank you very much last year, and by the House last year. It creates a minor exemption for notice for Dorchester County for leasing of property for terms of less than 5 years with an annual rent of $750 or less. It may seem minor, but this is a priority for Dorchester County. They've requested it last year, and they've come back again this year. I'm not sure why it wasn't approved by the House. I think time might have been an issue last year. There should be a letter of support from the county that was delivered today. There should be a letter from the delegation of we voted in favor. It's a one-member delegation, and I can assure you they will vote favorably if they haven't quite yet. So thank you. I urge your favorable recommendation for Senate Bill 391.
Excellent. Thank you very much, Senator. Questions for the senator before we turn it over to the opposition panel? Okay.
Thank you.
Thank you very much. All right. That'll conclude the hearing for the proponents, and we'll now have testimony from Rebecca Schneider, who's signed up in opposition. All right. Ms. Snyder. All right. I don't see her in the gallery. So with that, that will conclude the hearing for Senate Bill 391. We'll now move on. All right. Senator Geil is on her way. So we'll hold for a second, and we'll pick up with Senate Bill 447 when Senator Geil gets here. All right, we'll get back to the dad jokes. This is Maryland crabs, all right? Why do crabs never volunteer? Because they're shellfish. Oh, all right, got some laughs. There you go. That's some Maryland pride right there. All right. Yeah.
Circumstances, where do you keep their money?
I don't know.
In snowbanks.
I've got 2 daughters, and I've advised them never, ever, ever date a tennis player. Love means nothing to them. Oh. All right, Senator, you've rescued everyone from more dad jokes, okay? So, yeah. No, I'm sure they want to hear from you more than they do from me. So, all right, Senator Gao, welcome. You are here to present Senate Bill 447.
All right. Thank you, Mr. Chair. And I also have on my panel, Sarah Kivett from Anne Arundel County Public Schools. Mr. Chair, Mr. Vice Chair, members. For the record, Senator Don Guile here to present Senate Bill 447. This bill addresses a narrow but important gap in Maryland law by allowing the Department of Human Services to disclose an indicated finding of child abuse or neglect to other organizations that have care and custody of children, not just school systems anywhere in the state. Current law allows DHS to notify public and non-public schools so they can take appropriate action. However, children across Maryland also participate in child care programs, youth sports, and other supervised activities outside of school. Senate Bill 447 ensures that when DHS has made an indicated finding, other organizations responsible for children may also receive that information so they can take appropriate steps to protect the children they serve. This bill was introduced at the request of Anne Arundel County Public Schools after real-world incidents demonstrated that individuals removed from school settings were still able to work with children elsewhere simply because the law did not permit disclosure. While those incidents occurred in Anne Arundel County, the gap in the law exists statewide. You'll hear next from Sarah Kivett, Director of Investigation and Compliance with Anne Arundel County Public Schools, who developed this proposal and will provide additional context. You've also seen favorable written testimony in support of the bill, both from AACPS and the Anne Arundel County Executive's Office. And for these reasons, I respectfully request a favorable report on Senate Bill 447.
Excellent. Thank you, Senator. We'll hear from your panelists, and then we'll open it up for questions.
Chair Smith, Vice President Wallstreicher, and members of the committee. My name is Sarah Kivett, and I'm here on behalf of Anne Arundel County Public Schools, or AACPS, to express support for Senate Bill 447. At AACPS, student safety is our top priority. Under current law, the Department of Human Services can disclose indicated findings of child abuse or neglect, including child sex abuse, to AACPS. This law allows us to remove or limit an employee's access to students and make informed decisions regarding student safety. However, DHS is prohibited from sharing those same findings with other organizations that employ individuals to care for children, such as parks and recs, travel sports teams, camps, and after-school programs. This is a serious omission. AACPS has approximately 17,000 employees, and many AACPS employees also coach or work in these community programs. While AACPS can prevent an unsafe adult from interacting with students at school, these same individuals may still be coaching a youth sports team just because the organization supervising that team is not allowed to be informed. In my 18 years with AACPS, I have seen this happen repeatedly. Individuals are removed from school settings for indicated child sex abuse, yet they continue coaching for parks and recreation or other youth programs simply because those organizations were never given access to the necessary information. I have even been the parent watching my own child interact with a coach who has been removed from AACPS for child sex abuse, but continued coaching my child. Anne Arundel County Parks and Recs has approximately 10,700 active volunteers. If any of these volunteers have been indicated for child abuse, child sex abuse, or neglect, Parks and Recreation has no way to know, and that person may still be working directly with your children. Senate Bill 447 ensures that youth-serving organizations receive the same critical safety information that schools already do. Every child in Maryland deserves protection from adults indicated of harming children, not only during the school day, but in every program and activity. I respectfully request a favorable support of Senate Bill 447. Thank you for your time.
Thank you very much for your testimony. Questions from the committee? Senator Sidnor.
Thank you. Nothing was stated in the testimony about the correctional ombudsman, so I'm wondering what is that change intended to address on page 3, line 16? Page 3.
I'm not sure, Senator. I assume that was made by DLS because it's the correct title of the office. I see what you're referring to on page 3, line 16.
It's been answered. Thank you.
Okay. Thank you.
From leftover, because we moved it 2 years ago And then they may have just found this in the statute and they corrected it, so.
So you should move favor because of that, too. Also for that reason.
All right. All right, seeing no further questions, thank you both very much.
Thank you, Mr. Chair.
Thank you.
Okay, with that, that will conclude the testimony in the hearing for Senate Bill 447. We'll now move on to Senator Reedy. I saw a senator who's here. Oh, here you go. Senator Reedy with Senate Bill 451.
Thank you, Mr. President, Mr. Chair, excuse me. I appreciate being before you again today to talk about an important issue that's potentially affecting constituents of mine and several others as we deal with the possibility of a power line project running from Pennsylvania to Northern Virginia to supply power from one state to another, and largely no power supplied to us. I have a legislation before you dealing with eminent domain. If this power line project was approved, we would be situated in such a way that a corporate entity would be taking land over 70 miles of largely farmland and preserved land for a massive power line. And while we are hoping to perhaps defeat this at the Public Service Commission level, if that were not to happen, or in future cases, because it's likely future power lines will have to come into the state, this bill would address the hardship that our constituents face with these projects. I've had hundreds of constituents that have, in just my district, not to speak of the whole region, that their livelihood is very much tied to their property. And often it's an agricultural property, and many of them have been there for generations. And their generational livelihood is now under threat from powerful corporate interests. Senate Bill 451 would require the plaintiff in an eminent domain proceeding to reimburse for any legal, expert, or other fees or cost of the condemnation proceedings incurred by the defendant in a proceeding. That's the sum and substance of the bill. Last year, I had other legislation trying to figure out if we could adjust the amount of damages for agricultural property. This year, the focus, really this focus is about just making sure people can recover the cost of really adjudicating this issue if it comes to that. And I hope it doesn't, but if it does, and for future projects. So, Mr. President, Mr. Chair, I would ask that for the support of the committee, and I believe I have a witness that's virtual. Yes.
Excellent. Thank you very much, Senator. Mr. Eisenstein, you're up. Welcome.
Thank you very much, Mr. Chair. My name is Harris Eisenstein. I'm a Maryland attorney, and my practice focuses on eminent domain and related litigation, and I strongly support Senate Bill 451. Over the past 15 years, I've represented Maryland citizens and businesses facing the harsh reality of the government or some quasi-governmental body taking their private property by eminent domain, and this power is rooted in the Fifth Amendment to the United States Constitution, which reads, "Nor shall private property be taken for public purpose without just compensation." And while Maryland condemnors must pay just compensation, Maryland law does not presently allow condemnees, my clients, to recover a truly just amount for the life-altering experience of losing their property rights. This bill is an important step in the right direction. Currently, a condemnee is entitled to recover the value of the land and improvements that are taken by eminent domain, plus any diminution in value to whatever property remains post-take. A condemnee cannot recover legal and expert fees incurred defending an eminent domain proceeding except in the rarest of instances. This is true even though condemnors' initial offers often fall well short of just compensation, and these below market offers force my clients to invest resources for attorneys to develop, in collaboration with experts, the true value of the property taken. The result is simple. While the condemnor may increase its compensation package, the net received by my clients is reduced by any money they must pay lawyers and experts. This is unjust. This bill addresses the inequity by permitting every defendant in a condemnation proceeding to recover the market value of their property, plus legal expert and other fees. If enacted, this bill will provide Marylanders facing the difficult circumstance of losing their property rights to eminent domain with a path to recover full compensation for their loss. This is, as the Constitution contemplates, a truly just outcome. I thank you for your consideration of this very important bill and would welcome any questions.
All right, Senator, thank you very much. Questions for the committee? So currently during, this is for the attorney, just during those condemnation proceedings, what, apart from the actual value of the property, are there any other costs associated that the property owner is entitled to for the deprivation of their property?
It's the actual land that's taken, improvements that are taken, and then damage to what's left. So if they take, let's just say hypothetically, they cut off access to the property, right? It's a small strip of land. They have to pay not only for that portion they're acquiring in fee simple and any related construction easements, but whatever damage they've caused to the balance of the property. And if that's a complete wipeout of the property's value, they have to pay that as well. There's no right to recover my costs, expert costs, and related costs if, in fact, if a defendant's going to fight the case. And I truly believe, and other states have enacted legislation just like this, that allowing condemnees, my clients, to recover the full scope of their losses, to include legal and expert, would be wildly just, wildly appropriate, and is something this body should push forward.
Thank you, Mr. Chairman. And this question is also for counsel, if you don't mind, Senator.
I definitely don't mind.
Okay. I am generally, for the American rule of not recovering legal fees, but in condemnation, I feel differently because you want to make sure, in my mind, the government should make someone whole. And if you can't recover the entirety of the process, then it just keeps diminishing what you do recover. So you mentioned that other states have enacted similar legislation. Do you have a sense, so two questions. Do you have a sense of how many states generally have done this? And in those states, have they put any cap or restrictions, or is it just as open-ended as the language we have? Do you have any information about either of those questions?
That's a fantastic question. I reached out to a colleague of mine in Michigan. I know that Michigan has legislation similar to what's being proposed. I think the only caveat would be perhaps to insert the word reasonable legal expert and other fees. But I think there's always a reasonableness standard as it relates to recovering fees in litigation. I agree with you. I think that in this particular circumstance where the defendants did not invite the litigation, they didn't pick a fight, they got sued because they happen to own property along some public project, and they're affected perhaps by a power line, but perhaps by another project. And I happen to represent hundreds of landowners who are opposing this particular power line and other transmission lines proposed in Maryland. If they're going to lose property rights, they shouldn't have to net out from their recovery what they have to pay a competent lawyer or a competent expert to help build their case.
Yeah. And, just to be fair here, if pretend I'm a judge for a minute, what would be the argument, or have you seen cases that push back on the recovery of attorney's fees in general in this context? Because as I said, I very much support the American rule of not recovering attorney's fees and the expenses, et cetera, especially in other areas of the law. But in this is so extraordinary in that the government is going to take your property. So just in general, are you aware of what would be the pushback, if at all, other than, of course, they don't want to pay, but for the legal fees, the reasonable legal fees, but have you heard any valid concerns that we ought to be aware of as we move forward?
It's a very interesting question. If I was working for the condemnor, perhaps one consideration I would raise is that we're making fair offers. We're making just offers, and they just think they're entitled to more. But our offers are fair, and that's what a jury is ultimately going to decide. In my experience doing this, it is rare that the initial offer made by the condemnor is actually the final offer and the true value. And so if they're going to force, them being the condemnor, is going to force my clients to build their case, a case that they don't want in the first place. They don't want to lose their property rights. Right. Then they ought to pay for that exercise. Whatever they might raise, respectfully, I think would not be a very persuasive argument.
Well, I'll take a look at it because I could see, some argument in that regard, but I still am deeply troubled by a landowner having their property taken by the government for a purpose that they will not necessarily benefit from, and then not being made whole in these circumstances. All right, thank you, Mr. Chairman.
Thank you, Madam.
I'm very sympathetic to that scenario, but I'll give you a less sympathetic, like, property. So in my district, there's an abandoned Sears department building, and it's been abandoned for since Sears shut down. So it's like, I don't know, coming up on 10 years now. And now the property is owned by some private equity firm, not from Maryland, not from, my district. And they've just kept it there. It's blighted. And I've been trying to move on this thing. So I do have a bill for eminent domain to go ahead and get their attention. So that's a less sympathetic property owner, but I do understand this, because I get that. I mean, if you're, if someone's coming through your home or your small business or something, I get it.
Yeah, there'll be ways perhaps to type the language.
Well,
Yeah, I think, yeah.
I'm very open to discussing now. I also will try to provide the committee with other states that have done something the same or similar, or are proposing it. I just think this is a unique.
Yeah.
I understand your point too, Mr. Chairman, of course.
Yeah.
yeah, I mean, you're gonna, sorry to interrupt, you're obviously gonna have some bad apples, if you will, in the mix, and people maybe that would try to take advantage of legislation that has all the right intentions. I think by and large, and I've represented, I would say in somewhere on the order of 100 people or more dealing with eminent domain circumstances, none of them are looking for, a gift or sort of a free ride. All of them are looking for what is fair, and all of them are frustrated. Once they understand this is the process, this is the government's right, then they say, all right, well, how do I get fairly compensated? And oftentimes, a consideration is, do I even go with counsel who can benefit me tremendously because I have to cover their expense? But if they didn't invite the litigation, they don't want this. It seems to be part and parcel with just compensation. And that's why, again, I mean, this really is just expanding what just compensation means under Maryland law. And it makes real good sense.
And Mr. Chairman, it's just important to me, and I know it's important to those of us that represent these areas, just to be sure that people get the opportunity to be represented properly, because this is like an unusual circumstance. So anyway, I mean, we're happy to talk more about the language if we need to make a few tweaks.
Hey, well, thank you both very much. Thanks. With that, that'll conclude the hearing for Senate Bill 451, unless anyone has any questions. All right, excellent. Thank you very much, Senator.
I have
All right,
one
now
more.
you're back
You need to come
for
back.
Senate Bill 355.
Wonderful, wonderful. Thank you, Mr. Chairman, and members of the Judicial Proceedings Committee. We're going from eminent domain to marriage. So we've got, we're spanning the globe on legal topics today. But this is actually an issue that's been brought to me by the Clerks of Court Association. And it's it's dealing with marriage license applications. As amended, I'll just talk about the bill and I'll explain why. This legislation, as amended, that the amendment should be in your packet. The SB 355 would require both parties in a marriage to appear before the court clerk to apply for a marriage license. This bill, as I mentioned, was brought to me by the Maryland Clerks of Court Association, Circuit Court Clerks Association. Let's get the name right. Under current law, only one of the parties to be married. When I got married, I went and got a marriage license at the Carroll County Clerk's office. It's law right now that only one of the parties must appear before a court clerk and give under oath specified information that must be placed on the application form by the clerk. The amendment will allow for waivers in this situation, waivers from both parties appearing for deployed military members, incarcerated individuals, hospitalized individuals, and other good cause exemptions. And then there would be an affidavit requirement for that. And the reason for this is very simple. There has been a rash of marriage coercion issues in the state over time. And so the concern the clerks have had is, obviously they're the front line, and they just want to be sure that we are protecting people, often vulnerable young women, although certainly I'm sure it's not always women, but vulnerable young women, and making sure that indeed a marriage license is being obtained under the correct pretenses. I frankly, as somebody who really believes strongly that marriage is something that should be very sacred, I believe it's good to we've broken down a lot of barriers about divorce. I don't think it's a terrible hurdle to have a little bit more of a hurdle to make sure you get your license, to be quite honest with you. That's my personal opinion, and it's not speaking for the Clerks Association. But really, the reason we put the bill in was because of the concerns that they've raised about a number of situations where someone has later found out to have been, somebody's fraudulently obtaining a marriage certificate when they're not even, don't even know the person, or in some cases, it's someone who's been sort of coerced into doing it. So this would help with, really, I think it's more the fraud issue that they're concerned about, but also the coercion element. So, Mr. President, that's the bill we wanted to have. It was brought to us by the Bar Association, had the amendment to make sure there's obviously an affidavit process for good cause exemptions. I think I have some folks here to testify, and perhaps I should have brought them up to begin with, and I apologize, but if they could join me at the table. Please come on up. I'm sorry. Right behind me.
I've got a dad joke about marriage. Why do melons have weddings? Because they can't elope.
That's a good dad joke. That's a good dad joke.
If you could come up to the podium, please. If you could.
Want to go first? You go ahead. Yeah. Sorry, I should have brought you guys up.
Oh, you're fine. Thank you, Chair Smith, Vice Chair Waldstreicher, and members of the committee for this opportunity to testify to support Senate Bill 355. For the record, my name is Heather S. DeWeese. I'm Clerk of the Circuit Court for Carroll County. I'm also testifying on behalf of the Maryland Circuit Court Clerks Association. I support Senate Bill 355 because fraudulent marriages can promote identity theft, property theft, and federal and state benefit theft. In my own county, there was recently a case where a woman obtained a marriage license and used a fraudulent officiant's signature to assert the marriage had taken place. After a marriage certificate had been issued, my office found out that the other party was deceased. My office had no way of knowing because only one party must apply for a marriage license per Maryland statute. The woman is now currently under police investigation. There have also been allegations of ongoing marriage fraud operation in Maryland County involving foreign parties marrying U.S. citizens, which currently is being investigated. This situation involves multiple marriage licenses where only the foreign party is ever seen. Neighboring states such as West Virginia, New Jersey, Delaware, Pennsylvania, and Virginia require that both parties are present and show a government issue ID. However, a clerk in Maryland may never see the other party. And because of this, we are concerned about coercion, that underage, they could possibly be underage, or even if they're aware the marriage had even taken place. So for example, if I obtained Senator Reedy's driver's license, I could apply for and receive a marriage license, forge an officiant's signature, and then we would be married, and he wouldn't even know. So this bill adds a requirement that both parties to a marriage appear before the clerk, which will bring Maryland up to the same speed as most of the counties in the East, and most of the states in the East Coast. It will help reduce fraudulent marriage licenses and thwart potential human trafficking. I ask for a favorable report on SB 355 with amendments that have already been submitted, and I would like to thank Senator Reedy for sponsoring this bill, and thank you for the opportunity to comment, and I'm available for any questions.
Thank you, Chairman Smith, members of the committee. For the record, my name is Scott Poyer. I'm the Clerk of the Circuit Court for Anne Arundel County, and I am also here representing the 24 elected clerks of the Circuit Court in the state of Maryland. As my colleague, Clerk DeWeese, mentioned, the clerks are supporting SB 355 because we are responsible for issuing marriage licenses in the state of Maryland, and we need additional tools to fight marriage fraud. One issue that was discussed among the clerks, which Senator Reedy mentioned, was whether the proposed requirement that both parties appear in the clerk's office sets too high a bar for marriage applicants. To address this concern, we worked with the sponsors on this amendment and other organizations so that there are waivers for deployed military, incarcerated individuals, hospitalized individuals, and other exemptions for good cause. We believe this will allow situations where one of the marriage license applicants who cannot legitimately appear in the clerk's office yet still be a significant improvement over the current requirement that only one applicant ever needs to be seen. The clerks ask for a favorable report on SB 355, and we'd like to thank, again, Senator Reedy for sponsoring this bill, and also thank you for the opportunity to comment. I'm available for any questions you may have.
Excellent. Thank you all very much. Senator James.
Thank you all for coming, and I had no idea about this issue, but just so I understand, right now the clerk's role in when an applicant comes in, do you generally ask the applicant some questions before you accept their request, and how do they establish the partner? I have no idea I know my husband did this, but I don't know what he did or how he did. So I don't know if he showed up with my driver's license or my birth. I don't know what he did. So what happens now? Because I'm trying to figure out how you ferret out some of your concerns, which I applaud you for trying to work on this.
Yes, thank you for the question, Senator. Exactly. Right now in the current statute, only one party needs to show up.
Right, I get that.
They'll bring an ID. We have them bring an ID. So, but as
For both
parties.
Okay.
But as Clerk Louise says, these days you can get an ID on the internet. You can get a fake ID, and if they bring that in,
okay.
right. So, so if we only see one party, we can only question one party. We don't get to question the other party, and that's.
And do you sometimes question the parties? What's your latitude there?
I will ask. Right now, we have advice from AG that we have a very, very stringent requirements on when we can refuse service. We can really only refuse service if we believe that one of the parties is being coerced. But if we don't see the other party, we can't tell if they're being coerced. So right now, very limited discretion that we have. However, this bill would give us more discretion, one more tool in the toolbox to prevent marriage fraud.
And just so I understand, so you do have these stringent requirements, and you have to be careful not to deny except in cases of coercion. I can't imagine how you're going to ever ferret out coercion if there's only one person there. But I'm just trying to figure out, I think some of this coercion would be, I would have to say women, I'm going to say that at the moment, and that I think they'd be terribly afraid to speak up in that setting. But maybe your experiences with the other states, even though it's an imperfect solution, it does gain you some ability in this arena to try to ferret out these problems. Is that correct?
It absolutely would. And in my case, it's a best practice that you can separate. If both of them come in, you can question both of them. And what I've done is, and is a best practice in many of the clerk's offices, I think all the clerk's offices, we can separate them and talk to each one individually and then try and ferret out. It's still not, if they're under coercion, it may not be 100%, but it's one more thing that we can do.
Good to know that you can separate people if you are.
One more, yes.
Thank you. All right, thank you.
I'm sorry.
Oh, no, you're fine. I also just wanted to reiterate that the situation that involved in my county, the particular family of the deceased, they had to hire, an attorney. They had to take time off from work. They've had multiple cases involving the Register of Wills because a fraudulent will was also made. A fraudulent obituary was also made. This person took the driver's license off of the dead individual, and fortunately, or unfortunately for the family, the particular deceased spouse was going to inherit a tremendous amount of money. So, I look at it from also the perspective of just any fraud victim, and the amount of money you have to spend to thwart that is incredible. And this is not going to stop happening because, unfortunately, Maryland is only one of the states on the whole East Coast. There's only a couple that allow one party. And so they all come to Maryland to get married. That's why we have a lot of foreign applicants, meaning coming in, and they only have one applicant, and the same officiant was actually signing these marriages in a certain county, and it is now under federal investigation. So I just want to make that a little more clear to tell you why I was a huge proponent of this bill and contacted Senator Reedy, and Mr. Poyer and I have been very aggressive about it. Thank you.
Well, that's a who's on first.
It was me. Thank you. All right. And thank you for the testimony. As I'm listening, I'm just curious, outside of this one anecdote, how much of a problem this is in the state. I mean, is this happening a lot, or is it just one bad case, or just a few bad cases? Because it sounds to me as if what transpired was criminal acts, which we already have penalties for. And I'll be perfectly honest with you. I can remember I married here in Anne Arundel County. I'm from Baltimore County, so I remember having to drive down here to get my license. And I wonder what burden it would have been if me and my wife, current wife, would have had to both take off of work to do something when one of us could have done it. So now you're because of these bad actors on this side, which may or may not be a lot, you're asking for Marylanders that want to get married, you're putting a burden on them.
Well, if I went to the airport with my husband, we'd both have to show our IDs.
So back to the first question,
right?
How often is this happening?
And I will go ahead and say this, that it is incredibly important for you to understand that this particular case happened in one county, which is a neighboring county to another state that has two parties appearing. There were, I believe, how many victims are they up to now?
No, I understand all of that. I'm asking.
So, but it's
I understand
common,
all of that.
right? But
this
is not an uncommon thing, is what I'm saying.
What I'm
they
asking
were
is
caught.
how often. I got that. I heard y'all testimony. I was listening.
Yeah.
Now I'm asking you to answer my question. How often is this stuff happening? Is this one bad case? Is it a couple bad cases? I mean, you all are
Well, we know what we only know what we
counties.
know from
How
our
often has it
counties,
happened?
right? So I know that we have had multiple instances.
How many?
Well, we know I'm not going to give the counties because they're under police investigation, but I can name
That's
three,
what I asked. How
four
many?
counties.
I don't need
right
how
now.
many.
So I mean, I don't know for those particular counties. Mr. Porter, do you have any? I mean, you might have a little more information than that. Do you have that information? Okay, go ahead. Yeah, go ahead.
Yes, Senator. So it isn't every wedding. I mean, most people that come in to get married in our courthouses are doing so on the up and up. And it's and I would also like to throw in the additional information that, in my experience, most of the couples come in together. So already most of the couples that are coming in together. But as you rightly point out, it is more of an administrative burden, a logistical burden right now if both parties are always required to come in. So how often does it happen? Not very often, but I've been a clerk for about 8 years, and I've heard stories and there's been instances the entire time that I've been here. So every year in the state of Maryland, we're performing between 35,000 and 50,000 weddings in the state of Maryland. A small percentage of those might be fraudulent. We don't have exact numbers for you. I wish I did.
No, that's fine, and that's what I was trying to figure it out.
It's a relatively small number, but for those people it does affect. It really can affect their lives tremendously.
Because I also remember a few years ago, I remember us making some modifications because I believe, if I remember correctly, we wanted to make Maryland the Las Vegas of the East Coast because we were trying to bring in people and bring in this industry, this cottage industry around marriage. And this seems to be kind of walking something back. So
I was involved in the bill. If you're thinking about the same one a couple of years ago, we raised the age of Maryland because historically, yes, Maryland was one of the easiest, if not the easiest place on the East Coast of the United States to get married. And there was a cottage industry in the state of Maryland exactly doing that years ago. Since then, because of the human trafficking and the fraud issues that have been coming up, we've actually been walking that back. And that was one of the reasons why we raised the age, well, not we, you, the legislature raised the age of Maryland in Maryland a couple of years ago to offset that. But historically, Maryland did have a reputation like that.
And one last question. Are you, and I'm asking because I don't know, but I'm assuming some of the activities that were talked about in the testimony, these are criminal activities. So whomever is involved in this type of fraudulent activity, if caught, they're going to be prosecuted.
If they're caught.
If caught.
The issue is they can get married in our state, and then if they leave the state.
There's nothing we're really going to do.
That's correct, sir.
Gotcha.
Yes, sir.
I appreciate it. Thank you.
Thank you very much, Senator.
Thank you, Mr. Chair. Thank you, Mr. Chair. I had a question for the clerk of the court. It was in reference to the case you made
Yes,
me
sir.
think about a couple of things when you talked about the fraud in terms of these a fraudulent license. How easy or how often have you seen a fraudulent license get made?
The thing is it's not really our job to determine if a license is fraudulent unless we have it's painfully obvious. And because we don't always know what a license from another state might look like, that is another issue. So it can be a fraudulent license, but in the case in my county, they just, for the example I gave, if I just plucked Senator Reedy's license off of him, pulled his wallet out and grabbed it, like this particular this woman did, I can then use it for a variety of identity thefts, including fraudulent marriage.
Is there a way for us to check nationally or within our own state if a license has actually been filed properly at all?
It depends. It does depend on the state, and we have Real ID and all of that, right? We look for the commonalities that should be in a license. But in reality, some of this stuff is not necessarily a fake license like you would think for, for example, getting into a bar, right? The issue
Just a sheet of paper, right? Marriage license, a sheet of paper.
Right. The issue that we're dealing with is typically that license can be taken. It can be an authentic license, and it can be used fraudulently. Just like a credit card. If I took Senator Reed's credit card and went to Macy's, right? It would be the same kind of situation.
I need to leave the room.
I don't know where your wallet is, Justin, I promise.
No, so only reason I'm asking this, it just piqued my interest while I was sitting here listening to you in terms of the person that took the license off of somebody while they were dead.
And it was her boyfriend, by the way.
Well, if they were able to, do something like that, if they wanted to create a fake license and backdate it and said they were actually married a couple of months prior to this so they can get all of the windfall of money that you were talking about, how easy is that, and how would you check the actual license against her? Just say, hey, you got this license. I've been married to this guy or this gal for a year or 6 months. What do we do? How do you check to say, oh, this is actually a real license? This is a fake license.
Are you saying they're already married?
Marriage license.
The marriage license.
The marriage license is fake, and then we're getting it certified. They're coming in with the officiant, signing it. It's really up to the officiant, too, to check that. But in this particular instance, it was a fraudulent officiant, a fake address in Baltimore County, and then a fake officiant. And because Maryland has no officiant registry, there's no way to check to see if the officiant's even fraudulent. We just called over to Baltimore County Police and had them, my son's a Baltimore County police officer,
like
so we had them check and see if that
larger-
address existed.
This just sounds like a larger fix to a problem that needs to take place. There needs to be some things put in place to actually know if something is real or fake.
Yeah, go ahead.
I appreciate that question, and I think if I could just say something to the two folks of the question, both senators. Number one, those are both questions I anticipated. I knew my friend from Baltimore County was going to say, is this really a big problem? Give me a number. And I think what we're pointing out is we're on the cusp of it becoming a bigger problem based on what we see culturally with fraud, with everybody's information being available online. I agree with you, Senator Charles. I think, it could potentially be a bigger problem. And I don't know if we want to start doing registries of officiants or not. I mean, that's a whole other conversation, discussion. But I think, again, one case in a different county that's been referenced is one case, but it's potentially 100 fraudulent marriages. So, but it's also hard. It's like, when you think about trying to stop fraud, it's like, well, how much fraud's happened? Well, we don't exactly know. So this is trying to put into safeguards. Also, again, as we mentioned, as my friends here mentioned, we're not doing anything outside the mainstream of what a lot of other states in our region are doing. Most states are requiring two people to appear or have some kind of affidavit. And so I think we're trying to be sure that we, keep the barn door closed, so to speak, try to close the barn door before too many horses get out, which may be a terrible, terrible analogy for marriage, but for a marriage license thing. But just to respond, and we'll see what other data we have to provide. But anyway, thank you, Mr. Chairman.
Excellent. Thank you all very much. Any further questions from the committee? All right. Thank you. Thank you both very much. All right. We have, so that was Brendan Madden, and then I think that's it.
Good afternoon. I'm Brendan Madden from the Maryland State Bar Association Family Law Section Council. As set forth in our written testimony that was submitted, we agree with the bill. We agree with the public policy interest that it's trying to achieve, and the concern that we did raise about the potential hardship for couples where one party is unavailable to appear in person has been addressed by the amendments that add this affidavit exception. So we would urge a favorable report on SB 355.
Excellent. Thank you very much. Questions from the committee? All right. Thank you. All right. With that, that'll conclude the hearing for Senate Bill 355. We'll now move on to Senator Sidnor with Senate Bill 426.
Before I begin, I just want to check Amanda Stone and Ray Gallagher. Are you in? Come on up, please. Thank you. Appreciate it. All right. Good afternoon. For the record, Senator Charles Sidnor here for Senate Bill 426. Right now, anyone can walk into a courthouse and access someone else's divorce records. Financial disclosures and sensitive information have been disclosed. A stalker can learn of their victims' phone numbers, email addresses, home addresses, and identifying information. The only exception is that Social Security numbers must be redacted, but with the sheer number of documents filed in a variety of cases, Social Security numbers may slip through the cracks and have ended up in public records. This lack of privacy protections poses a significant financial, emotional, and personal risk to the public. Divorce creates uniquely comprehensive records of at least two people's lives, their finances, their routines, their relationships with families and friends. The public expectation of transparency should not extend to all vulnerable details available under the current law. When Delegate Simpson approached me to cross-file this legislation, she told me of a shocking story of a constituent who fell victim to this legal vulnerability. With one Public Information Act request granted, her privacy was gone. An upset individual received documents of this constituent's divorce with nothing redacted. This individual then uploaded sensitive information, including Social Security numbers of the family and the phone numbers of the constituent and several other identifiers that led to this constituent being subjected to harassment and death threats by her ex-partner and members of the public. As a remedy, Senate Bill 426 does three things. Number one, the bill requires strict confidentiality of divorce records, of certain divorce records. Divorce applications, financial records to a divorce application, divorce settlement records, and custody orders would be kept private under this statute. Now, this statute, it does exclude final divorce decrees from that privacy, but it restricts access to sensitive information to parties of the divorce, attorneys that are representing the parties to the divorce, and anyone authorized by a court order. These common sense practices will protect the privacy and safety of divorcees and their children during a legally and emotionally vulnerable time. It will help prevent identity theft and shield sensitive information, business and personal. It will also protect the locations of victims of domestic violence. For these reasons, I ask for a favorable on Senate Bill 426, and will turn the testimony over to my panelists.
Good afternoon. My name is Ray Gallagher, and I'm a current member of the Board of Education in Frederick County, which I'm not here to testify on behalf of the Board of Ed, but it's relevant to the story that I'm here to share today. So last year, I served as the president of our board during a time when a well-known, relatively well-known YouTuber began attending our meetings, and due to his use of repeated vulgar and threatening language, I had to have him removed by our sheriff's deputy on a number of occasions. He posted a lot of content on his social media that was targeting me, which led to me receiving a number of nasty and vulgar messages, including death threats that were investigated by our sheriff's office in Frederick County. During this time, I also happened to be undergoing a divorce. He submitted a Public Information Act request and received a full copy of my divorce records. He subsequently posted all of this information online and encouraged his followers to contact my ex-husband, which they did. He sent a full scanned copy of these documents to all of the elected county officials in Frederick and Washington County, as well as the boards of education. And then he posted details of the agreement and went ahead and shared the copies with anybody who requested. The worst part about this was that I have 2 minor children, and all of their information was included along with our contact information, address, and all of this information. Nothing was redacted. So now my minor children's information is out there being shared with individuals as well. The process of filing for divorce is incredibly painful and deeply personal, and while my story might be a little bit more extreme than most, I believe there's very little benefit for this information to be readily available to the public and should be restricted only to interested parties. Under no circumstances should minor children's information be included. I ask the committee for a favorable report on Senate Bill 426 for the protection of privacy rights for individuals. Thank you for your time.
Good afternoon. My name is Amanda Stone-Janez, and I'm a resident of Middletown in Frederick County. I'm also a close friend of Ms. Gallagher, who spoke before me, and also an official in Frederick County. Ms. Gallagher is a dedicated public servant, yet the absence of adequate privacy protection in Maryland's divorce records allowed her and her family's highly personal and confidential information to be exposed and exploited. As a result, Ms. Gallagher and others involved in her divorce received vulgar messages, including death threats and of violence, direct threats of violence and death. Her family became targets solely because their private information was made publicly accessible. My own personal data was part of this exposure as well. Divorce is an already intensely sensitive and emotional process. The public release of private details, particularly information involving minor children, reveals a serious gap in our public information laws. Allowing individuals who are not party to a divorce to access such records opens the door for misuse by bad actors with harmful intentions. There is no legitimate reason for members of the public to have access to deeply personal information such as financial records or custody agreements. At least 9 other states have enacted laws to protect the privacy of individuals involved in divorce proceedings. I respectfully urge Maryland to follow their lead. There is no public benefit to making detailed divorce records widely accessible, and doing so puts families at unnecessary risk. I ask this committee to issue a favorable report on Senate Bill 426 and take an important step toward protecting the privacy and safety of Marylanders. Thank you for your time and consideration.
Excellent. Thank you very much, Senator. I think I'm going to have questions for Mr. Madden, who's coming up for the MSBA, but Senator West, go ahead.
Thank you, Mr. Chair. And it may, I'm sure Mr. Madden is going to address this. I'm looking at Rule 20-201.1 of the Maryland Rules entitled Restricted Information. This is in the section of the rules that requires all pleadings these days to be filed electronically. The old days of paper filings are over. So this says each submission filed pursuant to the rule that requires electronic filing that contains restricted information, and it goes in great detail about what is restricted information and how you have to identify it and expurgate it, et cetera. Are you familiar with this rule, and why wouldn't this rule solve the problem that you're concerned about that is illustrated by this particular situation?
Yeah, I am not. However, we have had some conversations with the courts about rules and the like. From reading the Maryland State Bar Association's unfavorable testimony, it struck me as I think that, and probably rightfully so, if you are a litigant with an attorney, I guess the duty falls on that attorney to make certain that certain things are identified so that this information is redacted. I can't speak for pro se litigants, nor can I speak to what happened in the case that we just heard about. I don't know why the rules didn't work. I don't.
I note that in the rule, subsection A2 says, if the filer fails to file a completed notice of restricted information as required, the clerk shall reject the submission without prejudice to refile the submission accompanied by the notice. So the rule seems to contemplate that someone who's rather unsophisticated would try to file something electronically, which did not comply with the rule.
All right.
And so I guess the concern would be that the clerk would not follow the rule?
And something happened, or something that should not have happened in the case that you just heard. I know in reading the press's testimony in opposition, they asked the question whether access serves a legitimate public purpose. And I would point that question to the committee. Does putting out this type of information, so with Social Security numbers and the like, that could cause more harm than good, is it necessary for the public to have that type of information? I think our argument is it doesn't.
I think the rule contemplates that Social Security numbers fall within the scope of restricted information. That's why the rule was adopted in the first place.
And I would agree. But again, you have two people who are sitting here before you. The rules didn't work. Something happened. I don't know what that something is, but I do know that if the law prohibits the allowance for the public to see this stuff, it won't happen.
Thank you for your interest in my question.
I appreciate your questions.
Thank you, Mr. Chairman, and thank you to the bill sponsor. Have you had a chance to check out the written testimony from the Maryland, Delaware, DC Press Association?
Yes, I was looking at it. Yes, ma'am.
Looking at the portion of their testimony, I'd like to know your perspective on it. They lay out kind of the context of these cases, and they say judges issue binding orders affecting property, finances, parental rights, and personal liberty. And then they go on to say, public access to filings and rulings allows Marylanders to see how the law is applied, promotes consistency across cases, and reinforces confidence that outcomes are not arbitrary, biased, or improper. A categorical exemption for divorce records would remove a significant portion of judicial decision-making from public oversight. What's your perspective on public oversight and the access to the records being a role or a feature in public oversight?
You know, I think they make an extremely good argument. However, again, I think you can have some oversight without having some of the materials and the information that's included in some of these filings made available to the general public. If I had not heard for myself about this particular case, I probably would have taken the same position that our good friend from Baltimore County had taken. The rules are there. What's the problem? But unfortunately, we have 2 humans here saying the rules didn't work. So this is this is one of our responses to trying to deal with rules that did not work.
Thank you, Senator. Thank you.
Thank you.
Thank you, Mr. Chair. Thank you for the bill, Senator. Look, I don't really have so much as a question as a comment. I just want to say, look, I don't think you should have to file notice for an appropriate, insulary guardrails to be in place to protect people who are going through very difficult times. And Ms. Gallagher, I do want to publicly condemn those actions and behavior of that. It's not okay. And if this helps by moving the needle here to kind of protect those people from these attacks and protect your kids, then I appreciate you bringing the bill. Isn't that so?
Isn't that so? Yes, sir. Thank you.
Yeah, I want to thank you too, Senator. You and I are on the same page on this bill. I actually have a hard time understanding ever why it's in the public interest to find out about your financial circumstances. They certainly weren't entitled before you got married. Right. They're certainly not entitled if you decide to, I don't know, have a common law marriage, but never to actually put it down on paper. Right. And the same with children. So as much as I usually, listen very intently to what the Bar Association says or the court has to say, to me, it should be the opposite, that these records should not be available to the public and let there be exceptions for public interest in these. Because, or you can obviously collect the data and anonymously describe without any identifying information, if you're terribly interested in what happens in divorce cases, income range or something about children. So I applaud you for bringing this, and I'm very sorry also, but I also, for what happened to you all, but I don't really see a compelling state interest for making these public in the first place and then having to ask for it to be sealed. Here's my question. What's the standard that is required to meet that sealing? And I imagine it isn't something as flippant and it's none of your damn business what's going on in my life, but that to me is enough to some extent. I think there are other ways to get this information in an anonymous way if that's really compelling, and otherwise I think this information should never be out there in the public.
I would like to respond to that, but then...
in all substance, sure, anything you want to say.
I agree, but I also appreciate Senator Henson pointing to the Maryland, D.C. Press Association, because I think what they said, and generally I'm there as well. Anything happening within government, the public should have a right to know. But when you look at the role of government here, it's in making the decision. They are not government. Individuals are not government because they've decided, because of processes that we've created, that they have to use government in order to dissolve a relationship. Doesn't mean that we should all then get to pull up the veil and see what was going on in this family and in the family's dynamics. Right. It's none of our business. I mean, unless we just, and again, to point to, and it's on the second page under the heading Importance to Journalists and Public Oversight, does this serve a legitimate public purpose? And I don't think this information does.
I'm with you, and I'm very sensitive to this, and I think there's a way to craft the bill so that journalists under certain circumstances, let's put the onus back on the journalists, let's put it back on the public for when information come out, and I'm all for, making it, anonymizing it or anonymously creating it so that no one needs to know the parties involved but can generally understand what is going on in divorce cases. But anyway, thank you very much.
And senators, if this bill isn't the answer that you all think, then fine, we'll continue working, we'll continue talking with the courts. But the question is, when damage is done to our citizens, our constituents, what's the remedy? Is there, has there been a remedy? Probably not.
No, irreparable harm.
It's done, it's out there. And that harm is, when you're talking about Social Security numbers, right now, many of us have heard what has been going on with the federal government and DOJ. and allow the access into private information that is now on some third-party servers. We have no idea, and we won't for some time, what's going to happen on within the black web with Social Security numbers. I mean, this is serious. So, you had.
Just in response to the sealing, I did end up going back to court and petitioning for my particular case to be sealed, and that required an additional court hearing for me to go in and present evidence to the judge of the harm being done. And ultimately, my case was sealed, but that's additional steps, and I don't think that they would have done it without the proof of what had already happened, which I think is one of the...
So you were already harmed, as I understand.
Correct. It was already out there, and there was no bringing it back. But it is now sealed for any future, my particular case. But to go through that process, it's additional steps, and had the harm not already happened, I'm not sure that they would have sealed the case.
And there's a concept in the law, I'm a lawyer, called irreparable harm, which means that once that harm, there's no way to make the person whole again. And that's why I think this is the kind of harm that you all can experience and others can experience. So it's not a lightweight matter at all to try to figure out if we can come up with a better balance than we have right now. All right, thank you.
Thank you.
Thank you, Mr. Chair. How was Maryland case search impacted by this?
That I do not know the answer.
So if right now, if you want to go find out about somebody's divorce, you can go to Maryland case search and pull up all types of information. Maybe not Social Security numbers,
right?
But would you
I would
be
imagine
open
Social Security numbers in these particular files. That's not going to be up there. You go to case search, you just kind of get a good summary of the docket.
Right, but I think you made a very interesting point earlier that it's nobody's business about somebody's divorce and what people are going through interpersonally in their own households. Yet this information is on Maryland case search.
Right.
And so would you be open to adding, removing that information from Maryland case search as well?
If that's what the committee wants to do. I didn't go that far. I didn't go that far, but if that's where the committee wants to take this, it's up to us all.
I think it's a fine line in between, and I think this calls out a lot of open issues that exist, and I've heard other issues about case search before too. So,
got you. Appreciate it.
Thank you, sir.
Thank you.
Thank you very much, Senator. All right. Further questions from the committee? Thank you, Senator Sidnor.
Thank you.
Thank you both to the panelists. Thank you. Also echoing Senator Folden's sentiment, so thank you for sharing your story on that. Now we'll hear from Brendan Madden and Rebecca Snyder.
Brendan Madden, again, on behalf of the MSBA Family Law Section. So the MSBA certainly understands and appreciates the motive behind this bill, but we believe that it is an overcorrection for what is an isolated instance. As I believe was sort of evident, became clear through the questioning of the proponents, much of the information that is the biggest concern in this disclosure, that should have already been restricted by the courts, and I believe it should have been restricted even under the Public Information Act. Social Security numbers, financial information. That was leaked. I would call it a leak, even though I guess it was produced by the court. It was a mistake, and it's a breach of a system though that's already in place. Modifying the Public Information Act, I don't think really gets to the problem that occurred here, which is that the court made an error and the court disclosed records that shouldn't have been provided. The rules for access to court records, I guess, flow somewhat through the PIA, but actually are directly governed by the Maryland rules, Title 16 of the Maryland rules. So this bill doesn't really even get to the direct issue that arose in this situation, which is that the court applying Title 16 of the Maryland rules, and Title 20 is for electronic access, and they dovetail, but that there was an error at that level, not at the level of the Public Information Act. So if there's going to be a change and a correction to prevent this in the future, it should really be looking at what the rules applying to the court are, not the broad, the broad system in place for access to government records in general. So we would urge an unfavorable report on this bill.
Thank you, Mr. Chair. Thank you for your testimony. Can you just explain to me, I might be a little simple at times, but can you explain to me the public good in releasing someone's personal records, which their only reason for having any contact with the government is because they have to dissolve their relationship?
I think that could be said for most records that, most personal records outside of divorce that are held by a government agency. No one would really provide anything to the government unless they had to. Divorce certainly is a particular, and a very unusually sensitive area. And there are protections in place. There are restrictions, probably more restrictions than for any other area of the law in regards to accessing these records. Financial information is supposed to be restricted, even if you can get access to a broader document. If there's a filing that lists what someone's bank account, balance is, that should be redacted out.
So what would you recommend? What is the current law as far as recourse for an aggrieved party against when the government, who their only interaction is because they're dissolving a personal relationship?
Well, I have no idea I don't know if there's any remedy under the law for a breach by the judiciary, in this case, by the clerk of whatever court, in improperly disclosing information that by rule and by law should not have been disclosed. I don't know if there is a personal remedy available to the people who are harmed by that.
So if there's not one, you'd come in support of such a...
I'd have to see what it said, but, that's not the bill that is before us today.
No. But the bill before us talks about, personal matters being a matter of public record just because the government has their hand involved in the dissolution of a marriage. So we'll just disagree. We'll agree to disagree on what is good and proper for public consumption.
Well, I'm not, the MSBA's position is not that there should be free, unfettered, total access to divorce custody records. It's that there is an interest, and it's balanced against, there's a public interest that's balanced against the privacy interest. And here maybe the public interest is less because of the very sensitive nature of these records. But it is still something that should be discussed on an individualized basis. And that's what I have my complaints about how the shielding process works in the courts, but that is what the current rules provide for. If you believe there is a reason to seal or shield a record or a file, you can petition the court to do that. There is a hearing, and you present to the court the reasons you believe that the records should be withheld from public disclosure.
Yeah, so that's, again, where we'll disagree, because there is no good public reason. There is no good reason that for the public good for someone's personal matter. That's just the fact of it. Like, you consider and try to explain a little bit how you think it should be open for public review. What I'm saying is that's exactly the point. It's nobody else's business. The only reason the government's in it is because they issue a certificate for marriage that we now have to get voided. So I don't agree with you at all on that, and I think that it's and it does lead us to the part, when in your statement there about that there is harm because they didn't follow the policies or the guidance that's currently in place, is what I've heard. But if they don't, shouldn't there be something for the aggrieved to seek some sort of remedy for the harm that was done? And right now there is none. So thank you.
Thank you, Mr. Chair. I want to follow on Senator Fulton's line of questioning. So you represent the family law section of the State Bar Association, which has many, many members, correct?
Correct.
Hundreds, as I recall, lots of members. Would you be able to go back and talk in the next week to 10 days and consult with key members of the family law section and give us a suggestion as to what we can do to enable someone who is aggrieved because a court clerk has failed to follow the rule? I'm just thinking totally outside the box, maybe the right to have an immediate appeal to the chief judge of the court, to ask the judge to direct the clerk to adhere to the rule and to do what the rule requires. That's just me thinking outside the box here. But there may be a better solution. But how can we help someone like these ladies who has been aggrieved because the clerk failed to follow the rule? What can we do to get that person back into a position where the sensitive personal information is not available to the public? Would you be able to come back to us within a week or 10 days with a suggestion?
Yes, and I can, the section council at least is meeting this week, so.
Can you bring it up at the section
I
council?
can certainly bring it up. And
we don't have an awful lot of time, so maybe the section council could appoint 3 people to sit down and focus on this and spend an hour or 2 and then come up with your best idea and give it to us.
And this is, you're asking for ideas, and I'm not here. This has not been vetted by anyone on the section council.
I understand.
But, as I'm sitting here listening, one thought would be not a blanket restriction outright where you have to the public has to petition specifically to even see a record ever. But and I believe there's a similar procedure already under the PIA actually, if someone submits a request for records that are deemed to be personal, notice be provided to the subject of those records so that if they desire to challenge or, to shield or seal something, they know before the horse is out of the barn. And that would be, I don't know if that's under the PIA. I don't know if that would require, modification of the Maryland rules by the judiciary. But, there are certainly things that can be put in place that address the issue without totally cutting off public access.
Right. So I think you could sense that there's an appetite on the part of this committee to help Ms. Gallagher and Ms. Stone-Gines and give them recourse when they've been injured. So if you could get back to us within, say, 10 days from today, like middle of next week, with the family law section's best suggestion as to how we can deal with this issue, I'd appreciate it.
Certainly.
And why don't you communicate with Senator Sidner, and he'll share what you tell him with the rest of the members of the committee. Thanks.
Oh, thank you. I don't want to make this hearing longer, but I guess one of the things I'd like to know, just in general, is what is the standard for you to get your records sealed in a divorce proceeding? Do you know what that is?
I was trying to pull up the rule while I was sitting there, and I couldn't remember which one it was.
And I don't know if it's different than sealing in general, in a larger context.
I don't want to misspeak.
Okay.
I believe it is not simply just by a preponderance. There's a showing that you have to show that you have to have some particular interest that needs to be protected, and that has to outweigh the public interest in access to the record.
Right. So, I mean, I can talk to the bill sponsor more, but I think even just looking at that standard in a divorce setting is something worthy of our consideration. And again, you're not on trial here at all, but you did come in for the Mayor's State Bar Association, and I'm just having a difficult time thinking of 2 people that are not married that end up in a long-term relationship, have children, and then decide to split, and the world is not wiser for it. Or they may even obtain that level of common law marriage. Now, look, I know that's not a concept that generally prevails in Maryland, but and I can't for the life of me think of a compelling public interest for a particular, not a global look at divorce and child custody and support, but individual people who decide to apply for divorce. I can't think of a compelling interest from the public, or the financial records, or a record of their settlement, which is often very, very detailed and goes into minutia of things about how they're going to conduct their lives around these. these young children. And then, of course, whether people want to know about the custody order or not. In the particular individual. Globally, generally, I can see this, but I'm struggling there. I won't ask you now, but I would like to hear more of the State Bar Association's understanding of what is so compelling about all of that information and how we could better protect it while balancing whatever interest they do come up with.
And I know you're not asking for an answer to that question right now.
I know this is a lot.
I'll just, with regard again to the finances and marital settlement agreements, those are supposed to be restricted. So this is why we're referring to this as an isolated and frankly unusual case, because this is not the type of information that should ever have been disclosed under the rules that we have.
But that's why it makes me wonder if we don't flip the switch and make it so that it is so private that even a clerk of the court or their assistant can't make this mistake. And flip it so the public, journalists, or whoever else, they come in and they prove that this is information that's needed, because people in divorce are traumatized all over the place, and for them to think through and then have to go to a hearing and hit a burden pretty high to have their private lives remain private, to me is adding insult to injury. It's adding an awful lot of onus on them. Why doesn't the state have some compassion and think about how we flip that and make the proponents who want it won't be forever secret? If they have a compelling interest, they can certainly come up, we can fashion remedies for them to get some of the information. All right, thank you, Mr. Chairman.
All right, thank you very much. Senator, so I have the petition to seal here. I'll pass it to you, Senator James.
Oh,
and it has the standard
yeah,
that.
I hadn't seen it for a while.
Yeah, so we'll pass it around to the committee before we talk about this bill, if we want to vote on it. So I understand the rules cover things like, some of the settlements and names of minors, social security numbers, that type of thing. I know the rules, Rule 220-201, right? That's the rule you cite. But what about the other salacious details that are inside of that document that don't pertain to like finances or things? But people are going through very difficult times, and so they tend to drop in little nuggets of things and that could be embarrassing and not meant for public disclosure. I wonder, what is the public policy purpose for that? Because in like a criminal proceeding or something, there's obviously like a public safety element to that. Like the public should have access to understand like if there's a public safety threat. So I understand that, access to those documents. But what about that type of material in a divorce proceeding? I just don't understand what the public policy purpose would be to have that out on the street.
I think this goes to some of my homework.
No, yeah. I mean,
I leave here today.
No, I'm not trying to. I'm not sniping. I'm just trying to understand. And the rules go far to an extent, but it doesn't cover the other kind of more salacious, things that tend to be disclosed during these things.
And as someone who's written a lot of those details and motions and complaints, no, I understand. And there are, again, I said earlier, I'm not here to defend in total the rules we have and to say that they work the way society might want them to work. And I can't, the public is a vast entity, right? So what is the public interest in access to a particular record in a particular case? I can't say. There may be a reason, and as of now, the rules we have allow any member of the public to make that argument for a disclosure, at least under the Title 16 of rules, not necessarily the PIA. I think that the MSBA, well, I am the MSBA here today, so the MSBA's position is not that there doesn't need to be a change, not that there couldn't be adjustments or fine tuning, but that the bill that is being considered that just amends the Maryland Public Information Act doesn't get to the heart of the problem. It could have other knockdown effects. And I didn't even mention, this will not just restrict access to the courts. This would restrict access to divorce-related documents that might be in the possession of other agencies. And that happens, and it can actually be important. For example, if there's a pension plan, right? And when you submit a pension order that you get from the court, often you have to submit alongside it your divorce decree, your marital separation agreement. And those are records that, once they're out of the purview of the court, they're not governed by the Title 16 rules. But as a divorce lawyer, that is often very important to get, to be able to, issue we normally would do it by subpoena, but, to be able to request those records and get them, because it means more than just what is on the page. It shows some action by another government agency. And this bill would not just be limited to the problem that it was offered to correct, which is what happened in the courthouse. It would affect every agency, every governmental body in the state of Maryland that is subject to the Public Information Act and may have in its possession some record connected to divorce.
Excellent. Well, thank you very much. Senator Sidnor.
The scenario that you just mentioned about the other records, just out of curiosity, now let's look at the language of the bill and go to page 2, line 26, where it talks about how a custodian shall release a record pertaining to a divorce proceeding to an applicant who is a person in interest, or a lawyer representing the person in interest. Those carve-outs wouldn't be sufficient for you?
I think it would, the specific example I was thinking of was one where it didn't necessarily involve the party I was representing. There was a dispute over a pension where there was actually a question whether the decedent, he died at the time, had been married, was in a bigamous relationship with our client. And it turned out that his new spouse, they got in divorce, he got remarried, and he died, but in the year and a half where he was alive after the divorce, his new wife found out that actually he was never married to wife number, 2. We thought she was wife number 1, and submitted some decree from Virginia up to the agency, and it voided the award to our client of a survivor benefit. And that's not necessarily a document that the wife number 2 would have been entitled to obtain if there's this restriction on divorce records.
How about that third exemption has been authorized under a court order to inspect the record? You couldn't get a court order?
You could. I think that would be.
Okay, that's all.
Yeah, you could, but I think from the MSBA's perspective, that would be a onerous burden to have to do that for each
more
record.
onerous than the ladies who had their information put out there by the government?
I certainly wouldn't.
As attorneys, you're getting paid.
I certainly wouldn't say that, Senator. I
just wanted to make sure we're on the same. All right, thank you.
Okay. Thank you very much.
Thank you.
God bless you. Thank you for coming up here. I know like just a couple. No, it hasn't been easy. No, thank you. No, yes. Yeah. But it's invaluable, so thank you, sincerely. Okay. With that, y'all are too much, man. All right. That'll. All right. That'll conclude the hearing for Senate Bill 426. We'll now move on to Senate Bill 335 with Senator Love.
Thank you, Mr. Chair. May I bring my panel up? Okay. Good afternoon, Mr. Chair, members of JPR. Senator Sarah Love here to present SB 315, which I am calling the Home Act Part 2. In 2020, this body passed the chair's bill, the Home Act, Housing Opportunities Made Equal. The purpose of that legislation was to prohibit landlords from discriminating against individuals based on their source of income. Now, many landlords are complying with that law and both the letter and the spirit of it. Unfortunately, some landlords have figured out a way to circumvent the law by subjecting prospective tenants to excessive income requirements or to deny tenants housing based on a poor credit score or a credit history that reflect periods of hardship before the housing assistance was received. I'm sorry, I said 315, it's 335, my bad. Sorry about that, Senator. 335. SB 335 clarifies that landlords who use financial information in screening may not refuse to rent to a prospective tenant with an income-based housing subsidy on the basis of income, credit score, lack of credit history, or pre-subsidy adverse credit history when the landlord could reasonably have known when the subsidy began. Now, while considering income and credit score on the surface may seem like a reasonable requirement, basic math and an understanding of the process reveal that it is not. First, requiring a tenant to show they have multiple times the amount of the full rent doesn't make sense. They're not required to pay the full rent. They have the housing subsidy, so they're only paying about 30% of the rent. Second, the Housing Choice Voucher Program is specifically designed to stabilize families and ensure that rent gets paid. Housing authorities verify income, calculate utility allowances, determine affordability, and generally cap tenant rent contributions at 30% of income. So let's talk about credit scores. Credit scores are designed, for the most part, to assess repayment of loans. And so they're misapplied as a marker for the likelihood of paying rent for a subsidized tenant. They rarely include rental payment history, and they ignore the existence of the government subsidy and the rigorous affordability and income verification that is done by voucher administrators. Almost by definition, families eligible for housing assistance have lower credit scores. Families with limited incomes still need to find a way to handle life's crises, and the cost for caring for a family. And for those without other options, that can mean credit issues. You know, as we were looking at this bill, we looked into the HUD guidance. And I want to quote from that, the HUD guidance on screening of applicants for rental housing. Quote, limiting the use of credit scores when more relevant financial information is available may be a less discriminatory alternative to using credit scores in all instances. So let's turn to credit history. Again, HUD has acknowledged the flaws in relying on credit history to predict successful tenancy in all situations, and further that there is good reason to avoid credit history screening for tenants in specific instances. Quote, a government agency or other entity guaranteeing a significant portion of an applicant's income should make it significantly more likely that the applicant's rent will be paid on time, notwithstanding any negative credit history. So, additional screening, income and credit screening by landlords is redundant and serves only to create an unnecessary barrier and a legally allowable way to exclude voucher holders from housing. Failure to acknowledge this unique guarantee of rent payment has real consequences for real people in this program. For example, and these are real examples, a single mother who finds herself struggling with her credit after her divorce, but prides herself on never missing a rent payment in 20 years, denied housing. A family whose child lives with a chronic condition falls behind on medical bills, but prioritizes housing stability for their family. Closing these loopholes will ensure that the Housing Choice Voucher Program can serve its purpose in its full capacity. To be clear, the bill does not eliminate tenant screening or impose unreasonable burdens on landlords. It preserves existing federal exceptions and explicitly allows income verification where required for income restricted or subsidized units, ensuring flexibility where necessary. For these reasons, I respectfully request your favorable report on SB SB335, and turn it over to my panel. Thank you.
Who's going next? Mr. Chairman.
Oh, can you come up to the podium, please?
Sorry about that. Mr. Chairman, Vice Chair, and members of the committee, thank you for the opportunity to testify. My name is Adria Crutchfield, Executive Director of the Baltimore Regional Housing Partnership, here today in strong support of SB 335. Every day, we help economically disadvantaged families access the same things we all want for our children: safe neighborhoods, good schools, and the promise of a better future. The bill is designed to address key barriers that circumvent the intention of the HOME Act by keeping assisted families out of desirable housing while promoting more relevant screening alternatives. For these families, the impact of credit-based screening is not abstract. In a recent survey of participants in our program who moved last year, they reported submitting an average of 13 applications before being accepted, and nearly 50% report credit as the most common reason they were denied housing. Families use scant resources to pay application fees and prepare to move, only to be rejected because of a credit score that existed long before they received rental assistance and does not reflect their current financial security. Parents working multiple jobs, caregivers managing medical issues, or someone trying to escape an unsafe environment have their years of hardship continue to follow them in the form of a number that overrides their rental history and guaranteed assistance. To quote one of our participants, a lower credit score does not mean I am unemployed, unable to pay, or irresponsible. It means that I am prioritizing my family's survival, end quote. Credit-based denials directly undermine the purpose of housing assistance, which is intended to stabilize families so they can focus on work, school, health, and long-term economic resiliency. National guidance, as the senator mentioned, from HUD explicitly cautions housing providers against over-reliance on credit scores, not only due to what she mentioned, but also because they pose a significant risk of unjustified discriminatory impact. SB 335 recognizes the reality of assisted tenants and ensures that screening reflects what actually predicts successful tenancy, like rental history and landlord references paired with the voucher program's built-in income and affordability verification and safeguards. For these reasons, BRHP respectfully urges a favorable report on SB 335, and thank you so much for your commitment to housing access in Maryland.
Good afternoon, Mr. Chair, members of the committee. My name is Jennifer Bevan Dangle. I'm the Deputy Director of Economic Action Maryland Fund. Economic Action Maryland Fund runs a fair housing program where we work directly with clients who are struggling to either understand or understand how those laws are being used for or against them. And we also do training for landlords across the state. We are seeing a rise in complaints and clients coming to us over source of income discrimination. And a lot of it comes down to this use of credit history, credit score, when the HOME Act really has said that this is not an appropriate place or time to be using those factors. I know it has been said, but it is incredibly important to reiterate that there are tenant screens that are much more predictive of tenant behavior, looking at rental history, looking at the tenant's history. This is not prohibiting landlords from using any of those actually predictive screening tools. This is simply saying that the intent of the HOME Act was to take income out of the question, to give these tenants a fresh start, a second chance, and that to go back and use their credit score that, again, predates this voucher being given to them is undermining that entire intent. A lot of the opposition testimony that we're seeing sort of insinuates that they want to pick and choose among these tenants. And the whole point of the HOME Act was to say, look, we understand there are people who deserve that clean slate, they deserve that fresh start, and to give them the vouchers to have an independent agency thoroughly screen them, look at their income, determine what's appropriate and applicable, and then to have their back, to pay for, I know the sponsor said on average the entity is picking up 60%, but it can be, the tenant can be responsible for as little as $0 on their rent. That's what the rest of the funding is coming from these government agencies. So to then start to look and pick and choose clients or tenants just based on their income and their source of income and their credit history undermines the entire point of this program of giving people that fresh start. So we urge a favorable report.
Good afternoon,
Chair Smith, and members of the Judicial Proceedings Committee. My name is Nicole Earl. I'm the president of the Dominion Community Development Corporation. We're an impact investment real estate firm based in Baltimore, and I'm here to express my support for SB 0335 as someone who lives and works with families every day who are simply trying to survive, stabilize their families, and thrive in doing the right thing, who have secure income, who simply want a chance to live safe in housing with their children. This bill matters because it addresses something that is happening across Maryland every day. Families with housing assistance are being turned away, not because they can't pay, but because of how their income is viewed and treated. This is not fair, and it's discriminatory. This is about real people. I think about women like my neighbor and her beautiful children. She's not asking for charity. She's not asking for a free ride or a handout. She's asking for a fair chance for her family, an opportunity to have a better life. Stable income is stable income. And the bill sends a message. If a person has stable income, including income-based housing assistance, they should not be treated less than worthy for housing. It should not be legal that the same assistance becomes excluded. A credit score should not be used as a backdoor way to deny someone who has a reliable rent structure and the ability to pay their rent. Let me be clear, this bill does not, nor do I, support removing responsible screening. This bill does not prevent landlords from protecting their properties. As a landlord, I still want the right to verify rental income and rental history and tenant responsibility. What this bill does is stop the automatic exclusion of families simply because their rent is supported through a subsidy or because they don't fit a traditional credit scoring model. Maryland has strong commitments to fair housing and equity, and we should continue to lead. This bill is part of shoring up the communities. Families should be able to live where they choose in safe communities if they have stable income and are good tenants, regardless of that source of income. So in closing, I respectfully urge the committee to issue a favorable report on SB 0335. This bill will help families like my neighbor live a stable, thriving life for them and their families. Thank you so much for your support.
Good afternoon, honorable committee members. My name is Liz Kruger, and I am the Director of Homeless Services for Interfaith Works, where for 53 years we have served individuals and families experiencing poverty and homelessness. At Interfaith Works, we urge a favorable report for SB 335 on behalf of the community members we serve because they deserve fair access to housing and they have so often been denied it. At Interfaith Works, we have almost 20 years of experience being voucher administrators, and so we know firsthand how children, families, individuals thrive when they have stable housing. They invest in their community, they invest in their housing, and less than 5% of the population we serve gets into the arrears every single year. So that is significantly less than the general population, I want to point out, and 99% of them maintain their housing year to year. We also know the overwhelming discrimination our community endures year after year after year. And sometimes it's overt, more often it's subtle. The HOME Act was a great path forward. However, week after week, we are working with individuals and families who are still getting denied housing based on their credit history and their credit score. So this is something we inherently find discriminatory for all the reasons already stated, because our population has not had the chance, being chronically under-resourced, to build credit. But we also find it targeted. And Montgomery County Health and Human Services agreed with us, recently conducted a fair housing test where they found that more than half the landlords and property managers reviewed had been found were culpable of source of income discrimination. So I just want to conclude by saying this was distressing not only because of the harm to the community members we serve, but also because we believe that landlords and property managers really stand to benefit from a relationship with voucher administrators, from the support they would receive and the consistent guaranteed income at a time when so many, not just voucher holders, are struggling to pay rent. Thank you.
All right, thank you, Senator, and thank you for your panel questions. Senator Henson and then Senator West.
Thank you, Mr. Chairman. Thank you to the bill sponsor for bringing the bill. I really love this bill. That's probably why I'm a co-sponsor. Right. Oops. One quick question about it as well. Does this, I understand it would cover neatly housing subsidies if you have like a housing choice voucher. If the person lives in a property, let's say like a tax credit community, like a LIHTC community, or another community that has a subsidy attached to it by the way that it was financed to be built, would it be covered under this bill as well?
LIHTC properties here in Maryland already cannot screen for credit scores. And yes, I believe the bill language is written in a way that it talks about assisted families broadly. So those served by the housing choice voucher and others where the subsidy is attached to the property, which is what you're referring to.
Wonderful. With the LIHTC families and the prohibition on screening, do they get relief under the state law? Like, is that prohibition a feature of like their federal laws where they can't do that, or could they file a complaint with MCCR and get support there as well?
It's DHCD policy is my understanding, and yes, they absolutely could file a complaint, but that's the way the guidance is currently written for those who are seeking tax credit allocations in their project proposals.
Okay, can I keep you there for a second? Sure. The opposition testimony, a lot of it just said we don't like it. But one of them did have some substantive things that they pointed out, and I would love for you to talk through those on the record so we could have the benefit of understanding a full perspective on them. One of the opposition testimony spoke about when the portion of the rent is not fully subsidized and the tenant does have their own portion of the rent to pay, and the landlord wanting to have some predictability in that portion being paid timely and being paid in full, and the credit score being an indicator of that. When you talked about in your testimony, there are other reliable ways to measure that absent a credit score. Can you talk about some of those other ways to measure that without the credit score, and how this bill wouldn't take away those tools?
Yes, thank you for the question. This does not prohibit, as Ms. Earle mentioned, landlords from using other screening mechanisms. They can certainly look up any case law that exists, any court filings that exist for failure to pay rent, for example. And I do think it's important to understand that with those who are assisted, when their income goes down, the subsidy goes up. So that's how you could have a tenant whose income went to zero and the subsidy is covering the full fair market rent. So yes, there are definitely all the other tools available. Additionally, our understanding is that landlords have the ability to choose what metrics they want to screen for in those third-party algorithm vendors that they use, and they do not have to choose credit. And I couldn't tell you what's in the full algorithm of what those third-party providers are screening for, but there are definitely tons of other metrics they can be looking at. Additionally, we recommend for our participants landlord references, rental resumes that show where they've previously lived, along with just a reference from their prior landlord to indicate that they were paying on time.
One of the other things that was mentioned there were other costs. Like, let's say a person's renting a home and the renter's responsible for yard maintenance, and maybe it's presumed you'll have to hire someone to cut the grass, or maybe the tenant's responsible for utilities and they have to keep up with the quarterly water bill or some other things that outside of the rent you have to rely on the tenant to pay for, and the landlord wants to be able to screen to make sure they can take care of those other things. What sort of ways, outside of looking at a credit score, could a landlord get some assurance that that's going to happen?
Sure. Again, the housing providers are doing a full workup of affordability, and a lot of fees that landlords do try to assess may not be eligible, and those are stripped out of leases in advance of signing those leases and in advance of the HAP agreement, the rental assistance going into place. In terms of utilities, however, utilities are often factored into the subsidy. And so in addition to the rental assistance that a housing provider is providing, we are also providing utility payments. So they can actually cover both their portion of the rent and the associated utilities. So that's already an allowable cost for subsidized tenants.
Thank you. Thank you, Mr. Chair.
Oh, thank you. My question is going to reveal how little I know about a lot of this, but, so I think you can probably follow up because probably there are people in the committee that know a lot more about this. But, for example, I keep hearing there's tons of other screenings or tons of other ways for landlords to protect themselves, but I only keep hearing really one, which is, rental history from a prior landlord. Did they pay on time? So I'm sure the opponents of the bill will walk me through that, but I don't hear tons of other ways to screen. The second thing I've heard is that your credit score may predate your voucher, but what if the credit score does not predate the voucher? What if you've been having a voucher for 5 years and your credit score is pretty bad? What's your response to that? To me, that credit score then becomes very informative.
I'll take the last part first. My understanding of the bill is that it actually only would allow for a look back on the credit score, the screening, while they were assisted. The intent behind that being that they should have been paying all along while they were assisted. So again, we're advocating that you not be looking back at credit scores and credit histories when a person was really down on their luck and not assisted with the housing subsidy at all. So perhaps that's something that we can clarify for you after the fact, but.
Okay, yeah, again, just make sure. So
sure.
My question is, you've had a voucher of some sort for 5 years. In that 5 years, your credit score is very low. I don't understand why a landlord cannot take into account.
During the use of the subsidy, they absolutely could. That's how the law is written. It allows for that exception. And any housing provider can provide the terms of that subsidy, so a landlord would know.
Then just a philosophical question, which is I am a very modest, private, small landlord. It's not my main business, but I was very moved by some testimony in here that is coming from a group that are pretty much a lot of us little landlords. We're not businesses. We're not anything. We have 1 or 2 houses, right? We don't have an institutional ability to go around, and nor am I going to take the time, and nor do I feel I have the obligation to find out about the tenant beyond something reasonable. In fact, I think should be the onus is on the tenant to sort of prove that I should want to rent to them. But in that's what I feel like most of us little landlords would say to you is, I am delighted to get any tenant that pays on time, all the time, et cetera, et cetera, et cetera. But I do have to protect my situation because sometimes when I'm not paid, then I don't make a mortgage payment, I don't make this payment, I don't make a that payment. So, but most of us want a tenant that is reliable and with vouchers or whatnot. So why is it that your belief that these landlords who look at a poor credit score cannot balance that with perhaps, a good pay on time history? Why are we assuming we can't trust people like me to make decisions? Are we all angels? No, but just in general, this bill seems to me to be basically saying all landlords aren't to be trusted. All landlords potentially violate the law. All landlords are very unfair, as opposed to most landlords want a great paying tenant but want a full amount of information and have the information and weigh it and use good judgment and decency in the process. So how do you respond to that?
Sure, Senator, I appreciate that question. And we appreciate that over 2,100 landlords that are active participants in our program. We absolutely could not provide assistance to tenants without your partnership. So I would just say a couple things. We have surveyed some of our landlords, and the ones that own 1 property here, 2 properties there, the smaller mom and pop landlords, which we call them, do not use credit scores. They already do not. So this is not about necessarily
where are you surveying? Sorry, where are you surveying?
Within our 2,100 landlords.
Are they
in the Baltimore region?
Okay.
Yes.
So I oftentimes have to remind people the Baltimore region is not indicative of the entire state.
Fair, sure.
All right. So solutions often ought to be focused on that community, and other communities that are not experiencing this do not want to be under the solutions that are tailor-made for your community. So when I get a lot of information and it's data that supports it, and I find out that it's confined to a certain population or area, and there's been no effort to do things statewide and see if a one-size-fits-all would work for everybody, that is a problem for me. But thank you for being honest about where your data comes from.
Sure. I guess just to add on, additionally, we believe that there are other metrics that landlords are already using. And I would say that for the owners of multifamily properties, this is where it becomes an even bigger hurdle. And so I know that's not the type of property you lease, but for others, they're using
thousands of people just like me. It's not really about me.
No, I understand. I understand, okay. Totally. But for those multifamily property owners, those are the ones that are heavily relying on the third-party providers. And there is no transparency behind what they are using to deny someone. There's another bill I testified on, HB 313, last week, which relates to that matter. But again, there's not enough transparency. The tenant is never even fully informed necessarily through that report. It's just, or through the denial of why. And we really look at the credit score as just a barrier.
Well, then let me stop you. If you don't know why they're being denied, why are you focusing on credit scores if you don't have the data to back that up?
So I do believe there is some data. I misspoke, and we can certainly provide that to you after the hearing, for sure. There are lots of research entities that have looked into this issue, and I think some of my colleagues can speak to that better than I can. Additionally, I just want to say that, the HOME Act supports the whole state, and I was just speaking to our service jurisdiction, which is not just Baltimore City and Baltimore County, it's also Hartford County, Anne Arundel, Howard County, Carroll County. So that's the Baltimore region for us, and I believe others could testify to what they experience with landlords in other geographies in the state.
And then another question I have for you is, and this is, again, might not know too much about this, when you get a voucher and other subsidies, is that forever? In other words, when a landlord is looking at somebody and I did think there was sort of a cap where the tenant had to pay about at least a third.
30% of their income,
okay.
Correct.
Right, but you get down to zero with other programs. Is every program and all programs like in perpetuity, so a landlord doesn't have to worry about it putting in a tenant who had some subsidies, but then loses the subsidy? How does that work?
They are recertified every year to 2 years in terms of making sure they are still income eligible for the housing assistance. Mm-hmm. And landlords that are receiving the assistance receive regular communication from the housing providers in terms of the amount that the subsidy is paying.
And so that amount goes directly to the landlord?
Correct.
Okay. And then sort of, to me, I could be wrong about this, but I'm hearing, for some extent, I feel like this credit score is a proxy for race, and that what you're really worried about is some sort of racial or protected class discriminatory conduct, and this is a proxy for it. How would you respond to that, since, a lot of this is about lack of transparency and, to me, some speculation?
So discrimination based on income under the HOME Act is discrimination, and that has nothing to do with a racial lens or a racial component. This legislature, and some people voted for it and some people might not have, but this legislature has said, as a matter of state law, the HOME Act has said income discrimination is discrimination. And so that's why we're saying we're not claiming it's anything other than that.
So you have I cannot look at your income and decide that the income isn't sufficient and therefore I don't have to rent you? Is that the law? I apologize, I didn't know that was the law.
Under the HOME Act, source of income is in itself discriminatory. So for these voucher holders.
Okay, don't say income, you're saying source of income. Okay, so we're not talking about your income. I can look at your income and I can use your income as a basis for deciding whether to rent you. But if your source of income is from the federal government, and I assume it's only that source, because, in other words, is it any source if I get sources from legal? That's good. Legal source. Okay. Legal source. So if we have a law then that says that you cannot deny renting to someone based on their source of income, then again, how does this credit score Why is, I just don't get why this credit score is needed unless it's a proxy for something other than a credit score.
So that is our concern, is that the credit score has become a proxy for source of income. And so the credit score is being used sort of in lieu of looking at the source of income. So it's very specifically on this.
And you're finding that landlords will reject tenants with good rental history, go completely against their own self-interest just because of the vouchers. Is that correct?
We have, yes. I think across all of our different clients, we have certainly seen that.
I'm sure you have anecdotally, but I don't know about, large-scale data, which would be helpful to me. All right, thank you. Thank you very much for your indulgence.
I don't know whoever wants to answer this question. I'm just perplexed. So I supported the Home Act, and I believe during that testimony, we were told that this was going to fix our problem. And I'm actually offended to say looking at somebody's credit score is somehow discriminatory. It's like saying if everything's a priority, then nothing's a priority. And speaking on behalf of Allegheny County Landlords Association, I believe we have 28 members. I don't know exactly why you think the Baltimore region should dictate what the state of Maryland should do when it comes to your issues that you're having. It seemed to me that this bill is more about third-party providers and the little click if you're going to have the credit scores. I really have no idea. I am a small landlord. I don't know what you want me to do. I mean, we have a housing shortage. I believe it was last year we had somebody come in and talk about all the housing shortages, and the biggest problem is all the regulations that the General Assembly seems to be passing. I mean, just go ahead and put it on a bill that says you want to take it all over and just pay the landlords for their properties. I don't understand why this bill is not just for third-party providers. And if you don't subscribe to a third-party provider, then having a credit score shouldn't be a problem.
Yeah, and I just want to, so my agency represents Montgomery County. I know there's been a lot of talk about us just representing the Baltimore region, Montgomery County, and we've actually expanded our services into Prince George's as well. So there is data we've been collecting. We don't have Allegheny County just because it wasn't available, not because we didn't want it, but it's been hard. This is very hard data to collect, actually. But what I will say, the important distinction.
Is it hard because you're not getting the answers that you want, or is it hard because...
No, we're not manipulating data. It's a good question. It's a fair question. Yes. It's really, really hard to get this information from public housing authorities. It's hard to determine how many evictions are voucher holders. I've actually been appalled at how difficult that data is to find. So we've done the best we can, and I think it supports a narrative, not because we were looking for it, because we were genuinely curious. And there is a lot of evidence. I know you were asking about maybe some of the evidence that there is discrimination happening. So I just want to go back to your point, because it's a valid point. Like, credit score has been a long-standing way to assess risk. But we're not asking that credit score and credit be taken out of the equation entirely. Just for the period that person did not have the resource of a voucher. Really, so this is really like applying to first-time voucher holders. If they've had a voucher for a year, you can look at what happened over that year. You also have access to court records, right, as was pointed out previously. So there is a way to search, what happened with evictions, et cetera. So what my colleagues have said is that credit score, credit history is not the greatest indicator. There's also evidence of that, of who will reliably pay moving forward. And so, like the landlord reference, and I understand your point too. You're like, that seems like, that's not enough. Landlord reference is one of the strongest indicators of someone's reliability, their responsibility, and an indicator of whether they will pay. So that's why it keeps coming up.
I can tell you that is the number one for me and a lot of the landlords that I have conversations with. It is that, do you have a reference from the landlord about making payments on time? To start, I think it's a a sliding slope to take out credit score, what's going to be next? I don't, I've only been a member of the JPR for going on, this is my 4th year. But it's an all-out assault on landlords. It's just unbelievable. You want to know why we have a housing shortage? You know why people want to get out of it? Because of the unbearable regulations that the state is putting on it. And I get it. You got a problem in Montgomery County. I got it. You got a problem in Baltimore County. It seems to me you got a problem with subscribing to third-party providers. But if you're a mom and pop landlord, all we want to do is have someone to pay the rent. You know, I look at my building as we're one great big happy family because we all got to live together. I live with my tenants. To say that I can't use the credit score, I just go in blind. And I'm somebody who looks for helping out people.
That's right.
I pride myself of being a second chance guy. But awesome. I don't know. I think you're doing yourself a disservice by casting a net so wide and then throwing small landlords into this supposedly bad behavior. It would just seem to me that this bill would be better for talking about third-party providers. And if you're not doing a third-party provider, leave the rest of us alone.
Okay.
And I guess I have to answer that in a question, didn't that so? But thank you.
Yeah, no, thank you. And I will just add to that that we have found that small-time landlords are also guilty of this discrimination. And like even in the fair housing test that I just referenced, that it is discrimination, but will you let me explain? So like the fair housing test that I was referencing in Montgomery County, right, that they were applying different standards to different people. So that like, well, there was a credit score standard for our tenants in our continuum of care. They weren't applying that standard equally across all applicants, right? So that's what a fair housing test will do. Right? And your average tenant, your average, nonprofit doesn't have the resources to make that kind of request all the time, right? So we just have to accept that they were denied on credit, and we don't know if the landlord, small time or huge property or Bazzuto, right? Like we don't know what standards they're applying across the board. And so the reason I bring that up is to show that there is evidence. There are other examples like that, but we don't have the resources to every single time we suspect someone was discriminated against to go out and do a fair housing test on the small time landlords. And we appreciate you. The smaller landlords are some of our best partnerships actually. So this is not to harm the landlords or property managers either. Like we see this as a win-win situation. I mean, there is guaranteed income coming from the voucher administrator. It's generally 30%. For a lot of the times we're paying 100% actually, and we still get discriminated against because that's not protected. But it's the Home Act has not covered all of it, and we have found that discrimination is still happening. So
you talk about not having the resources to be able to do this. Where are the resources going to come for these small landlords to be able to figure out all the nuances and all this kind of stuff? Where's that going to come? You know where it's going to come? It's going to reflect in the rent. And so you're just pricing yourself. I mean, it's kind of like chasing a dog chasing its tail. It is absolutely. I apologize.
Okay, no, don't apologize. It's good questions. And the resources should come from the partnership with the administrator, whether it's a public housing authority, whether it's a nonprofit. They should be helpful to the landlord too.
Right. I'd be interested to know the data that you're talking about that now is saying all these credit scores are the reason why not you think it is,
of course,
but that it is. And I understand it may be hard to get the resources to be able to do the fair testing and all that kind of stuff. But at some point, I think there was something shared with us last year that talked about, regardless of people building new rental housing and that kind of stuff, the actual financing for it, and that Maryland is designated as somewhere, if you're an investor and you want to invest in housing, you don't want to do it in Maryland. And I'm going to tell you, it's bills like this that just have a thumb on people that are just trying to help people out. And so, thank you very much. Thank you.
And I think there's a lot of reasons for it, and I'd love to talk to you more about it sometime. I think there's.
Well, I suggest you go back to that, and regardless of what the policy is, if people aren't willing to invest, they're not willing to invest. And I think
true.
Montgomery County is a prime example of any kind of brand new multi-housing units. So thank you very much.
Thank you.
Chair, can I ask a question of the sponsor of the bill? To piggyback on the conversation that just transpired. So would you be willing to consider an amendment to the bill which would only apply this bill to landlords that rent more than 6 units? So exempting the small landlords from the coverage of the bill.
I am always open to having conversations. I think before I commit to an amendment like that, we need to figure out the data that we've seen and what the folks up here and their partners are seeing, but always willing to have that conversation and entertain different ideas.
Okay. And then secondly, interestingly, it wasn't apropos of this bill, but last night I had dinner with a person, an elected representative, who is quite familiar with Montgomery County and distinguished the independent towns of Rockville and Gaithersburg from the rest of Montgomery County. I talked about the testimony we had last year that you couldn't get financing in much of Maryland and Montgomery County in particular to build new rental housing because of all of the bills that we've passed, which make it difficult for a landlord to make a buck. He said, Chris, because those two communities, Rockville and Gaithersburg, are separate, they're not subject to much of what we've passed or much of Montgomery County has passed. And therefore, he says, we're building rental housing in Gaithersburg and Rockville where we're not building it in the rest of Montgomery County. Do you find that to be the case?
So I don't know the specific situation that you're finding or that you were talking about or who you were talking to. I can say that all that I have read about the challenges of building housing in Montgomery County have nothing to do with the Home Act. It has to do with rent control. It has to do with some other things that are in Montgomery County, but none of it has been around the Home Act. So your specific question, I don't know.
It is the rent control, and it's talked about all the time in Montgomery County. The rent.
Do you want to come up to the podium? Yeah.
Rockville and Gaithersburg is rejected.
Yeah.
So that's what he's talking about.
Yep.
Yeah.
Okay.
That is deterring builders.
Yeah.
All right, great. Thank you very much.
Sure.
I'm sorry to follow up, but I just got a chance. I'm certainly going to ask if the proponent's here, but I just read some testimony that I have to understand. This is a person who's describing to me not your FICO scores or, what are those, the 2 or 3, right? But there's something more involved, things that are called like rental-specific screening services like Rent Spree, CoreLogic, My Rental, and they go on, and I'm doing a bit of a disservice, I'm going fast, but they not only do a credit report, the background check, eviction history, income verification. I'm thinking about how technology, AI, it's coming, we're not stopping it, and it's going to be in everything, including helping small landlords or big landlords just have, cool apps and all kinds of stuff to be able to get information. So, can you want to respond to this? Are you trying to ban this? And I don't know how you would keep up with something that did, but remember, these do have a credit score component, which I think is what the bill is trying to outlaw, but here you have it, and I think it's even smarter. It's a more comprehensive, probably very nimble, flexible, and will constantly be in a subsequent iteration of what it can provide for you. So What if you're using something that has a credit score in it as one of the aspects of this new technology, and this new technology or these new apps that whatever these are called, whatever these services are called, how does your bill interact with these? What do you want to say about them?
So what I would say is that the bill does not ban the use of those. What it says specifically is you can't refuse housing on the sole basis of. So
Yeah,
this
sole
thing.
basis of what does it say? Is it say
On
credit score?
income, credit score, or lack of credit score, or adverse credit history prior to the subsidy. So this screening tool that has so many other things in it, I don't think is something that would be prohibited. Do you want to add to that?
Correct, it would not be prohibited. It's always an option that they can choose or to include or exclude.
Right, I just want, yeah, I see. So it's sold. So in a way, you might be passing a bill that is pretty much obsolete the moment it's passed, because I have a feeling this kind of more global analysis or some iteration of it, or anybody that reads your bill could easily figure out how to get around it by AI and algorithms and apps. But, you know, borrow a credit score, no problem. They can put it right in there and have 4 or 5 other factors that you may or may not find acceptable but are not addressed in your bill. And you may come back and find these all acceptable, but your bill is not going to deny landlords the use of these tools, right?
No, not at all.
Okay, that's very helpful. Thank you.
Sure.
So a question, so I know the concession you made by having the credit history available while you're on the voucher. But let's say you get on the voucher and then you apply for housing, and then I can check your history, which can date back, and that'll still have it could potentially have the adverse information accessible. It takes months, maybe years to build credit. So I wonder, like, is it, you know, tell me more about the concession and why that was there.
My understanding of the concession is that it cannot look back at the credit history during that time. And this is modeled, this is a change that's modeled after the DC bill.
Okay.
So I hear what you're saying about you now are on the voucher. I think that's what you're saying.
How do you stop? You can't stop the credit history at the point you're on the voucher. It's the point of the voucher I can look back, but your credit history is going to be, you know, back a certain amount of time. So you know it's going to have that adverse information in there. So I just wanted to know the genesis of it, the concession.
You're absolutely right, Mr. Chair. It is, but I think as you noted, that was a concession. That was a compromise that was made in the drafting and the discussions leading up to the drafting of the bill. Mm-hmm.
Thank you very much. Thank you.
Thank you.
All right. So we still have some folks signed up in favor of the bill. So we're going to go to the next panel. Mr. Shaw.
Good afternoon.
Earl, yep,
Chair Smith.
Yep.
I'm sorry, go ahead.
No, go ahead. Bring.
Right. Chair Smith, members of the committee, Zafar Shah, Advocacy Director for the Human Right to Housing at Maryland Legal Aid. As many of you know, Maryland Legal Aid serves renters across the state in all jurisdictions. Across all jurisdictions, Maryland has an estimated 128,000 unit shortage when it comes to affordable units for residents at 30% area median income or less, and overall 275,000 unit shortage for folks at 80% or less. And I just want to, just based on the conversation so far about this bill, I do want to stress that this shortage affects Hartford, it affects Garrett and Allegheny. It is intense. Around 5,000 unit shortage in Hartford and higher in Western Maryland. And it's because of that shortage that this bill is so important. When someone qualifies for, after waiting years literally, qualifies and obtains a housing voucher, that they be able to place it. They have 60 days typically to place that voucher. They're racing against the clock. They've already done everything that they should do. That I've detailed in my written testimony what the voucher represents in terms of income testing. The Housing Choice Voucher Program requires all sources of income to have been third-party verified, It does this over and over again through a system called enterprise verification. It happens quarterly. Every year, a tenant must continue to verify their income with the housing authority. And so the question in this bill really becomes whether things like the credit score or credit history actually tell a landlord more than what the housing authority is telling them. And I think that our argument, which you're hearing over and over again, is no. The answer is categorically no. The landlord already gets better information and gets it over and over again prospectively. And that's why we urge a favorable report on SB 335.
Good evening, Chair, members of the Judicial Proceedings Committee. My name is Albert Turner. I'm an attorney with the Public Justice Center and a member of Renters United Maryland, asking for a favorable report. Just real quickly, if I can, to add on to Mr. Shaw's point, particularly when we were talking about housing vouchers, not only is that voucher a golden ticket, but it is a ticking time bomb. So essentially, as Mr. Shaw pointed out, when you get your housing voucher, you have about 60 days to find a place to use it. If you don't have that 60 days, you're unable to find a place, you might ask for 30 days. That might be granted, that might not be granted. If within those 90 days you have not found a place to place that voucher, you lose it and you go right back to the waiting list. Just to give you some idea of what that waiting list looks like, Prince George's County opened up their waiting list last December. There were 47,000 applicants for 5,000 vouchers. The need is incredibly high for vouchers in the state of Maryland. And it is important that we connect people who have vouchers who are paying for the rent. The government is paying for that rent, connecting them with landlords and not allowing for arbitrary, unnecessary markers to get in the way of that. If I can add to a little clarity on how this works in practice, I represented a client in Annapolis and Anne Arundel County. She had a voucher that paid her full share, and she was denied over 20 times because of her credit report. Over and over and over again, she was getting these denials because of her credit report, even though her voucher was paying the full amount of the rent. And because of these arbitrary denials, she had to readdress where she wanted to live. She wanted to have her children go to a certain school. They had to readdress. She had to move to a place that was further away from where she wanted to go. And she had to kind of just figure out what to do because of the time limit. She had 90 days to find this place. Finally, on the 88th day, she was able to place this voucher. And because of that, we asked for a favorable report. Thank you.
Oh, thank you. For either of you, again, not knowing a lot about this, so what the federal government gathers before awarding a voucher to someone, is all that exact information in full provided for the landlord to read through? In other words, you keep saying the landlord, federal government does a great job at vetting these individuals and whatnot, and knows what kind of tenant they're going to be because they've done all kinds of review of them. So no need for the landlord to second guess the federal government. By the way, I think all individuals have the right to second guess any level of government, even though I work for the government, right? We see often the government makes mistakes. But besides that, do they share the depth and breadth of that information with the landlord, which would be maybe an approximation to a pretty good credit history and even broader and deeper analysis of the individual? Is that given to the landlords? So,
and my colleagues that just spoke might know this better because they actually negotiate these and provide these vouchers. First of all, it's not HUD that's doing this collection.
I didn't mention any government entity at all.
It's not federal. These are the housing authorities in your local county.
So they don't get any money from the federal government.
I'm trying to just address who's doing this verification, right? So
well, everyone has mentioned the federal. I'm happy if I don't care which one it is, but it is a government. How about that?
Right. It's your local housing authority collecting this information. They do not provide that to every prospective landlord.
Why not?
Why not? Not every prospective landlord enters into the contract with
Oh, that's fine. How about providing it to all the landlords that are in the system?
I don't think that automatically they get that information.
And that's a problem. to be honest with you, because I think if you want to tout how great it is, how great the analysis is, and then you deny the landlord the ability to read it and see it and get that comfort level and ask us, trust us, we're from the government.
Sure.
And I'm all for the good things government does. I think that's a mismatch that we ought to consider in when we move forward in trying to demand people to do something on the back end. However, I don't think it should be relied on in testimony if the landlord doesn't have a free hand at being able to see it, because everyone's touting it as great. It's the way to determine whether these tenants are quality tenants or not. But if the landlord has no ability to access it automatically or in some meaningful way, as a matter of course, I'm just suggesting that is another area that I think ought to be looked at if you're going to tout this background information.
I think that's a red herring. I don't think that, for instance, if you favor credit score checks.
No, I don't. What I said, I'm not sure I'm favor banning them entirely.
Okay.
How about that?
Do you agree that in your, I don't want to misconstrue you, but there are some small landlords that think that a credit score is valuable information. But they get that credit score information. They're provided by one of these screening companies or one of the big three. They don't know what information the company collected to create that credit score. They just get the credit score. So my point, I think, is that I think that there is equivalency between a landlord getting just the credit score, but not all the information that led up to creating the credit score, with getting the voucher information, that the mere, just the availability of the voucher, and not knowing all of the things that the local housing authority calculated and screened to come up with the fact that they are approving the voucher. So there is some equivalency there. I think that if you think
that when you don't get a credit score, like a FICO score, you don't get the background, are you hobbled and not understanding it fully? Is that?
If I'm a small landlord?
Yeah.
I don't think so.
Like you just see the number and you won't, but you don't know what went into it. You think that that's the best way to inform.
I think that is the, if I'm a landlord, I'm thinking, I'm not sure what to do with this credit score, because I myself know that, for instance,
I just asked if it's the best way to get the information is to know nothing about how it was derived. Yes or no?
No, I think that goes equally then to both credit scores.
That's right.
And again,
I'm not looking
Senator,
for an argument. I have one question, and apparently this is, it's just getting under your skin. I just heard multiple people, I didn't ask you to answer the question either. I think the other gentleman had mentioned, lots and lots of people are saying in this hearing, the federal government or the federal government may be funding it. Government levels have done the hard, heavy work to find good tenants for these programs, and that should be enough. And one of the justifications for, pushing out the credit scores or FICOs, whatever we're going to call them. And I asked, well, do they get this information automatically in depth and in breadth? And I think I'm hearing no, but so, and then I'm thinking maybe that's an area, a fruitful area to consider to get landlords to be more interested in believing that the process that exists as opposed to being wary of it and wanting to go with FICO scores. Can we agree on that?
I absolutely agree with you that
that's the
if
only
it
question I
takes
have for you.
landlords getting some type of income verification green light from the housing authority, and that will help the tenants place a voucher in 60 days, I absolutely agree with you.
Right.
But if they're going to get that information,
Listen, seriously. You got to stop. I got the answer I needed, sir. Thank you. Okay, because it wasn't helpful.
Okay. All right, further questions from the committee? We have a couple people. All right, thank you both very much. Thank you. Tanika Richardson, LaWanda Williams. So Tanika's in the Zoom room, yes? No. Okay. So, and then Nicole Earl. Miss Earl. Say what? Oh, yeah, sorry. My bad. All right, and then Tanika's not in the Zoom room. Okay, Miss Williams.
Good afternoon, Chair and members of the committee, and thank you to Senator Love for supporting this bill. My name is LaWanda Williams, and I'm a licensed clinical social worker, and I work at Healthcare for the Homeless as their Chief Behavioral Health Officer. I'm here today in strong support of Senate Bill 335. Every day I work with people who are experiencing homelessness and housing instability, and I want to be really, really clear that finding safe and affordable housing in Maryland is extremely difficult. Even when people have incomes and housing vouchers and disability benefits, they still really face overwhelming barriers. People are working, they're getting SSI benefits, they're using rental assistance and vouchers, and they're doing everything that they can do to build and rebuild their lives, but yet they're still denied housing, not because they can't pay the rent, but because of these screening practices. And some landlords I've found in my experience impose some income requirements like earning 2.5, 3 times the amount of rent. And these policies are routinely used to shut people out who rely on SSI and these housing vouchers, even though these are steady and legitimate sources of support. I work with clients who have been turned away the moment they mention having a voucher or a rental subsidy. Others are required to pay repeated application fees, even when the landlord doesn't really have an intention to rent to them. Some of them are asked for extra documentation. I've personally been asked to provide character references for clients even before they actually step foot in the complex to even apply, just when they know that they've been associated with our program. And credit is another major barrier. So poor credit is often not a sign of irresponsibility, but it becomes an issue for folks because of things like medical debt and domestic violence and identity theft and financial exploitation, to be quite honest. And a lot of these crises leave really lasting scars for people, and far too often people are punished for years, blocked from housing and stability. So I urge a favorable report for Senate Bill 335. Thank you.
Thank you very much, Ms. Williams. Questions from the committee? All right, thank you very much. That'll conclude the testimony from the proponents of the bill. We'll now switch to the opposition panel. And I have Mr. Greenfield, Mr. Castelli, Mr. Anlou.
Committee, Aaron Greenfield here on behalf of the Maryland Multi-Housing Association in opposition to Senate Bill 335. You heard a lot from the proponents. I think it's important to underscore that the PHA does not provide that material to landlords. And if we were talking about 100% vouchers and they provided the information, that might be a different conversation, but that's not the case. Housing providers use screening tools, credit history, and income verification not to exclude applicants arbitrarily, but to assess basic risk and ensure stable communities. These tools help determine whether an applicant is likely to pay rent on time and respect the rights of other residents to quiet enjoyment. Removing or restricting this information forces providers to make leasing decisions with incomplete data, increasing the likelihood of non-payment, evictions, property damage, and disputes. When risk increases, costs follow. Providers may face higher legal expenses and FTPRs, increased turnover, more staff time devoted to enforcement rather than resident services, and greater financial instability. These costs do not disappear. They are often passed along through higher rents, fees, or deposits, making housing less affordable overall at a time when we're facing a very severe affordability crisis in the housing market. Importantly, limiting these screening tools do not eliminate risk. It shifts how providers manage it. Faced with uncertainty, many providers will respond by tightening other criteria, such as requiring higher income ratios, co-signers, or longer employment histories. This means fewer housing options and higher barriers to entry, especially for lower income applicants. Maryland already has a strong fair housing and consumer protection laws that prohibit discrimination and ensure screening criteria are applied consistently. For these reasons, we respectfully request an unfavorable report on Senate Bill 335.
Good afternoon, Mr. Chairman, members of the committee. Brian Anlou on behalf of the Apartment and Office Building Association of Metro Washington. I wanted to address two things that you heard from some of the proponents. The first is that rental history is a more accurate indicator of a tenant's likelihood to pay rent on time. However, the General Assembly passed a bill a few years ago that restricts a landlord's ability to look at rental history in cases that do not result in an eviction or where the tenant uses their right of redemption. And those records are then shielded. And we agree that you should not be using those records to screen tenants. However, that's part of, as you heard, indicative of whether the tenant's likely to pay their rent on time versus credit scores. The second thing the committee heard is that the bill is modeled after DC, but there are a few key differences from how the housing subsidy programs work in DC versus specifically Montgomery and Prince George's County, which is the county that my members represent or are in. The first is that DC, because they have rent control citywide, they divide up the city into submarkets and they issue vouchers on a property by property basis. And so the landlord, when the tenant is applying, the prospective tenant is applying, they don't even know how much the voucher amount is for. They have to call the Department of Housing, and the Department of Housing has to give them a number. And so therefore, it's possible to determine when the voucher was issued or when the prospective tenant began receiving the subsidy. In Montgomery County, specifically, the vouchers are issued, according to bedroom size, number of occupants, those kinds of things. And so it's not always possible to determine when the subsidy began. And to Chairman Smith's point about credit history and comparing those adverse actions, it's not always possible to determine, okay, here's when the cutoff line began. And so with that, we respectfully urge an unfavorable report on this bill. Thank you.
Good afternoon, Mr. Chair and committee members. My name is Michael Cerrito. I'm a real estate broker in Upper Marlboro. And for those that have just testified in the other direction, I represent single-family landlords, not multifamily, single-family, mostly mom-and-pop owners. I'm a landlord myself, and I represent many of them. And we are real people also. We keep referring to the tenants being real people. Small landlords are real people also. Retirees that require this income, military who are PCS'd overseas. So they're real people as well. Third-party screening. I've heard a whole lot about credit scoring. You were referring, I think, to my testimony. The third-party screening was actually introduced in response to HUD to provide a screening score that does more than just credit. It looks at several credit history, criminal activity, eviction history, income verification, and it creates a score that you can look at so that you can make a determination. Most landlords I know pick a score, and that's the score that you have to either get or above to get in, and there's no variation. Most of these third-party companies are actually part of the three major credit bureaus or subsidiaries of them. So these scores, it's not an AI-generated thing. It's a mathematically based research tied to factors that are beyond just credit. And I actually do have the Hemlane's 2025 Insights on Tenants' Credit Scores, everyone should know, which clearly states that credit scores alone, or the third-party credit scoring, that's rental credit scoring, like Rent Spree, like CoreLogic, My Rental, have much more relevance than just the ability to pay rent. I'll leave you with this. These third-party companies, they are the only objective way for small landlords to make a decision. If you take away scoring, then you're faced with a landlord trying to look at a plethora of information on each individual case.
Thank you very much.
Thank you.
Thank you.
Thank you, Mr. Chair, members of the committee, Bill Castelli on behalf of the Maryland Realtors, and I will be very short. I think one of the points we want to underscore is that we are trying to find objective measures that we can use from tenant to tenant to tenant. And so that's one of the reasons why you might look at a credit score. It's one of the reasons why we look at the tenant report, so that we are using the same measure when we are looking at different tenants. But the other underlying point I want to make is it's not just tenant or voucher holders who are having difficulty finding housing. You've heard it today from both sides that we do have a significant housing shortage. And so when someone is looking for an affordable rental unit, and those are the most difficult to find depending on what your income is, whether you have a voucher or not, you are going to have difficulty. You're probably going to be applying for that with many other tenants. When a property manager like Mr. Cerrito is looking at tenants, his job is not to find a tenant, is to find the best tenant. Not just because it's good for the property owner, but they want to make sure that that tenant has success in that property and can afford it long term. If they can, if they're right at the edge, that's what leads to housing instability for them. So for those reasons, we do oppose the bill. Thanks.
Thank you, Mr. Chair. I've got a question for Mr. Greenfield. I'm looking at the bill. I'd like to read the exact language of the bill. So in this case, the relevant provision says a landlord that uses financial information as part of a prospective tenant's rental application may not refuse to rent to a prospective tenant who pays rent with the assistance of an income-based housing subsidy on the basis of the prospective tenant's income. So when I first read that, I figured, okay, the housing subsidy would cover the rent. But then based on testimony I've heard earlier today, I've now been corrected. The housing subsidy will not necessarily, and in fact, in most cases, will not pay all of the rent. So there's rent remaining that the tenant's going to have to cover from his independent income. Plus, we're talking about utilities and other expenses, which the tenant will have to incur. So as I read this, the landlord is not permitted to refuse to rent to a tenant based on the prospective tenant's income. Is that how you, in other words, the landlord cannot consider the tenant's income when trying to figure out whether the tenant's going to be able to pay the rest of the rent as well as all these other things?
No,
I think how you read this?
Yeah, that's how I read it. I think you hit it on the head. The reality is the majority of vouchers are not 100% vouchers. So the prospective resident has to come up with some portion of that. And we should have the ability to vet that and make sure they can meet that obligation in addition to other obligations, whether it's renter's insurance, utilities. I understand that PHAs also include utilities, but those costs need to be factored in, and you should allow the property owner to be able to vet that information. But yes, I read it the same way.
Okay, now, since you do read it that way, if this bill passes, what will the landlords have to do in order to make sure that the tenants that they're renting to will be able to afford to pay the rent and everything else, and will not default 2 or 3 months into the rental period, forcing an eviction case and all the unpleasantness that we've gone through over the years in various bills before this committee?
Well, that's the major concern behind this bill. And the reality is, without being very careful because of source of income discrimination, we don't want to violate the source of income discrimination, but it is likely that that providers will respond by tightening other criteria in order to qualify prospective residents.
Next question. Last year, at my request, you prepared a list of the bills that we've passed that have, I think it's fair to say, have hurt landlords over my 8 years on this committee. And we already talked about Montgomery County and the fact that multifamily housing is not being built in Montgomery County except in Gaithersburg and Rockville. You represent the Multifamily Housing Association, which is primarily in the greater Baltimore area.
That's correct.
Could you give us some insight as to how much multifamily housing these days is being built in the greater Baltimore area after 8 years of passing anti-landlord bills down here?
Yeah, it's a good question. I'll have to get back to you on the specific data, but anecdotally, folks are looking at Northern Virginia. We just had a briefing over in the House, and they're not looking at Maryland to invest, to build. whether it's because of BEPS, whether it's because of higher filing fee rates, all of these, it's a death by 1,000 cuts. And so it's all of these factors that are dissuading folks from building in Maryland where we need rental housing.
Thank you.
And following up on Senator West, I need clarification on the second part of B. It's got 1 and 2. After I read, the gentleman who represents mom and pop landlords, and he explains that there are these other, I don't know what they're called, apps, tools, whatever they are, that are not just a credit score, but they have a credit score in them. How do you all read the language of the bill? You can't rely on the prospective tenant's credit score or lack of credit score with the which was what's in this gentleman's testimony about a multitude of tools that have credit scores in them, as I understand it, and a multitude of other factors. How do you read them? Would you read this language to say, to the extent it's partially relying on those credit scores, it could be suspect? In other words, this language is very ambiguous. Would you look at it like these new tools are outside the scope of this law? And if that's the case, is it possible this law will do very little since the tools have left the building and they do far more than just rely on one small FICO score, but a global analysis?
Yeah, Mr. Streeter may have a better
he might, and that's
response
fine.
on that
Yes.
than myself.
Were you paying attention? No, I'm just kidding.
Yes, I was paying
Okay, I'm just kidding. Sorry, it's late.
So the way I read this bill and the way that the sponsors define a credit score is we would no longer be able to use these third-party apps because they create a score.
Right.
It's not, and it's a
That's
score
true.
that's based on many, many different things.
And we don't have a definition of tenant's credit score in here or lack
And
thereof.
so you're
Okay.
hanging landlords out to dry that could normally say, I'll accept anybody with a 620 or better credit score. How do they vet that?
And interesting that the bill's drafters or proponents don't think it applies, but I tend to think it's
It
ambiguous
absolutely
at the
applies.
least and probably does apply at the worst.
Yes.
All right, thank you, Mr. Chairman.
Thank you, Mr. Chair. And to the last gentleman who spoke and to that, to Senator James's question, I'm sure we can come up with some language because I don't know if you were here during the sponsor panel, but we certainly all said loud and clear that those would be allowed. So I'm happy to work with you on some additional language. Isn't that so? But the question I have for you, Aaron, wouldn't you agree that a landlord requiring a multiple of the full rent amount for a prospective tenant who has a voucher is just wrong? Let's put it out that way.
If I understand you correctly, Senator, I don't think so. I think we need all potential. We're extending credit essentially, right? It's housing, but it's credit. And we need all tools to ensure that this person, this applicant, is not a serious risk and isn't, go ahead.
I didn't want to interrupt you, so thanks for stopping. So even though there is a guaranteed substantial portion of that rent, you think that it's okay to require the tenant, who by definition is low income because they have that subsidy, to have an income that can cover multiples of the entire rent?
Oh,
Doesn't
I
that
see what you're saying. I see what you're saying.
undermine the entire purpose of
and
a housing subsidy?
No, I see what you're saying. Let me pull that back then.
Okay.
No, I think we should only qualify, if I understand you correctly, I think we should only qualify for the amount that the tenant has to come up with.
Okay. So if we were to sit down and talk through some language that would enable that portion, would you be okay with the legislation? And the broader, not just the straight-out credit score, but the broader apps or whatever they are that take into account some of the things that we have said multiple times through the sponsor panel we think are acceptable.
I mean, of course, we're willing to have those discussions with you. I think there are, additional problems with the bill in terms of, the points that Senator West raised. But we're happy to have those discussions with you.
Okay. And then my final question, and that may be answered just through our colloquy a moment ago, but you talked originally about, pretty much the sky falling if we do this. But isn't it true, and didn't we hear earlier, that voucher holders are some of the most reliable, consistent tenants?
We have members that love voucher holders because it is a consistent stream, but we want to make sure that they're going to be able to pay their portion of the rent. And that's what's so critical.
And I think we're going to talk about that.
Okay, great.
Great, thank you. Thank you, Mr. Chair.
Further questions from the committee? All right, seeing none, thank you all very much. And with that, that will conclude the hearing for Senate Bill 335. We'll now move on to Senate Bill 432. Senator Love.
Thank you, Mr. Chair. May I bring up my panel? Thank you. Okay. Good afternoon, Mr. Chair, members of JPR. Senator Sarah Love here to present SB 432, and I think I got the bill number right this time. Under the Maryland Constitution, the Maryland Attorney General has certain enumerated responsibilities, including investigating, commencing, prosecuting, or defending cases as specified by this body, the Maryland General Assembly, or that the governor directs be undertaken. And over time, this body has granted the Attorney General additional authority. In 2017, we passed the Maryland Defense Act, authorizing the Attorney General to sue the federal government based on its action or inaction that threatens the public interest and the welfare of our residents with respect to protecting our health, safeguarding public safety and security, protecting civil liberties, and more. In 2024, we passed the Port Act, requiring the Attorney General to sue to recover economic damages arising from the closure of the port and the collapse of the Francis Scott Key Bridge. Last year, we passed the Protect Our Federal Workers Act, again extending the Attorney General's authority to sue the federal government with respect to protecting our federal workers who are not being paid, who were part of the massive firing of federal workers, or who were inappropriately denied benefits that they had earned. SB 432 would again extend the Attorney General's authority for much-needed protections in Maryland. It would allow the Attorney General to pursue actions against certain fossil fuel entities for tortious or unlawful conduct that has contributed to adverse climate impacts in Maryland through fraud, deception, or other action or inaction or practice. So what am I talking about? Since 1968, the coal, oil, and gas industries knew their actions would have devastating impacts on the planet. The Stanford Research Institute presented a report to the American Petroleum Institute warning that, quote, the release of carbon dioxide from burning fossil fuels could carry an array of harmful consequences for the planet. And they go on to say, there seems to be no doubt that the potential damage to our environment could be severe. In 1981, ExxonMobil's in-house climate expert warned the company of the connection between fossil fuels and climate change. Yet ExxonMobil spent $30 million over the next 20 years on think tanks and researchers that promoted climate change denial. If either one of those entities had shared this information with the public and began transitioning to clear air initiatives, taxpayers, we the people of Maryland, would not be paying the consequences of their disinformation today. Maryland taxpayers are now saddled with increased costs in our state budget and our county budgets out of our own pockets. And I encourage you to read the comptroller's study that she put in with her letter of information. And I'll just cite two things. quote, a conservative cost estimate of what it will take to safeguard businesses, homes, roads, and entire communities in Maryland from chronic flooding alone. That's chronic flooding alone, not including other adverse climate impacts. By 2040, under a moderate sea level rise scenario, is $27.4 billion. Second point, Maryland has experienced 85 extreme weather events between 1980 and 2024. According to the National Oceanic Atmospheric Administration, the total recovery costs for Maryland for those were between $10 billion and $20 billion alone. And this isn't all. To fully account for the true cost of climate change, it's crucial to not only consider the immediate impacts, such as disaster cleanup from extreme weather, but also the broader compounding economic pressures it creates. Climate-related hazards drive up the cost of materials, strain public resources, deplete natural resource, inflate housing crisis, and on and on. Workforce disruption, agricultural losses, tourism decline, et cetera, et cetera. We, the taxpayers, should not have to bear the burden of paying for these costs, which will only increase as global temperature rises. Just as the tobacco companies and opioid manufacturers have had to bear responsibility for their deception and actions, so too should the fossil fuel companies. Maryland's Attorney General must have the authority to hold these polluters responsible for their actions and make them pay their fair share so that taxpayers do not. And finally, as I mentioned, I encourage all of you to look at the comptroller's report that she had submitted, and also to hear the voice of the next generation and read the testimony from Mr. Kenny Love Fabrizio. With those, I respectfully request a favorable report on SB 432.
Good afternoon. Thank you very much for this opportunity. William Piermate here, Managing Director of the Environmental Law Program at the University of Maryland, Carey School of Law. I'm testifying in my personal capacity as my views may not represent the law school. This bill instructs the Attorney General to investigate whether the fossil fuel industry violated Maryland law, and if so, empowers the Attorney General to bring civil or criminal cases against the violators. This is an important bill for three reasons. First, the bill gets to the truth. Did the fossil fuel industry violate Maryland law to sell more of their products? If so, the Attorney General must be empowered to bring this case given the damages climate change will cause in Maryland. Second, an Attorney General investigation will get to the truth much faster. This statute falls squarely within Maryland's constitutional police powers and will give the Attorney General the leading legal authority in Maryland answerable to the public, the ability to go forward and get to the truth. Third, this legislature began the session commissioning a climate change cost study. One important step along the road to the truth. Once we know the costs, this investigation becomes part of the plan to address them. The comptroller study that was mentioned, billions of dollars in the future. We already know this. The Annapolis Dock Project, $80 million. Ellicott City Flood Prevention, $130 million. Just in May 2025, Allegheny County flood, $15 million. And the comptroller noted that for every dollar spent in prevention and resiliency saves $13 in damages. We need the truth to plan better for the future, which should include looking at the fossil fuel industry that made trillions in profits creating this climate crisis. Failure to do so puts the financial burden of climate change solely on Maryland citizens and this state's budget. I ask for a favorable review and look forward to your questions. Thank you.
Mr. Chairman, members of the committee, thank you very much for the opportunity to testify. My name is Jamie DeMarco. On behalf of the Chesapeake Climate Action Network and our members in the state, I urge a favorable report on SB 432. As you heard from the sponsor, this legislation gives the Attorney General of Maryland the authority he needs to, if he finds necessary, bring a lawsuit against the fossil fuel companies for illegal actions that they have taken. This is a very standard practice now in the United States. There are more than a dozen states, plus the District of Columbia, that have brought lawsuits against fossil fuel companies on behalf of their state. There are jurisdictions within Maryland, including Anne Arundel County, Baltimore City, and Annapolis itself, who have all brought similar lawsuits, each with a slightly different theory of the case. When we live in a law-based society, and if a company breaks the law, it is only right and just that the state have the right to determine whether they broke the law in our opinion and to bring a suit to represent ourselves and to prosecute for them for that alleged violation of the law. That is the purpose of this legislation, and we think it is really important and has the potential to bring billions of dollars into the state that are owed to us by damages and libelous action, deceptive action taken by the fossil fuel company. Thank you very much, and we urge a favorable report.
Good afternoon, Chair and members of the committee. My name is Dr. Murner. I'm a lead scientist at the Union of Concerned Scientists, where I work at the intersection of climate science and law. I'm here today in support of Senate Bill 432. This bill matters because it recognizes that the climate crisis was not solely a result of unseen consequences. It's been significantly worsened by decades of deceptive conduct by the fossil fuel industry. As documented in Decades of Deceit, a report I co-authored, major fossil fuel companies understood the risks of climate change from their own products as early as the 1950s, with growing certainty through the 70s and 80s. For example, as the senator mentioned, in 1968, the fossil fuel industry's largest trade association commissioned a scientific report warning that the consequences of fossil fuel use would lead to significant temperature changes that are almost certain to occur by the year 2000. That was in 1968, and that warning was delivered directly to industry leadership. But instead of sharing that information with the public or changing course, company executives chose to protect their business interests. Internally, their scientists accurately projected rising temperatures, sea level rises, and widespread harm. Externally, those same companies funded campaigns to cast doubt on climate science, delay policy action, and to tell the public that the risks were uncertain or far off. This deception includes coordinated disinformation campaigns, the use of front groups to manufacture doubt, greenwashing strategies that executives knew were misleading, and efforts to discredit or intimidate researchers. These are deliberate choices sustained over decades that helped lock in today's climate damages. Senate Bill 432 affirms that deceptive conduct contributing to climate harms warrants accountability and gives the state the tools to respond. I respectfully urge a favorable report. Thank you for your time.
Good afternoon, members of the committee. My name is Julie Kuspa, and I serve as an Assistant Attorney General. Thank you for the opportunity to testify today. I'm here on behalf of the Office of the Attorney General regarding SB 432. We support the intent of this legislation, which seeks to authorize the Attorney General to investigate, commence, and prosecute or defend any suit or action that holds certain entities accountable for tortious or otherwise unlawful conduct that has contributed to climate change. Climate change is one of the most pressing and destructive challenges facing our planet today. This bill would empower the Attorney General to take legal action against companies whose activities continue to endanger public health and the environment. However, the Office of the Attorney General recommends an amendment. The amendment would modify the Uniform Contribution Among Joint Tortfeasors Act exemption on page 6, lines 5 through 11, to any action brought by the Attorney General arising from or relating to injuries or threatened injuries to the environment or natural resources of the state. Maryland law currently presents serious impediments to the settlement of any case brought against a large number of defendants who are jointly responsible for an injury because it fails to account for the percentage of culpability of each defendant. Currently, if the Attorney General settles a claim against one of several defendants, the state's ability to collect against the remaining non-settling defendants is reduced by an equivalent share based on the total number of defendants in the case, regardless of fault. Thus, it is very difficult to settle with smaller, less culpable defendants and multi-defendant actions without the state giving up a large percentage of its total potential recovery. The practical impact of this is that it has been to complicate, delay, and potentially foreclose settlements in these multi-defendant environmental actions. This amendment will make Maryland law more consistent with federal law and the laws of many other states in the country by ensuring that defendants are responsible for their fair share of harm. We have shared proposed amendment language language with the bill sponsor, and are available to work with the committee on refining this legislation. With these amendments, the Office of the Attorney General respectfully urges this committee to give SB 432 a favorable report.
All right, thank you very much. Thank you, Senator, and thank you to the panel. Ms. Cuspa, like, we should, for you, the UCATA piece, I remember this. I have like vivid memories of this when the bridge fell down. That's a huge policy choice, but I think we should, I would like your expertise in helping the committee understanding that. I mean, we can talk more offline, but, you know, I would like to get some folks together to understand the implications of changing UCATA. So we could take that offline, but I want to make sure we have an opportunity to take a deep dive. But that's a significant policy, very significant policy choice. So I just want to make sure that everyone's just kind of well-versed in understanding that. Yes. And then maybe there's like, this is also even bigger, but like Maryland is one of only, I think, 3 or 4 attorneys general that don't have common law power. This is why you're coming here to ask for statutory power to do this. I want to have that conversation. I know that's going to upset a lot of folks in the room here, but I think we should learn more about what that looks like. But Senator West.
Thank you, Mr. Chair. I agree with you about the Uniform Joint Tortfeasor Act. We cut a deal on Sonny Died, I think it was 2 years ago, just after the bridge collapsed, and the deal was we would let the Attorney General have a special version of the act applicable, but only to claims relating to the bridge collapse. He wanted a special version applicable across the board, and I think we agreed at the time that we'd come back later and revisit that greater request. Were you involved in that?
Yes, sir.
Yes, and I had my partner
Yes.
from Semsbone and Sems. The 4 of us sat there and work together.
Yes,
so
I'm
I
happy
agree
to
with
do
you.
that again.
It would be a good idea to have a conversation
Absolutely.
about this. But my main question is, and it's going to be brief, is for the sponsor of the bill. So China has over 1,100 coal power plants, and it provides over half the world's coal-fired power in China, coming out of China. So 57% of the world's coal-fired comes out of China. Does your bill enable the Attorney General to sue Chinese companies?
Well, the bill is very clear about who would be affected. And it says, a publicly traded entity, including its subsidiaries, with a cumulative market capitalization greater than $1 billion at the time a suit or action is filed that is or was, et cetera, et cetera.
Yeah, I'm not aware that Chinese companies are publicly traded. Are you?
I don't know the answer to that. So, but that who is affected. But to take that one step further, Senator, the Attorney General would have to prove not only that this company falls into what is specified in the bill, that they fall under the bill, but also that they committed a tortious act, and that act led to these adverse outcomes. So it's not just, you know, he can sue anybody for anything, and there's no nexus. There have to be very specific things that he would have to prove in order to prevail in a lawsuit.
Well, who knows whether Chinese companies have engaged in tortious acts? I suspect the law of China is significantly different than the law of the United States in that regard. What about other countries in the world? The United States is not the only country other than China that produces electricity using fossil fuels. Would your bill enable the Attorney General to sue companies in South America, Europe, Africa, the other Asian nations? Or is it just directed at American companies?
The same answer applies. If they fall under the criteria that are laid out in the bill, and there is, you know, the nexus that the Attorney General can prove, then they would be subject to it.
You would agree with me that global warming is not just produced by activity in the United States, it's produced by activity in China and other countries around the world, as well as in the United States.
I would agree with you, but this bill is focused on Maryland deceptive activities that have had a direct impact on Maryland that we, the Maryland taxpayers, are paying for.
the bill seems to be focused on global warming generically, which collectively impacts Maryland. So wouldn't you agree with me that Chinese companies that generate electricity using fossil fuels by burning coal have just as much an impact on global warming of the globe as companies here in the United States?
I think Mr. DeMarco wants to jump in. I'll let him.
Thank you very much for the question, Senator. It's a very good question. Where we've seen lawsuits like these be brought in other states, they do exactly what they're talking about, where the damages that are due to climate change, they take a portion of that is proportional to the amount of emissions that the companies being sued are responsible for. So if climate change has caused $10 trillion and the companies that are defendants in the lawsuits are responsible for 20% of global emissions, then they would be sued for $2 trillion because that is their proportion of the global damage. So exactly what you're saying is exactly right, and the lawsuits are sure to account for that in who they are bringing the lawsuits against.
Okay, thank you for your answers.
Additional questions from the committee? All right, seeing none, thank you very much. Thank you all. Thanks. And Julie, we'll be in touch. We'll give you a okay, so. All right, we'll also have Ms. Randolph, who's signed up in favor, and then we have Fabrizio, Kenny Fabrizio, who's joining us virtually. He's in class. Yeah. He's in class, all right. Study on. Where's that? Jennifer. Oh, Jennifer Mizrahi. Welcome.
Good afternoon, Chair Smith and members of the committee. My name is Nika Duckett Randolph, and I am the resident environmentalist at Out for Justice, a member-based grassroots organization dedicated to engaging, educating, and empowering communities to build power to dismantle harmful systems of oppression. I want to speak to you today about equity. Specifically, who bears the burdens of climate pollution in Maryland and who benefits from polluters avoiding accountability. Right now, the costs of pollution fall hardest on communities that are already overburdened and underserved. In Baltimore's infamous Black Butterfly, decades of intentional environmental degradation and disinvestment have left Black neighborhoods exposed to multiple intersecting health risks, from asthma and heat stress to legacy lead exposure, blight, and flooding. Even as childhood lead poisoning has declined due to strong prevention laws, lead hazards remain a serious concern in older housing stock, with no amount of lead being safe for children and contributing to lifelong health and public safety concerns. Baltimore also experiences some of the worst asthma hospitalization rates in the nation, with elevated rates tied to air pollution and climate-linked factors like heat and precipitation that exacerbate respiratory conditions. Extreme weather events are no longer rare. Flooding and nuisance-tied events are increasing, threatening public safety and damaging infrastructure and imposing costs on families and local governments that had no role in causing climate change. These harms to health, safety, housing, and economic stability are not evenly distributed. They disproportionately affect Black Marylanders, low-income residents, children, and older adults who lack the resources to recover on their own. That is fundamentally inequitable. Senate Bill 432 helps correct that imbalance. It gives the Attorney General the authority to pursue actions against entities whose misconduct has contributed to climate pollution and establishes a climate crimes accountability fund, so that the costs of climate change, of climate damage, are borne by the polluters, not the people least able to afford them. Equity means not just acknowledging harm, but ensuring justice. This bill shifts the responsibility back to those who profited from pollution and away from the families and communities who have endured its consequences. For these reasons, Out for Justice urges a favorable report on SB 432. Thank you.
Hello, Mr. Chair and committee. I'm very delighted to be here. I'm Jennifer Laszlo Mizrahi. I am a climate philanthropist, and I serve on the Maryland Climate Change Commission and also on the commission for Brooke Learman, who issued the report on how much climate is costing us. I want to speak as somebody who grew up in rural North Carolina in the #1 tobacco growing district in America. My father was a cancer doctor. We watched as Liggett & Myers and other tobacco companies gave their employees free cigarettes and told people there was no harm from tobacco. My father was one of the doctors who figured out and testified that tobacco kills people, and also there were people who figured out that they did it intentionally. This law that is being proposed by Senator Love and by Delegate Ruth is very, very similar. It's from around the same time when corporations were really looking for profits over people, and they intentionally had deception, which has caused people to die. The amount of money involved is massive. Eventually, we won the tobacco lawsuits. The whole world is better for it. But it was also $246 billion. $246 billion. Our state needs money, and it should not be on the backs of our citizens and our residents here. It needs to be on the people who did the harm. So I really encourage everyone to give a favorable thing to this bill, and also for the amendment from the Attorney General, who I've gotten to speak with about the UCATA changes. These are very important things that can help our state. I'm happy to answer any questions. Thank you very much.
All right, thank you very much. Questions from the committee? All right, seeing none, thank you. Thank you. All right, that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. Mr. Wiggins. Are you the only one? The Lone Ranger.
Yeah. Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce. We submitted written testimony which outlines 8 specific concerns with the legislation. In the interest of brevity, I'm going to highlight 3 here today. First, looking at the bill language itself, it is exceptionally broad. You're establishing liability due to a mechanism, action, inaction, or practice that has contributed to climate change. How you would go about quantifying what has and has not contributed, and then assess the impact that a specific action had, I'm unsure, given, to Senator West's point, the consistent impact that foreign corporations and foreign countries have had on climate change as well. Second, from a timing perspective, we don't feel that the bill is ripe. We just passed the Renew Act. That report is due December 1st, 2026. So I think if we were going to pass legislation, we should wait until that report comes back. 3, pending litigation. So as was mentioned, there have been cases filed. My understanding is that the Annapolis City, the Anne Arundel County, and the Baltimore City cases are currently pending before the Maryland Supreme Court. I know that the Baltimore City case was dismissed, and in doing so, the judge there cited federal preemption and a statute of limitations issue. And in that case, the judge noted, and I'm going to read this because this is from Justice Ruth Bader Ginsburg. And she says, cases such as these are inappropriate under state law because there are questions of national or international policy. And we would echo Justice Ginsburg's concerns there in opposing the bill. And then I would also just note, again, restate that we have the written testimony, which has additional concerns delineated within it. Thank you, Mr. Chair. Thank you.
I'm back.
For Senate Bill 432, we'll now move on to Senate Bill 433, Senator Love's final bill of the day.
My final bill, and then you're done with me for today. For today. Sorry. Okay. Mr. Chair, Mr. Vice Chair, members of JPR, for my final bill of the day, Senator Sarah Love, here to present SB 433. SB 433 addresses 2 parts of the protective order statute, timing and relief. First, it moves the time between a temporary protective order and a final protective order from 7 days to 14 days. Second, it provides financial relief to the petitioner for expenses that they had to incur as a direct result of the abuse. So first, the timing. Right now, our law provides that when someone goes in for a temporary protective order, a hearing for the final protective order is automatically set for 7 days later. That 7-day period is too short. During that time period, a victim often has to find a safe place to live. They have to ensure care for their children. They have to get medical care. They have to get an attorney. Having to do all of those things within 7 days is extremely difficult, especially when you are juggling a job and childcare. As you will hear from those who have direct experience handling these cases, it's difficult in that short period of time for the petitioner to get an attorney. 14 days would give the petitioner time to get an attorney and for them to have time to prepare. It also allows respondents time to be served and to get an attorney to appear at that final protective order hearing. And it would also give law enforcement time to ensure that service is made before that final protective order hearing. Beyond the harm it causes and the unfair impact it has on victims, 7 days between the temporary protective order and the final protective order is far below best practices and national standard. Maryland is only one of 2 states that has such a low period, a period below 10 days. Wyoming is the only other state. So moving on to the second part of the bill provides that a final protective order may include ordering the respondent to pay for losses or expenses incurred as a direct result of the abuse. Think about the broken tooth that the petitioner had when he hit her so hard she slammed on the floor, or the broken cell phone when he threw it across the room. Right now, the victim has to pay for those things, and that's not fair, and it's not right. The cost should be borne by the one who caused it. I saw the judiciary's concern, and there are members of this panel who will address that directly, but to suffice it to say that other states and areas have this provision, and it's not a problem. So for these reasons, I respectfully request a favorable report on SB 433. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Laurie Ruth. I'm the Public Policy Director at the Maryland Network at Domestic Violence. No, I'm not. The Maryland Network Against Domestic Violence. Pardon me. Been sitting there silent for so long. I also want to, we are obviously here in support of this bill and urge a favorable report. I also want to let you know that the House of Ruth supports this bill. They're undergoing some transition and don't have people who can come down and testify right now, but they authorized me to say that, as well as MLAW, the Maryland Legislative Agenda for Women. It is a priority bill of theirs. I want to thank Senator Love, Senator Henson, and Senator Muse for being co-sponsors, and Senator Love for being the lead sponsor on this bill. And you are going to hear from a lot of people who do this work every day about why these things matter, but I just wanted to tell you about the genesis of the bill. I was at a Partners for Justice conference last May. It is put on by the Pro Bono Resources Center. It's the only conference for legal service providers in the entire state, and it's a day when you really hear from that community of which many of us are a part. I was on a panel about domestic violence, and we had been talking at them for a long time, so when it got to be my time, there were about 50 lawyers and advocates in the room who work with domestic violence victims and survivors. And I said, look, let's just open it up to you all for a minute. If you could change anything in our protective order law, what would help your clients the most? And these were by far the 2 requests that we got, especially the timing between the temporary and the final protective order. It's just really difficult when you've been traumatized, possibly physically, mentally, and otherwise, to focus on all the things that you have to do, as Senator Love said. And so allowing that time, and it has these peripheral benefits of letting law enforcement have more time to serve and letting the respondent perhaps more time to find a lawyer as well. I will let other people go into detail about it, but I urge a favorable report. And somebody's also going to talk about the judiciary's opposition, which I would call making a mountain out of a molehill. So thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. I am Jody Kavanaugh. I'm the Legal Services Director for the Sexual Assault Legal Institute, and I'm here to add our voice to support of this bill. I want to just emphasize 2 things that I think have already been emphasized, but I want to say this is a very practical, important change for practitioners and petitioners. It reflects what often happens in court anyway. Oftentimes, the first 7 days, it's not enough time for attorneys to prepare for court or to negotiate settlements or effectuate service. And it's also, it's not enough time for petitioners to connect with our attorneys at Sally. Sometimes, like just today, I placed a case with an attorney that's coming in on Thursday, and today's Tuesday. So we understand that changing to 14 days makes sense for survivors. The second part of the bill would add reimbursement for financial loss incurred by the petitioner due to the Respondents Act. We understand that some expenses occur later, but this bill would clarify that the financial award does not preclude a claimant from a future tort or other recovery. For those reasons, and I don't want to be duplicative, I know my colleagues will also have things to say, but for those reasons, we ask for a favorable report on this bill. Thank you.
Good afternoon, Mr. Vice Chair, Mr. Taylor, esteemed members of the Judicial Proceedings Committee. My name is Katie O'Malley, and I'm the Executive Director at the Women's Law Center of Maryland. Prior to that, for 22 years, I was a member of the Maryland Judiciary in the District Court of Maryland, served for Baltimore City. This is a common sense bill. As already stated by Senator Love and the sponsors, there is not enough time to get from the first hearing, the temporary, to the 7 days for many people to get prepared for the hearing. Oftentimes, it's not enough time for law enforcement to do service. So there's many times there's an extension well beyond that 7 days to 14 days to 20, up to 6 months for the service issue. I have the statistics here that I can share with you if you have any questions about it, but I'll just tell you in FY25, the Judiciary's annual report for the hearings from the temporary order hearing to the first final protective order hearing, out of 52,000 temporary order hearings held, 25,000 of those were postponed. So that was in FY25. In FY24, it was 52,000 were held and 25,000 then were then postponed for another date. When it gets to the monetary issue, I think the opposition that you'll see from the judiciary, I think they're just a little excited. I don't think that this issue is going to be so, I mean, they're saying that they don't have enough time, that their dockets are too heavy. And that's just probably for some jurisdictions like Baltimore City, Baltimore County, Prince George's, because I've looked and I've had the numbers also for all around the state. Most of these cases, they are not very long hearings, but they definitely would have time if there's already evidence at the hearing that there's been abuse that's caused some type of monetary loss. The petitioner can then produce a receipt to show that loss or paperwork from the hospital, anything that can be produced there. And it really isn't a heavy lift. So I'm going to defer to my other colleagues and I'll be available for questions.
Good afternoon. Thank you for the opportunity to testify. My name is Sarah Tenen, and I am the Executive Director of Volunteer Legal Advocates. Our organization, among other things, provides pro bono representation to survivors of domestic violence in civil protective hearings in Montgomery County. I'm here today to urge the committee to issue a favorable report on SB 433. The bill makes two important changes to Maryland's protective order law. My testimony focuses on extending the time between a temporary protective order and the final order hearing from 7 to 14 days. Right now, survivors are expected to move from crisis to trial ready in just 1 week. Based on our experience working with survivors in both Washington, D.C. and Maryland, that timeline is simply too short. It often undermines survivor safety and access to justice. 14 days is consistent with D.C. and still far shorter than timelines in other states. There are multiple reasons we support extending the timeline. Additional time allows survivors to stabilize after a temporary order is issued. The days immediately following a TPO are chaotic and overwhelming as survivors navigate housing, childcare, and other urgent needs. Extending the timeline reduces the pressure to navigate a complex court process while still in acute crisis. More time significantly improves access to legal representation. Survivors often face financial, logistical, and emotional barriers to securing counsel. 14 days makes it far more likely survivors can connect with pro bono attorneys and arrive better prepared. Additional time also allows for more meaningful case preparation, particularly with clients of limited English proficiency. This is especially critical for volunteer-based legal programs like ours, which rely on adequate preparation to serve survivors effectively. Extending this timeline promotes trauma-informed proceedings, greater court efficiency, and ultimately clearer records for more durable protective orders. Thank you for your consideration.
Thank you, Mr. Chairman. Thank you to the bill sponsor. I appreciate you bringing this bill. I did this work for many years. When I was an attorney right out of law school, I worked for the YWCA for Anne Arundel County, and so I represented survivors of domestic violence in their peace and protective order hearings. So understanding that it's a short amount of time, because when you're proving your grounds for relief, you have to make that proof through the criminal code, because oftentimes those grounds are defined by the criminal code. So that's what you're looking at to put together the evidence to prove whether it's an assault or whatever those grounds. And then when you're trying to prove your relief, a lot of times that's defined by the family law code. So then you have to, figure out, what do I get this person to order their life and to put it back together? So you're trying to gather that evidence and figure out what's appropriate to make your arguments to the court. So extending it to the 14 days certainly gives you more time to prepare for a trial. But if I can, I want to ask a question about what I know we're going to hear in terms of the other side of the argument, and I would love to make sure the record is clear in its full. What people are probably going to ask us is, because I say us because I'm a co-sponsor on this bill, is that for the person who's on the other side of this, if you're the person who is the respondent in this order, one of the grounds for relief is that the petitioner can have you removed from your home. You are out of the house because they could get use and possession of the home on the temporary order. If you're the respondent, they could get custody of the children on a temporary order. An order where you have no contact with them. You could have no contact with your children as well. So if we extend this from 7 days to 14 days to double the time in between, how are we reconciling that with this person not having had the opportunity to be at that temporary hearing, not having the opportunity to be heard, and now having it go from 7 days to 14 days before they get that day in court?
Practitioner Sarah, do you want to take that as the practitioner?
Thank you for your question. I think on balance, I hear the concern, and I would say on balance, something has to give. And so the balance of keeping safety for the victim is obviously the primary importance. And in terms of removal from the home, it's only once an order is actually served. So that often doesn't even happen before you hit that 7th-day mark, which is why oftentimes, as other individuals have stated up here, those cases end up still being continued beyond that. And there are sometimes in temporary orders where custody is not included as a form of relief. It is an available form of relief, but it's not always a guaranteed part of an order. I think it's a valid concern, but again, on balance, it's something that we see often in DC, and the courts there move forward with temporary orders on a 14-day, lasting for 14 days.
Okay. Going through your testimony, I expected to see favorable support from the sheriffs, because we hear, I don't know if they've weighed in, but we hear so often from them that with more time, they could be a better partner in serving, and that more time is something that they're looking for. Have you had conversations with them about how an additional 7 days would impact their work in serving these orders?
Thank you so much for that question, Senator, because we have heard that as well, and that falls on me, that I did not reach out to the Montgomery County Sheriff's Office, and I know that there were attempts by the House sponsor to do that, but that falls on me 100% for not reaching out to them.
But you're hearing the same thing I'm hearing?
I am hearing the same thing that you're hearing, yes.
Okay. And then the judiciary's concerns about the monetary relief being included. I will tell you, as a practitioner of the law, it's similar in our landlord-tenant statute, you can seek a money judgment in a landlord-tenant case. But there are judges who will say on the record that because you don't have the benefit of a full evidentiary hearing in a landlord-tenant failure to pay rent case, even though you can seek that, they just routinely will not grant it because you don't have the benefit of discovery, you don't have the benefit to have all the tools you have in a civil case there. So they won't grant it even though you can check the box, you can personally serve, and you can seek it as relief, they just won't do it. So looking at the judiciary's testimony about expanding the protective order statute for monetary relief, what do you think about what it is that they've said there in their thinking that it's misaligned with the spirit of the protective order statute?
So I would say, based on the conversations, and the practitioners can answer this, and we'll hear more from the second panel about that piece specifically, but that where it is in practice, it is not that difficult. So you don't have to have a full-blown evidentiary hearing to do that. It's at the final protective order, so the respondent is there with an attorney, and they can challenge it if they want to. But the petitioner can be there, you know, with the broken glasses or the broken tooth and the bill, and can testify that that is a direct result of what happened. But the respondent is there with their attorney and can challenge it if they want to.
Thank you. Thank you, Mr. Chair.
Thank you, Mr. Chair. Thank you for the bill. I find that with this bill, I'm at least partially in favor of it.
Okay.
So,
I'll take partially favorable as opposed to completely unfavorable.
yeah, the 14 days, it's within the discretion of the court. So it's not a mandatory 14 days. And if the court decides it should be as short as 4 days, the court could say this is a 4-day temporary restraining order, and you have to come back in 4 days and let's hear the full case. Because many of these TROs are ex parte. So you're not requiring the judge to wait 14 days until the contested hearing. Isn't that so?
Katie, you want to answer that? No, I believe what the bill says, and with the temporary protective order, it is, most 99% of them are ex parte, but there's sometimes, because of interims, there are sometimes respondents at a temporary. But right now, the way the law is set is that the temporary is held, and then 7 days later, the final protective order is set.
Well, actually, the law seems to say the temporary protective order should be effective for not more than 7 days.
So the
judge could set the next hearing for less than 7 days.
But they don't.
Okay,
I mean, there's no way to get service generally for that. That's the main problem as it is now. Having it set out just 1 week is not enough time for law enforcement to get them served. So that's why over 50%, and even before COVID in Baltimore City, 70% of the orders were not even served. So the bill is saying that the final protective order would be set 14 days out.
Well, again, it says for not more than 14 days. So the judge would have the option of setting it for 7 days.
If there was good
or 8
cause,
days, or 10
perhaps.
days.
I don't see that happening in practice. I think I have seen sometimes judges, after the temporary is issued at the first final protective order hearing, when the respondent hasn't been served, I've seen them setting it out 2 weeks later to give law enforcement that additional time, or if they believe that the respondent's incarcerated somewhere. So I do see them changing it to some extent, but it is generally temporary to the first hearing. The first final would be 7 days.
Okay. Let me go to the second part of the bill, which I do have some problems with.
Okay.
I was taken by the testimony of the judiciary, and let me just read you the relevant portion of that. It said, protective order proceedings are designed to occur quickly, given the emergent need for safety and protection. Unlike in civil actions, there's insufficient time to engage in discovery, and no discovery is afforded to the parties. Parties do not have the opportunity to obtain estimates, repair bills, or treatment provider bills and records. Neither does the opposing party have the opportunity to review same. Without evidence and a meaningful opportunity to review that evidence, the bill's relief may be illusory. I note that somewhere in here it says, oh, here it is. The current statute balances the emergent nature of the proceeding with the financial concerns of persons eligible for relief by providing for emergency family maintenance. An award of emergency family maintenance allows a court to enter child or spousal support to directly benefit the person eligible for relief and their children. So under the current statute, a court can order emergency relief, but this bill seems to contemplate that the court is going to enter a more permanent award of damages, a more comprehensive award of damages. It says for any losses or expenses incurred as a direct result of the abuse, which could have been going on for years, including medical costs, dental costs, or mental health treatment costs. Don't you think that the defendant in the case deserves the opportunity to find out what those costs are, to cross-examine the doctors who were going to testify, to hire his or her own experts, to disagree with the experts? This sounds like an almost not quite ex parte, but certainly a peremptory proceeding with no opportunity for discovery if we pass this bill.
So first of all, doctors aren't going to come in and testify, even in, in civil cases. They get.
Then how can a court award damages for
So if you give me a
medical
second.
expenses with no testimony?
No, we would make, the judge would have to hear evidence. And then
Well,
certainly
what kind of
also
evidence?
the
If there are
court.
no doctors,
You would
what
have to have
evidence?
medical report. You would have to have perhaps photographs. You would have to have a receipt from what you had to pay for, determining on what if it smashed the cell phone and then you were able to show a photograph of the phone. There was testimony that the abuser respondent caused that damage. You have the petitioner bring in the receipt for that bill and present that to the judge and let the judge decide.
But then the abuser in 14 days has no chance to. I'm sorry, were you done?
No, of course not. I certainly was not.
Keep going.
So again, the nexus to safety is really what the issue is, and I think that's what the judiciary was upset about. They were saying, well, wait a minute, we're diverging from the intent of this statute is to protect people, but when you don't have a cell phone, or when your door's been smashed in, or when your car has been disabled, or when you're unable to go to work because of some damage to your property, your uniform, or your tooth has been taken out, that loss of income can also have a safety component to it. And so that's what the bill is asking, that the court consider this. It's not mandating that there be a hearing, but that the court can consider it. Right now, the statute allows for any additional relief. So in the bottom of I think the last page of the protective order, final protective order, it says the court can award any other additional relief that is necessary or sought. So that could be asking for your passport to be brought back. Or you could have said, and some petitioners have, hey, my cell phone was smashed, Judge. Will you please have the the respondent reimburse me for that cost? They don't generally won't do that. Judges won't diverge into that. So I think this is a very good way for them to then have the tool to use, just like emergency family maintenance. They don't always do emergency family maintenance. Sometimes judges say, go file in the circuit court. I don't have time for this. This is a divorce in custody and we're here just for a protective order. But you have all created in the protective order statute emergency family maintenance so that a petitioner can seek custodial costs, for the care of their children, can seek perhaps, limited to, because of course all of that is then going to get relitigated if they have a divorce and custody hearing in the circuit court. But it grants the district court the ability to do that. And this mirrors that, but in a different way. Again, it's not emergency family maintenance. It's making them whole again after this abuse. Again, it has to be related to the abuse that the judge has heard has occurred and has found by a preponderance of the evidence that the respondent has caused that abuse and has caused that loss of the property, whatever again it is. We've seen broken doors, broken windows, cars being disabled, tires being slashed. We've seen, medical bills. And so making that petitioner then go file another civil proceeding, I think is not right. And then again, if the court is saying, I want to give this respondent extra time to get, to prepare for this, they can hold that hearing like they sometimes do with emergency family maintenance. They'll grant the protective order. They'll reset it another week if they don't feel like that the respondent's had enough time. So it's not saying it has to be done right there and then, but it gives the tool to the judiciary. It gives the tool to the petitioner to seek that relief.
Are you finished?
Yes.
Okay. I'm frankly surprised that you as a judge don't see the concern. This bill empowers a judge after 14 days with the defendant having had no opportunity for discovery at all to award damages for what may have been years of abuse and mental health treatment costs. And the defendant has no opportunity in advance of the hearing to find out what the costs are, whether the costs are real, what kind of treatment was obtained, whether the amount of money charged for the treatment was fair and reasonable. You see, as a judge, you seem to think that it's not reasonable for the defendant to have that opportunity for fair and due process in the courts to defend himself?
Are you finished?
Yes, I'm finished.
Thanks. Well, as a former judge and as someone who certainly believes in due process, I think that this bill does allow notice because they will get served, and there could be some amendments that require, if someone is going to seek monetary, not restitution, but reimbursement for any damages to their property, that be delineated perhaps in the petition. That might be some favorable amendment that could be added. But I do think that the judge at the time of the hearing, if they do think that there's been ample time, that the judge can allow for, like in emergency family maintenance, can allow for a separate hearing on the issue if it's that complicated. Again, I think some of these issues are not years and years of abuse. We're talking about someone coming in and saying, hey, at the end of the hearing where the judge has found by a preponderance of the evidence that the abuser has caused a damaged cell phone, has kicked in a door or broken a window, here's the receipt for it. Would you please grant that in the award in this as one of the remedies that the petitioner is seeking? So it doesn't have to be years and years of abuse and or mental health therapy treatment. That again would be a little bit more detailed, and I would imagine that in that instance, if there was an amendment that allowed for in the petition, because they all get served the petition, the respondents get served the copy of the temporary and the petition to show what exactly is being alleged, that they have that opportunity. Now, granted, when it's only 7 days and they get served that like the 4th day and the hearing's 2 days later, that's not enough time. I agree, and that's why we're asking that these temporaries be set out 14 days rather than the 7 days, because the respondents aren't served generally until way after the 7 days. But even if they were served between the first hearing and the 7th day, they've generally been served a day or two before the hearing, and they don't have enough time to really prepare, to get an attorney. So that's obviously the other component of the bill. But I think it all works.
Thank you for your answers.
Senator James. Thank you. I just want to follow, because I got a little lost in this. Can you tell me whether or not in the law anywhere a judge can follow the suggested language on damage awards outside of the temporary awards that are permitted for what we've already mentioned, family maintenance? Are there other areas in the law where a judge, without any of the discovery, any safeguards, can just, and without the defendant having any ability to properly respond, could give permanent damage relief to a litigant? If you don't know, that's fine, but I just want to know if there's another example.
Senator James, thank you for the question. Sure. I think the reason we put the last provision in the bill was in conversations with all the people who work is to allow a further action by the petitioner against the respondent. If it's not going to get taken care of, for example, in family court, they can file a tort action or damages action.
Another example. I'm not asking for why you did. Just first, I'm just trying to. Yeah. I can ask you why after, but first I need an example. I'm trying to
answer yes. There are other ways to do it. So
Are there other exampms of allowing a court to give a permanent award of damages to a litigant without discovery?
Restitution in criminal cases certainly, which happens frequently.
So and the defendant has no opportunity to do discovery or.
I mean, I don't practice criminal law, but not generally, no. They're ordered to, they've been found guilty. They've been found of, extorting $200 million, and they're told to pay it back in restitution. And that's.
But they had a court case or a settlement, right? And then.
I mean.
If you have a criminal case, you're found guilty, and then you're ordered to pay restitution. Right. Okay.
Yeah, so that's an example. There may be other areas of law, but I don't really practice in many other areas of law.
Right. So. Just so I understand, currently can a litigant under these temporary to permanent restraining orders request It's filing fees, court costs, and reasonable attorney's fees.
Generally, no, but we didn't want to preclude it because there is a possibility. We hypothesized, that I present the receipt for the broken cell phone, which is a very frequent occurrence in domestic violence, and it's, $800 to get a new cell phone, and then he doesn't comply, and I have to file contempt and get him to pay that. The court could award the attorney's fees for my attorney to have to file that supplemental contempt. So we wanted that in there to make sure that if there was an opportunity for attorney's fees to be awarded, that it was explicitly allowed under the law.
Well, that was my question. I'm not sure that's clear. It doesn't sound like it's just related to an enforcement action, which we would require more language here. So that's your intent. I think that would require more language. And then I was going to say, I don't want the public record to be unclear about the fact that even if a court were to order something in this context, there is then whether or not the defendant pays it and whether there has to be enforcement proceedings, and they can go on for a considerable amount of time. I don't want anybody to come about the
Yes, sadly, there's a lot of contempt in protective order cases.
Just make the record clear. I don't want anybody to misinterpret this bill as if after 14 days a court will issue an order against a defendant permanently to require him to pay, and that the defendant will be paying immediately whatever the judgment is, or whatever you would call this relief.
No, and I also just wanted to clarify something for Senator West while I'm here, which is, this is why I said I think the judiciary is making a mountain out of a molehill. First of all, a lot of other states do this, including the District of Columbia, and you're going to hear from another witness about that. And it is not a huge discovery or due process issue. I'm already testifying. My husband, slapped me across the face. He took the phone, threw it against the wall. It's broken. I had to get a new one for childcare reasons, for this and that. And here's the receipt. So they've already heard the factual testimony, and then I present a receipt for the bill. It's not for the 20 years of therapy that I was in before this incident happened. It's not for some sort of, it's for costs that occurred at the time of the abusive event that led to the issuance of the temporary and then final protective order.
Well, so it is limited. Answering the question, because let me just say, I don't see that. I like that clarifying language. I just don't see any of that explanation in the bill. It is not so limited.
I mean, we are absolutely happy to take a look at the language and tighten it up if there's some way. We looked at a lot of other states, red and blue, all over the country that do this, and it is designed after, I don't remember anymore what state, and it might have been a combination of a few, and you will hear from Ms. Swanson, this does happen elsewhere with no moment.
And just so everyone else can follow up, you were not able to answer definitively one way or the other. So if anybody else understands my question, I'm just trying to find out if we have anything in Maryland that mirrors this kind of relief right here. 14 days, no opportunity for discovery, a permanent judgment against the defendant. I don't want an analogy to criminal law after a criminal trial and restitution.
So in a civil matter, we can find the answer out for you if nobody on the panel knows. I understand what you're asking now. Thank you.
Now you do. Okay, thank you.
Excellent. Thank you very much. All right. See no further questions for this panel. Thank you all very much. Thank you, Senator. We now hear from Robin Swanson.
Can I interrupt? Somebody just answered a question for me.
Okay.
Who's not signed up to testify. In small claims court, up to $5,000 with no discovery, a court can order somebody to pay the money. Civil small claims court. And I'm happy to follow up further, but I was interested to hear that.
Let's go ahead and follow up further on that. Thank you very much. Yes. All right. Sophia Barlone, and then Amanda Rodriguez. And is Ms. Jordan here? And then Mr. Madden, and then Laura Wilt, also joining us virtually, but let's go ahead.
Good afternoon. My name is Robin Swanson, and I'm a managing attorney at Volunteer Legal Advocates. As our executive director, Sarah Tenen, just testified, among other things, our organization provides pro bono representation to survivors of domestic violence in civil protective order cases in Montgomery County. We strongly support SB 433, which would clarify that a final protective order may require an abuser to reimburse the survivor for losses or expenses resulting from the abuse. Although the current law includes a broad catch-all provision that arguably already allows for this kind of relief, reimbursement is almost never awarded in practice. We had a client whose glasses and car window were broken during an assault. We requested reimbursement from the respondent for the repairs as part of her civil protective order case under that catch-all provision, arguing that being able to see and having transportation was essential to ensuring the client's safety. The court denied the request and told the client to pursue restitution in a related criminal case where the respondent had been charged with malicious destruction of property. Now, we don't know whether that client was ever awarded restitution, but we do know that some of her crucial immediate needs were not met via the civil protective order process. According to the Administrative Office of the Courts, of the 801 protective orders granted statewide in Maryland in January 2026, only 3 included orders for other costs beyond emergency family maintenance. So that's less than half of 1%. Plainly, survivors in Maryland are routinely denied timely access to funds that they urgently need for safety and stability. SB 433 would clearly enumerate the types of monetary relief available in these cases. This clarity makes survivors more likely to request reimbursement and courts more likely to grant it. It would allow survivors to replace broken phones, repair damage, or address other immediate needs without waiting months for a divorce hearing, pursuing restitution in a criminal case, or filing a separate small claims case, delays that are especially harmful for low-income survivors. For these reasons, Volunteer Legal Advocates urges a favorable report on SB 433. Thank you.
Mr. Chair, members of the committee, my name is Amanda Rodriguez. I am the CEO of Turnaround, which is the comprehensive domestic violence provider, designated rape crisis center, and human trafficking service provider for Greater Baltimore. I'm also the co-chair of the Legislative Committee of the Maryland Human Trafficking Task Force, which was created in 2008. It's a collaborative group of law enforcement, victim service agencies, government agencies, and survivor leaders across the state that have supported thousands of victims of human trafficking. At Turnaround, I just wanted to highlight one particular client that would have benefited from this bill. This client was sexually abused by her father for multiple years. Shortly after her 18th birthday, she got up the courage to leave her home without shoes on and walk to the local police station to try to get help. We received the referral the next day. We immediately went to work. In addition to having to secure emergency housing, addressing her emergent medical and mental health needs, we finally filed a protective order. The respondent in the order was both her father, but then also multiple family members who threatened to injure her if she were to talk about the abuse to anyone else. As a result, in most cases of protective orders that we file, her safety was our first priority, so we needed to file immediately. We went to work attempting to locate an attorney to handle the final protective order, and with only a week worth of time, it was impossible to find anyone to assist after calling 5 different legal providers. As a result, I ended up having to represent her myself. Most of the time, survivors don't even get to us until that week has already started to expire after they file a temporary protective order. 7 days is simply too short for a survivor to access legal support, especially as in the case of most instances, there are immediate safety concerns. Additionally, in this client's case, she had no monetary support whatsoever and would not have been eligible for the family relief that you've mentioned or heard mentioned in previous testimony. She did have immediate medical needs because she was hospitalized during part of those 7 days between the temporary and final protective order. So she was trying to navigate her young life without any financial support whatsoever. Based on this and the hundreds of survivors who Turnaround supports and getting protective orders every year, we urge a favorable report. Thank you.
I'm back up. Brendan Madden for the Family Law Section Council of the MSBA. And I won't repeat most of the, the testimony you've already heard. The MSBA largely agrees with the other advocates' positions. From the perspective of the timeline extension, I can report that many of our members, and we have heard as a section and as the section council, that this 7 days is often too short. I mean, I myself have gone in after 7 days, and you have to request an extension because if you accept a case, you might not have enough time to prepare it. We've heard from some attorneys that they just have a policy, they don't accept protective order cases because they don't have enough time, and that affects both petitioners and that affects respondents. So there is a balance, yes, of, well, is a respondent now going to be under this TPO for an additional 7 days? Yes, but it's balanced with they have a greater ability now to seek out counsel to prepare for a hearing. And it's an appropriate balance, in our opinion. As to the financial piece, we agree with the other advocates that it's a narrow remedy. It's not intended to be this, broad sweeping, you get a $25,000 award relief. It's a direct result of the abuse is what the language of the bill says. That is going to be the standard, a direct result. And we trust the courts to be able to discern what that means and apply it appropriately, and to apply the appropriate standards when you're in a hearing, with the restrictions of a protective order. And with most of these being in the district court, I'll just note that if there's some issue that a respondent has, they have an automatic right of appeal to the circuit court to seek further and different relief. So for that reason, we would urge a favorable report.
All right, excellent. We're going to go to our panelists who are now joining us virtually. We'll start off with Sophia Barlone. Welcome.
Thank you, Chair. Thank you, Chair and members of the committee. My name is Sophia Barlone, and I'm the Deputy Director for Victims' Rights at Maryland Legal Aid. There are two critical issues that this bill fixes. So, number one, in practice, the 7 days is simply not enough time. 7 days is rarely sufficient for either party to secure legal counsel, gather evidence, locate witnesses, or prepare for trial. It is often not enough time to even arrange for childcare, get off work, or reschedule essential appointments. Maryland's 7-day temporary protective order period is unrealistic, and it's out of step with the rest of the country. About 40 states provide at least 10 days, at least 10, and 31 states provide 14 days or more. Maryland Legal Aid created a chart outlining all the states and timeframes, which is attached to the written testimony. Maryland and Wyoming are the only two states in this country that has less than 10 days. This bill gives both parties a fair opportunity to prepare and promote safer and more just outcomes. Secondly, this bill addresses the financial harm caused by domestic violence. Maryland Legal Aid attorneys routinely see abusers destroy phones, damage homes/tires, and force survivors to miss work or incur moving or therapy costs. Despite this, Maryland law currently does not provide a mechanism for the court to order the abusers to compensate victims for those losses within a protective order. This bill will fix that and will fill that gap by allowing courts to order reimbursement for abuse-related expenses, relief that many other states already allow. When survivors are forced to absorb the financial fallout of their abuse, the system reinforces their victimization. SB 433 promotes accountability, stability, and justice by ensuring that those who cause harm bear its cost. So for these reasons, we strongly urge the favorable report of SB 433. Thank you.
Excellent. Thank you very much. All right, Ms. Wilt, you're up. Welcome.
All right. Good afternoon. Thank you, Chair. Laura Wilt, I'm senior attorney in Baltimore City for the Maryland Crime Victims Resource Center. Thank you for listening to all the very valuable testimony. Honestly, I'm not going to repeat because you've heard so much valuable information today. Regarding the time frame, I would ask you just to look at that data that Maryland is out of step. You've heard testimony from so many different victims groups today that makes it very clear that the victims need this time frame to prepare for a legitimate court proceeding. And I think that goes both ways. For those of you thinking of the responding party and their ability to prepare is important as well. They need time to get counsel. People need time to get their documents together and to prepare for their future separate. One point I would bring up based on previous questions that were asked is, I could hear somebody saying, oh, well, the court can just postpone this. Courts are doing it all over the state. Apparently, they'll just postpone. I would ask you to consider the hardship on these families. Every time that victim misses work, she is afraid she is going to lose her job. To struggle to get daycare, every time she misses and has to come into court is a tremendous stress. And us lawyers, we're in court all the time. We don't think anything of that postponement, but it means a lot to these families. And I believe, as I think it was Senator West pointed out, the court doesn't have to do 14 days. They can grant the number of days they think appropriate. But I would ask for your support for this bill. And if you have concerns, we ask for your support on behalf of victims to come up with limiting language regarding the finances that will allow you to support victims and this legislation. Thank you.
All right, thank you very much. Senator Love, did you have a question? Senator James.
I just want to clarify something. My understanding is small claims court generally don't go to trial for 30, 60, or 90 days. Does that ring true to you? And do they go to trial within 15 days? If you're going to say you know nothing about small claims
court, so if anyone else knows, but
I just looked it up, and the answer is yes. But, and the other thing, I don't know, can you appeal a final protective order? And the reason I ask is that if you cannot, or if there's some different track, I wonder how that dovetails with the potential damage award and whether that can be appealed or not. But I don't know if anybody has anticipated that how would that work under this bill?
So final protective order in district court can be appealed immediately to circuit court, and it's de novo in the appeal. So you basically start over. So let's say that there was an order of, covering the cell phone. The respondent could appeal that order. It would be heard de novo in circuit court.
Sorry to interrupt.
No, it's okay.
I just want to ask you, I get the immediate appeal. Some of these, I know the answer. I understand the immediate appeal to a final restraining order, right?
Correct.
But money damages is a very different animal. But from the viewpoint of the drafters of the bill, they would put them together and treat them. So this would be interesting. This would be a damage award that could be immediately appealed and be de novo. Is that correct?
If it's connected to the protective order, any provision within the protective order can go to circuit court for a de novo appeal.
Okay, so that's how you all understand this bill as being drafted. So that could be immediately appealed and a completely new de novo. If you had a de novo hearing, then you could come in and bring
all
additional,
over again.
Right, with
We do it all the
evidence
time.
and everything.
Yeah.
Interesting.
Senator, I also wanted to mention restitution because I think that came up a little bit. I was a criminal prosecutor, handled restitution cases a lot.
Yeah.
And so in those instances, yes, you do get to a guilty finding and then restitution can be ordered.
Right.
In many of cases where I had restitution, if it was a simple restitution like handing over a receipt because of a cell phone being broken, some medical damages that needed to be covered, it was handled right then and there, and the judge would immediately issue it without extra discovery time related to the restitution. However,
I totally get that, but it's after a trial.
Correct.
Okay, so that's, I just want to make sure we're clear on that. I understand you can have a restitution order.
And in these instances, you would also have a hearing already on the preponderance of the evidence related to the abuse. So you'd have essentially the same as you would in circuit court, just the evidentiary standard would be lower in terms of having to prove the abuse happened.
Yeah, well, I wasn't asking about that, but thank you.
All right, seeing no further questions from the committee, thank you all very much. With that, that'll conclude the hearing for Senate Bill 433. We'll now move on to Senate Bill 346.
Thank you, Mr. Chairman. Well, members of the committee, let's start with a thought experiment. In July, our country will have its 250th anniversary. That's a quarter of a millennium. It's a remarkable achievement. In those 250 years, what is the most important statute that the U.S. Congress has ever passed? And so I'm talking about statutes only, not constitutional amendments like freeing the slaves. What is the most important regular law that's ever been memorialized in the U.S. Code? Most folks' minds will gravitate towards the Civil Rights Act of 1964. Martin Luther King fought for it, freedom riders died for it, and in the wake of the murder of John F. Kennedy, Lyndon Johnson cajoled his former colleagues and signed it into law. It's codified at 14 U.S.C. 1983. So when folks talk about civil rights law, sometimes you'll hear them refer to it as the 1983 law. That's a reference to the section of code, not the year 1983. The Civil Rights Act was a historic achievement by any measure, but it's also a product of its time. In the 1960s, it was state electeds and state officials who were sicking dogs on peaceful protesters and standing in schoolhouse doors. And so when the Civil Rights Act was written, it only applied to state officials. In other words, the Civil Rights Act, 42 U.S.C. 1983, allows Maryland residents to file suit in federal court to uphold their constitutional rights, but only against state officials, not federal officials. Now, here we are in 2026, and the converse problem is occurring. Federal officials are allegedly violating the constitutional rights of Maryland residents. They are entering homes without warrants and detaining citizens without probable cause. Unless you think this is a criticism only from the left, let's be clear. The president and federal law enforcement officials have repeatedly said that it is unlawful to bring a registered firearm to a protest, an act that is clearly protected by the Second Amendment to the Constitution. But because these violations are occurring under federal, not state officials, there are no remedies for these clear violations. In 1987, a young law professor theorized that a solution to this problem was not only possible, it was necessary and constitutional. 40 years later, his work is being vindicated as multiple states are taking up this issue. The solution is the bill that you have before you, the No Kings Act. What does SB 346 do? It's short and straightforward. It simply closes the loophole created by the Civil Rights Act of 1964. It allows Maryland residents to use their own Maryland courts to vindicate their constitutional rights. That's it. That's all it does. There's a lot of talk about all the states that are passing this bill, but at its core is something very honest. It's a venue bill, and it provides a venue for your constituents and mine to uphold their rights when those rights have been wronged. Let me pivot now to some questions I've received about this bill. We all work hard to separate our life and hearing committee from our lives on social media, and that's a good thing. But I posted about this bill online, and I did get some serious questions, not just trolling. So let me address those questions. All right, here, only the serious ones. First, are you a leprechaun? I am not a leprechaun, thank you for asking. I had some Lucky Charms this morning for breakfast. All right, 2, does this bill abrogate qualified immunity for federal officials? The answer is no. Lines 15 through 17 on page 2 specifically retain qualified immunity. A lot of my friends on the left oppose qualified immunity, and I personally oppose it, but this isn't the appropriate bill to make such a radical change. This is a venue bill, not a policy bill. 3, why doesn't this bill apply to the Second Amendment? In fact, it does apply to the Second Amendment. There are no spare amendments. The Second Amendment is not a second-class right, which is why Maryland Shall Issue supports the bill in front of you. All constitutional rights are protected by this bill. So if the federal government decides to quarter soldiers in your home, you now have a venue with which to vindicate your Third Amendment rights. 4th question, doesn't this bill violate the Supremacy Clause? No. The Supremacy Clause is at its most operative when it is resolving conflicts between federal and state law. When there is such a conflict, the federal law is appropriate, and federal law is appropriate, the federal law must reign supreme. We don't question that at all, but here there is no federal law in conflict. In fact, we are filling a specific hole in federal law by providing Marylanders with converse rights to 1983 in order to fill that hole. This bill is for Maryland citizens who have their rights violated in Maryland. We provide venue for such remedies all the time, and it doesn't trigger Supremacy Clause issues. 5, doesn't this bill violate sovereign immunity? The answer is no. And the original law review article addresses this directly and at length, but let me boil it down to simple logic. Sovereign immunity may apply to certain limited tort actions, but it clearly doesn't apply to violations of constitutional rights. Why? Because if every official who violates the Constitution were immune to suits, then the entire Constitution would be useless. Why would the Founding Fathers and subsequent generations specifically write down these rights in our most sacrosanct document if they didn't believe there was a remedy to vindicate them? A sovereign immunity opposition to this bill leads to absurd outcomes and is a clear affront to the plain language of the Constitution and the memory of our Founding Fathers and the whole concept of originalism. So now you know what the bill does, you know what the bill does not do. So let's talk about the path forward. We have received some incredible feedback from many advocacy groups, left and right, as well as governmental offices, including the Attorney General, the Governor's Office, and the Judiciary. And here are some of the amendments that have come up that we should entertain. First, we should carve out the Judiciary by striking lines 12 through 14 on page 2. The Judiciary called me and indicated that the correct remedy for a constitutional violation by a judge is an immediate interlocutory appeal of that violation. That is, of course, correct. And with that amendment, the Judiciary will support the bill. 2, we wrote the bill to apply to both federal and state officials, even though the focus is exclusively on federal officials. We originally did this for the same reason that JPR did in the masking bill, which just passed. The Attorney General, in his letter, argues this idea creates unintended consequences and that the bill should only apply to federal officials. My discussions with the Governor's Office, which has explored the idea and supports the bill in concept, leads me to believe they hold the same view as the Attorney General. This is a close call, but the AG's letter is detailed, and I find it convincing. It also eliminates the fiscal note. I need to speak with the delegate with whom I cross-filed the bill, but I believe we may need to adopt the Attorney General's approach. So now you know the history of the idea, what the bill does, what the bill does not do, as well as the path forward via amendments. The only thing left for me to do is to introduce someone very special who will testify after me. I keep talking about this 1987 law review article from which this bill sprang. It was authored by Professor Akil Amar, who joins us here today. Professor Amar came down from New Haven to join us. Professor Amar is the most cited living law professor on the entire planet, and his background is refreshingly heterodox. A self-described liberal Democrat, Professor Amar is the nation's leading originalist, an idea traditionally identified with conservatism. He's in the area as jurists recognize the 10th anniversary of the passing of Justice Antonin Scalia, the originalist powerhouse of the Supreme Court. Professor Amar himself clerked for then Judge Stephen Breyer, who of course became the liberal lion of the same court. I'll ask our committee for a favorable report and ask you to welcome Professor Akil Amar.
Thank you very much, Mr. Vice Chair. And as Professor, as you take the podium, I want you to know that I did a sign of sovereignty and federalism to the entire committee to read before, in advance of your appearance here. Joke. But welcome.
My sympathies. It's a long piece. Thank you, Mr. Chair, Mr. Vice Chair. Thank you, members. I'm not a Maryland resident. I'm not a practicing lawyer. It's a great honor to be with you all. This is, I think, my first time here. Wow, what a beautiful complex you have. And by the way, thank you all for your public service. Even those of us not in your state are very grateful to you. We know you have many other options, and not everyone is appreciative of public service, but this witness is. Earlier today, I was giving a talk in DC for Habitat for Humanity, and had occasion, I got asked a question about Insurrection Act and I put up on the screen an image from, it's actually appeared in several of my books. It's when George Washington, in a place called Annapolis, actually surrendered his military commission. The Continental Congress had made him basically a dictator with all power, and the war was won. The Treaty of Peace with Britain was accomplished, and he was surrendering power. Jonathan Trumbull captured that moment very powerfully. The King of England had asked earlier, what was Washington going to do with his army? And he was told, oh, they say he's going to give it up. And the King of England, George III, is reputed to have said, if he does that, he'll be the greatest man in the world. And he did that, and he did that here. And this is my first time here, and so it's really an honor to be in such an historic place where the history of the world was changed when a commanding general who had the only army on the continent gave it up. Okay, and we have a tradition of civilian supremacy because of that. Today, there's an opportunity to affirm another idea that was dear to the founders. The idea is that states can play a role when the federal government acts unconstitutionally in the same way or in a similar way that the federal government can play a role when state governments act unconstitutionally. I'm just going to read you a passage. It's from the Federalist, number 28. If you read an earlier book of mine, it's dedicated to, among other people, Lynn Miranda. And I'm a Hamilton fan. This is written by Alexander Hamilton. And I just want to read you the quotation from the Federalist number 28. This is coming from an American revolutionary. Colonial governments stood up against Parliament. And that's in part what gives us the American Revolution. And Hamilton, who was a nationalist, who was saying state governments can do the same thing under the new Constitution that's being proposed when the federal government actually acts outrageously. I'll just read the quote and then I'll sit down, and I'm happy to answer questions that you have, and I'm happy going forward to be at your service as you work through the many technical complexities that will arise. This is the Federalist number 28, to repeat. Power being almost always the rival of power, this think of ambition checking ambition, the general government, what we call the federal government, will at all times stand ready to check the usurpations of the state governments, and these will have the same disposition toward the general government. The people, by throwing themselves into either scale, think balances, like checks and balances, will infallibly make it preponderate. So whoever the people in the end support, that's who's going to win. If their rights, that is the people's rights, are invaded by either government, they can make use of the other as the instrument of redress. It may safely be received, and I know I'm over, my apologies, as an axiom in our political system that the state governments will, in all possible contingencies, afford complete security against invasions of the public liberty by the national authority. Thank you.
Thank you very much, Professor. Thank you.
Thank you, Chair Smith, Vice Chair Waldstreicher, and distinguished members. My name is Jane Bentrott. I'm a counsel at Protect Democracy United. We encourage you to issue a favorable report on SB 346. This legislation stands for a simple proposition. If any governmental officer violates your clearly established constitutional rights, you should have a remedy. Under current law, Marylanders cannot sue federal officials like ICE or FBI agents for past harms. The No Kings Act solves that problem. This legislation is growing increasingly urgent. For our constitutional rights to have meaning, there should be a remedy available when they're violated. That's why it's so important that this bill is drafted to withstand federal judicial scrutiny. By treating equally all officers acting under color of law, creating a procedural cause of action solely for the deprivation of U.S. constitutional rights, and not upsetting defenses already enshrined in federal law, the bill is drafted to withstand judicial challenges. The recent killings of Renee Good and Alex Preddy in Minnesota demonstrate why this accountability is so necessary. Whether their families should have a remedy for their loss should turn on whether their rights were violated, not what badge the officers carried when they pulled the trigger. But the No Kings Act can protect Marylanders in many more contexts. If federal officers interfere with an election by unlawfully seizing ballots, if federal employees cut university funding to punish protected First Amendment speech, if federal law enforcement conduct warrantless searches, Marylanders will be able to sue federal officers personally, no matter their badge. So we respectfully ask that you issue a favorable report on SB 346 so that no officer is above the law and the U.S. Constitution remains the supreme law of the land. Thank you.
All right, thank you all very much. We'll take questions from the committee for this panel. We'll start off with Senator West.
Just a note to the professor. Since this is your first time at Annapolis, if you were to walk down the street to that lovely building with the big white dome and walk up the stairs to the front door, walk into the building and walk till you're directly under the dome, you will find a kiosk there. Inside that kiosk is the original speech that George Washington delivered, resigning his commission in his own handwriting. And what's really neat about it is at the end of the speech, in the original speech, it said, "I take my final leave of public service." And he struck out the word final. You will see it right there.
Wow.
So if you get a chance, do it before the day's over. I guess I should say, isn't it so? Now, I do have some questions for the sponsor of the bill. I found the bill hard to understand, so I need to have you explain it to me. It's called the No Kings Act. So I thought the bill was going to be about the President of the United States. But when I read it, it says, the critical language, an aggrieved party may bring an action against an individual. And then it goes on from there. So let me ask you, who is included in that term individual? Is the state of Maryland included? Under this bill, could a cause of action be brought against the state of Maryland?
So I do not believe so because of the use of the word an individual.
And how about the government of the United States? Could an action be brought against the United States under this bill?
Well, so this bill has antecedents in other states, and so I'm going to defer to counsel. I believe that you would sue the head of the agency as opposed to the United States because of the use of the word. And so you would be essentially suing the United States, but you wouldn't, the caption wouldn't read the United States. It would be that the individual whom you allege as plaintiff has violated your constitutional rights.
My next question was the governor of Maryland. Could a lawsuit be brought under this bill against the governor of Maryland?
So the answer to that question is yes. But as you heard earlier, there's some discussions based on the letter from the Attorney General, not an opinion as to the constitutionality of the bill, but a letter from his policy shop about whether and how we might apply this in different state versus federal contexts.
Okay, and it sounded to me from your original testimony as if you are disposed to introduce an amendment which would limit the effect of this bill and exclude state officials.
So the Attorney General is recommending that. I don't make any decisions without my cross-file, and we would have to explore the constitutionality of that change. But I am empathetic with what the Attorney General is advocating for.
Okay. So if you don't make the change, then under this bill, this would authorize lawsuits against the governor of Maryland, personally.
Now, just to be clear, Marylanders already have that right under current law, and so there's an argument that we are not expanding those state rights, but to the extent that the Attorney General believes that this would expand those rights, we should be cautious about that.
So I'm looking again at the bill. It says the aggrieved party may seek damages. There's no limit on the damages. So if you seek the kind of damages the President of the United States always seems to seek, it would be $1 billion of damages against the governor.
So this wouldn't abrogate the traditional limits we have on damages in the state of Maryland. We have limits in many contexts in Maryland. This wouldn't change that.
Well, we have limits for torts. We have the caps that we keep litigating here in this committee year after year. Yeah, we'll see that bill later on. But I'm not aware we have limits on how much damages could be awarded against the governor if you decide not to exclude the governor from the effect of this bill. Wouldn't you agree with that?
We can definitely explore that. And again, I can defer to counsel on how perhaps that is being handled in other states where this idea has been proposed.
And again, if you decide not to exclude state officials, that would mean that under this bill, lawsuits could be brought against the Attorney General, the Controller theoretically. I'm not sure how the Controller could violate constitutional rights. Each of us, in passing legislation, as this committee is well aware, I've stood on the floor of the Senate any number of times and said I believe this bill is unconstitutional. Certainly in the Second Amendment context, you're well familiar with the bills we've passed to restrict people's constitutional rights in the Second Amendment area. If you don't exclude state officials, would you agree that lawsuits could be brought against each of us if we vote in favor of bills which arguably were to restrict or impair one's constitutional rights?
That would not be the case. So
Why not?
Because there is a long list of case law, we are happy to provide it, where legislators cannot be held liable for the votes that they take and the policies that they implement. And so this would be for a direct violation of your constitutional rights, someone barging into your home without a warrant. This would not apply to us. If you wanted that clarified, we could make that clearer, but we have been in touch with attorneys, and it's very clear to us that that does not apply to legislators.
Now, the Maryland judiciary seemed to be of the opinion that this bill would apply to them, and they submitted a letter, a memorandum, pointing that out. I think you said in your original testimony you're prepared to strike references to judiciary.
That's correct. Lines
in lines 12 to 14.
Excuse me.
So would you also be willing to exclude the judiciary after using the word individual, to exclude Maryland judges?
If we need it, I don't think that's necessary once we're striking lines 12 through 14.
Well, I point out lines 23 to 25, in which the bill says a court may not award fees or costs under this section against a judicial officer.
You're exactly right. Yes, we would need to strike that as well.
Okay.
Yep.
Now, are we also going to exclude federal judges from the scope of this bill?
This bill is not intended to include federal judges. To the extent that we need to clarify, we should do that. I believe you could do that by striking the lines we just discussed, but if we needed to explicitly state that, we could.
Okay, let me keep going. Just a few more questions, if I could, Mr. Chair. I think these questions are relevant because the bill it's quite broad, and it's quite broad. So I think it's important we define the contours of the bill. The Maryland Association of Counties is concerned about attorneys' fees. Right now, attorneys' fees are not recoverable against counties, but it appears as if the county is alleged to have violated someone's constitutional rights, the plaintiff suing the county under this bill now would be able to recover attorney's fees if the plaintiff succeeded in establishing the plaintiff's case, correct?
Well, so if we moved in the direction of excluding state and local officials, that would be out. But just based on your question, it would only, in the bill, it's only upon finding. So you said if they allegedly did, they would have to have been found to have done something, which is the something here is a violation of constitutional rights. So philosophically, I believe the bill is appropriate. If someone violates your constitutional rights and you are forced to vindicate that right by bringing it to court, there should be fee shifting. But I don't think it's going to apply to MACO because I think we're likely to take them out of the bill.
So if you do exclude judges and state officials, then what this bill, and you say the U.S. government wouldn't be covered. So what this bill really would be limited to would be causes of action against federal officials, correct?
That's correct.
Okay. So are you familiar with the Supreme Court decision in 2022 entitled Egbert versus Boole? B-O-U-L-E.
I'm going to have to defer to the professor on this. He is shaking his head.
Nodding. He is familiar.
He's nodding his head, yes.
Great. You said you're not a lawyer.
I'm not.
Could I ask you some questions about the Supreme Court decision?
Of course, yes. Please come to the podium.
So,
at your service.
Thank you very much. You're from Yale.
I am.
Good for you.
Guilty as charged.
How many years have you been a professor at Yale?
40 years. I was hired at the age of 26. I'm one of the 2 youngest people ever hired at Yale, the other being Guido Calabresi, and I'm one of the 2 youngest people ever to get an endowed chair at Yale, the other being William Douglas. Wow. And I hold the Sterling Professorship of Yale, which is Yale's highest professorship.
And what area is the professorship in?
I'm a professor of law and political science at Yale, but I don't practice law. I don't take money.
Did you go to law school?
Yes.
Okay. So
I clerked for Stephen Breyer.
So, okay.
No, First Circuit clerkship. Then Judge Breyer wasn't on the Supreme
This will
Court
be
yet.
a privilege to ask you some questions about the Supreme Court.
And it's a privilege to be here, sir.
So I'm just going to read a couple of portions of this decision and ask you to explain how this bill would relate to them.
Sure.
So Justice Thomas, who wrote the majority opinion in a 6-3 decision,
Yes.
again, 2022, wrote,
restricting Bivens.
yes. So he talks about Bivens in his very first paragraph, and he says, in Bivens, this court authorized a damages action against federal officials for alleged violations of the Fourth Amendment.
Yes.
Over the past 42 years, however, we have declined 11 times to imply a similar cause of action for other alleged constitutional violations. Said, nevertheless, the Court of Appeals permitted not 1, but 2 constitutional damages actions to proceed. In this case, there is no limit to the constitutional claims which would be permitted under this particular bill, is there?
Indeed. Well, I haven't read this bill with great care, and apparently it's a work in progress, but the idea that I floated back in 1987, Converse 1983, is just the following idea. Congress hasn't given individuals remedies when federal officials violate the Constitution. Courts began to do that in the Bivens case in the 1970s.
And 2 succeeding cases.
Excuse me?
And 2 succeeding cases.
And since Bivens, the court has pulled back on its efforts to provide remedies against federal officials. And they've done so in part because of an anxiety of courts on their own creating causes of action and recognizing liability. So Bivens, even when I wrote in 1987, was there were concerns that it was being limited, and none of those concerns, Senator, applies when a state passes its own law. My friend Justice Thomas and others are worried about judges doing things on their own, and those concerns don't apply when the state of Maryland or any other state passes a law.
So Bivens was decided back in
72, 73, something like that.
73, when I was in law school. And then the 2 following cases were decided. The most recent case which sustained the idea of an implied cause of action was in 1980.
Exactly.
And in the past 46 years, the Supreme Court has never sustained another implied cause of action.
Exactly, which is why in 1987, I saw the handwriting on the wall, and I said, Bivens is probably not our way forward because the court, if anything, is showing a disinclination to expand it, and if anything, perhaps an inclination to contract it. That creates the gap, in the remedial gap.
Justice Thomas said that rather than dispense with Bivens altogether, we've emphasized that recognizing a cause of action under Bivens is, quote, a disfavored judicial activity.
So let's remember, Senator, what the world looked like before Bivens. The world before Bivens was a world in which state law was basically your key remedy when your federal Fourth Amendment rights were violated by federal officials. Here's what would happen before Bivens. And Bivens added to it and didn't eliminate the existing remedy, which isn't quite broad enough, but here's what you could do. You could sue a federal officer who came onto your property and you sue them in tort. You say, this is a trespass. And they said, I'm a federal officer. I can do this. And you would say, no, you can't because you violated the Fourth Amendment, because you acted unreasonably, because you didn't have perhaps a warrant where the Fourth Amendment doctrine would require you to have a warrant. So in fact, before Bivens, it was state tort law that enabled you to sue. Let's take a Fifth Amendment takings clause situation. A federal government official just grabs your property, your real estate, and tries to use it for a federal dam or a fort or a road. You would use state property law to say, hey, wait a minute, you can't just grab my land. That's a tort, that's a trespass. They would say, we're the federal government, we can do anything we want, and you would say in your reply, the plaintiff's complaint and then defendant's reply, and in your answer, you would say, defendant's answer, your reply, excuse me, you would say, no, you can't do anything you want because the Fifth Amendment of the Constitution requires you to have to pay just compensation. No private property shall be taken for public use without just compensation. So my article was saying we can go back to an earlier tradition before Bivens. Bivens didn't preempt any of those things, and given that Bivens is being limited, states need to go back to what they've done from the beginning, which is protect their citizens from federal violation. That was the Federalist 28 that I read.
Okay, well, instead of going back to pre-Bivens, let's continue to focus on Egbert versus Boole, which was only decided 4 years ago.
Yes.
So Justice Thomas, who chooses his words, I think all the Supreme Court justices, when they write their opinions, which are well vetted by the other 8 justices, choose their words carefully.
Indeed.
And what Justice Thomas said is, if there are sound reasons to think Congress, doesn't mention state governments, Congress might doubt the efficacy or necessity of a damages remedy, the courts must refrain from creating it. He goes on and says, even a single sound reason to defer to Congress, not state governments, is enough to require a court to refrain from creating such a remedy. Put another way, the most important question is who should decide whether to provide for a damages remedy, Congress or the courts? He never mentioned state governments. Now, it is your contention that under Bivens, the Supreme Court has authorized the state of Maryland to create these recipes?
It's my contention that my friend Clarence Thomas has cited me on multiple occasions for the proposition that state law, of course, can provide remedies. That's obvious. It wasn't relevant on the facts of Egbert versus Boole, but I wrote an article in 1994 in the Harvard Law Review. It's entitled Fourth Amendment, First Principles. I think it's been cited 8 times by the justices, many times by Justice Thomas, and it stands for the proposition, in fact, that the Fourth Amendment was designed to be enforced by damage suits, in fact, not by the exclusionary rule. And, in fact, you might be interested, if you're at all of an original sort, there's an important, I didn't bring all my documentation down here, but there's a piece by, yes, well, as am I. And this is my friend Justice Thomas. There's an essay by in the ratification of the Constitution is by a Maryland farmer, and you can find it on the Google right now. I'll give you the quotation. A Maryland farmer, and he says, if a federal constable enters a house and pulls down the shift of a bed, pulls down the clothes of a bed, we would say sheets, and searches a woman under her shift, trial by jury would be our safest resource, and heavy damages would deter the government official from doing this in the future. And that would have been state law. That would have been state tort law. So Egbert versus Boole was about a different issue. Should, as a matter of separation of powers, courts on their own, federal courts, act where Congress hasn't acted? But no one, not a single justice, actually, I think would have been remotely of the view that states can't act here, because they do all the time. That's state trespass law, state property law. That's the backdrop of our constitutional system, is state law.
Can you cite me a Supreme Court decision which held that a state could create a cause of action against federal officials for damages, for monetary damages against federal officials? Has the Supreme Court ever held that?
Not yet, in the following sense. There are many cases, they're all cited in Of Sovereignty and Federalism and in Fourth Amendment First Principles, which together, I think, just the two of them have been cited about 15 times by the Supreme Court, which is a lot. But most of what states have done before haven't been targeted causes of action against federal officials as such. Trespass law just protects people in general. Property law against private officials, against state officials, against county officials, and against federal officials.
And let me just interject. If Senator Waldstreicher amends the bill as he suggests he's thinking of doing to exclude state officials, this bill will only target federal officials.
Exactly.
So this will be the first time that a state has passed a law targeting federal officials and giving people the right of action to go against federal officials for monetary damages, something the Supreme Court has never sanctioned, correct?
Or prohibited. It's an open question. I'm being straight. This is why I got tenure at the age of 30, because I had this idea. It was an untested idea. It's still an untested idea, but many other states are beginning to do that now. This will reach the Supreme Court, and I cannot guarantee that 5 justices will say you can do that. Although, truthfully, I actually like the odds of such an approach. So just to give you why we call it Converse 1983, you just take a couple of words out of 1983 and flip them around. Converse 1983 is a federal statute that says when someone acting under color of state law violates the federal Constitution, you can sue that person. And it's targeted against states, state officials. And this would be a state law saying when someone under color of federal law violates your federal constitutional rights, you can do it.
In fact, in just 2 years ago, isn't it correct that there was legislation introduced in the Senate of the United States by 6 senators to change Section 1983 by inserting the words "of the United States" or before "of any state"?
Indeed.
And that bill didn't go anywhere, did it?
Sure, because the federal government doesn't like to pay when it does bad things. And I've been just this week in conversation, I will not disclose the names of U.S. senators' offices on this issue. But the feds you don't like imposing costs on your constituents any more than they do on theirs. And the genius, if I might, of Converse 1983 is, the feds are going to pay for their mistakes, but Congress, Congress can't always be trusted to police federal officials. Neither can federal judges that are paid by the federal government. And that's what Hamilton is saying. He's saying states are going to actually play an important role here, just as colonies did against Parliament. That's the thought.
Professor, thank you so much for this conversation.
Thank you, Senator.
Appreciate it.
All right. I feel like this is actually a really good place to end this hearing because, honestly, this is great. That was great. Senator McKay, go ahead. And then we've got Senator James.
I guess a sponsor, please. So if we do pass this, does this apply to any contractors, volunteers, private entities performing government functions?
So it would be a question of language. The bill as drafted says under color of law. And so the question that would litigate, the question for the court would be, are they acting under color of law?
Okay. So is this bill a new cause of action separate from the existing Section Federal 1983 claim, or does it mirror it?
It mirrors it at the state level.
At the state level.
So you currently have a cause of action in federal court against state officials. This mirrors that cause of action by providing you the exact same right against federal officials in state court.
So a follow-up, if I may, sir. So does that mean a plaintiff can bring both a claim and the federal 1983 claim at the same time?
So if we were to amend the bill as the Attorney General recommends, you would not be able to bring both because one would apply where the defendant was a federal official and one would apply where the defendant is a state official. Presumably, in almost all cases, those will be separate factual circumstances.
And, you know, this seems to be looking back at federalism and going back to the original intent of the states. Could you just maybe clarify, like, why we have titled this, what we have titled this bill?
Sure. So the title is just to make clear that no one is above the law. When you have constitutional rights, but no remedy to those rights, then the people who violate those rights are above the law. And the whole point of our founding, the whole idea of the originalism that you've heard today, is that no one is above the law, that the rule of law is supreme, and that you have rights. Those rights are given to you in the Constitution of the United States, our most sacrosanct document, our founding document, a living document that has been amended during the lifetime of everyone here. But those rights don't mean anything unless you can take action to vindicate it when they are wronged.
What would you say to people who would concur in what you just said, but by adding the words "No King's Act" has politicized something that is an exercise that needs to be, as the professor has said, probably needs to be settled, but yet added to those who might believe adding "No King's Act" politicizes it instead of making it an actual intent to be decided?
Well, 100% a fair question. It was not my intent to politicize the issue. If this committee is empathetic with what we're trying to do, but objects to the title, of course we can amend the title to be just a factual DLS-style title to move the bill forward.
Well, I would be more inclined to eliminate the political end of that and to come on and support this. So thank you for thank you for at least extending that. We'll see what the committee does.
Thank you for asking the question.
Thank you.
Thank you. It's probably for the professor, and it would be a little tutorial for me, brief if you can be, but I know it, and I loved constitutional law. It was my favorite subject in law school, and I'm completely rusty because unfortunately my law career didn't allow me to follow it other than casually. But I guess the ordinary citizen, I would think anywhere in the country would think, don't I already have the right to bring a cause of action against the federal government? I didn't know I needed a state, my state, to pass a law to let me do that. So what am I missing? Because I am surprised given, and this may be technical, you know, the essence of our country are states, despite what everybody seems to think around here. And I tend to be more an originalist, but not an extremist originalist. But the central, most important governmental unit in the country remains states, whether people understand that or not, right? So that's why I'm struggling with why we need a statute for something that seems fundamental.
It's a great question. Very quickly, for much of American history, when the federal government violated the Constitution, it was always also violating a common law interest. It's your property, and your property was the substratum underlying. So when they grabbed your property without due process or just compensation, you could just use property law. When they searched or seized you, that was typically a common law tort, and so common law protected most of our interests. Now today, the government can violate your Constitution without violating common law rights. I'll give you two examples. Let's take a wiretap. A wiretap actually that's upstream of the property line doesn't cross the property line and so might not be a state law trespass. So in a case called Katz, actually, the court said that's a Fourth Amendment violation. Well, now the Fourth Amendment is going beyond state law of trespass, and Katz was decided very shortly before Bivens. So after Katz comes along and says a wiretap can violate the Fourth Amendment, Bivens says, wow, now there's a gap between what the Fourth Amendment prohibits and what state common law, and so that's what Bivens came in, but I said, oh, I saw Bivens was being cut back. Give you one other example. Right. When there's discrimination against someone because they're black, because they're Catholic, because they're Protestant for that matter, or because they're male or white, when the government is engaged in discrimination, that might not violate a common law tort. If they basically say, you know, you'll get this job if you're of this stripe, but not of that stripe. So the Constitution now protects all sorts of interests that aren't protected at state common law in all sorts of ways. If the government, if they've made a contract with you, my friend mentioned cutting off, the federal government cutting off funding that they've promised to universities and all the rest. So that you might not quite have a common law claim against an individual in contract because you're not making the contract with the government official who signed it. You're making a contract with the government entity or something, and there may be some complexities there. So the answer is, in a nutshell, the Constitution now protects things that state common law doesn't always protect. So we need a general statute to deal with the gaps.
Sorry, I don't mean to make this longer. I'm sorry. I thought my question was about the Constitution. In other words, I heard you talk about the federal government may have come in and committed a trespass or whatever, and then it would, but that it would invoke, But
if they did a warrantless thing, state trespass is not going to give you a cause of action because there was no trespass.
But my question was, I'm surprised that an individual citizen of Maryland or any state hasn't always had the right to sue the federal government for violating their constitutional rights without the state having to first give you permission, and now you're connecting it back.
Yeah, until the modern era, you never sued directly under the Constitution. Even today, when you can sue it directly under the Constitution, it's typically only for an injunction. It's a case called Ex parte Young, but you actually can't typically sue for damages directly under the Constitution. That's what Senator, I believe, West was talking about. So Bivens basically said, since you can sue directly under the Constitution for damages, why not for injunctive relief, why not directly under the Constitution for damages? And a very great traditionalist, John Marshall Harlan the second, said, I get it. But today, the Supreme Court doesn't want to do that. They think that's judicial adventurism to let you sue directly under the Fourth Amendment or the Fifth Amendment or what have you.
Okay, that helps a lot. Thank you, Professor.
Thank you.
Thank you.
All right, further questions from the committee? All right, seeing none, thank you very much. Thank you both. All right, we'll now move on to the next panel. Let's hear from, well, he's virtual. Hold on, let's see. Okay, Mr. Harrison Stark, you were on the panel. You're up next, then we'll switch to some of the folks that are here virtually, and we'll go to Cynthia.
Wonderful. Thank you very much, Chair Smith, Vice Chair Waldstreicher, members of the committee. Thank you for the opportunity to speak today. My name is Harrison Stark. I'm Senior Counsel at the State Democracy Research Initiative at the University of Wisconsin Law School. Our work aims to advance research and dialogue on state-level democracy and government institutions, and one of our projects focuses on state checks against federal overreach, where we have done a deep dive building on Professor Amar's work on this kind of remedy, a state-created cause of action for constitutional violations that would apply to federal officials. I know the committee wants to hear from witnesses for only a couple of minutes, so I'll do my best to keep this brief. In short, this bill would fill a critical gap in the constitutional landscape. Rights are only as strong as their remedies, and in 2026, it is arguably harder today than at any other point in American history to sue federal officials for damages if they violate your constitutional rights. And critically, we believe that facially neutral bills like this one that apply to any person are legally sound. The Supremacy Clause of the Constitution does not bar state damages remedies against federal officials. In fact, for centuries, state tort suits against federal officials were the norm. Nor is this law, we believe, preempted by federal law. And during the Q&A, Senator West, for example, I'd be happy to dig into some of the originalist history about why we believe that. And the version of the bill that we looked at earlier was the initial bill as introduced. I have tremendous respect for the Office of the Attorney General. Respectfully, we would disagree as to the necessity of removing state and local officials from the bill. Under contemporary doctrine, states can apply facially neutral and even-handed regulations to the federal government. As soon as state legislation singles out the federal government alone, usually there are some constitutional difficulties, but critically, by including state and local officials in this bill, but extending the immunities that exist under federal 1983, this bill would pass constitutional muster, we believe, but would not actually increase liability for state and local officials. Again, happy to chat more about that during the Q&A. Thank you very much.
Cynthia, go ahead, and Ms. Rubinstein, go ahead. Welcome.
Thank you, Senator Smith and members of the JPR Committee. I'm Cynthia Rubinstein, president of the Women's Democratic Club of Montgomery County, otherwise known as WDC. WDC urges swift passage of SB 346, Civil Actions Violation of Constitutional Rights. We support its establishment of civil liability for an individual who, under color of law, deprives another of a right, a privilege, or an immunity secured by the U.S. Constitution. As federal immigration operations have escalated across the country, so too have reports of constitutional violations. In January, we as a country witnessed a masked ICE officer and masked Border Patrol agents kill 2 U.S. citizens who were trying to protect their neighbors. Masked federal law enforcement have also tear gassed peaceful protesters, detained individuals, including U.S. citizens, in horrific conditions, arrested children, assaulted the elderly, and threatened bystanders exercising basic First Amendment rights. Reports indicate that ICE believes it should be unconstrained by the Fourth Amendment. The escalation in Maryland has been devastating. ICE arrests in Maryland nearly tripled in 2025, with more than 3,300 people detained. Residents have reported that they've been targeted by immigration enforcement because of their race, national origin, and their political beliefs. Accountability is the best deterrent in the protection of our constitutional rights, and it should not depend on the badge an officer wears. WDC applauds the sponsors of SB 346. We ask you for a favorable report and strongly urge swift passage. Thank you.
Thank you very much, Ms. Rubinstein. Straight out of D20. Good to see you.
Good to see you as well, Senator.
Questions from the committee? All right, seeing none, thank you all very much. Thank you. All right, let's go back to our panelists joining us here in the committee room. Is Jane Bentrott here? Jane, come. Oh yeah, you already went. All right, let's go. Carrie Hansel, I see you here. Kristen Mack, and then Tiana Boardman. Hey, go ahead. Welcome.
Thank you, Senator Smith. It's nice to be with the committee again. My name is Carrie Hansel, but today I am representing a coalition of 13 different civil rights lawyers here in Maryland from 10 different civil rights law firms, which is to say these are the people who will be at the tip of the spear applying this statute here in our state to protect our citizens. We urge that it be passed, but only with critically important amendments. And that is with our thanks to the good efforts and good thoughts behind this bill. Unfortunately, as worded, it will do more harm than good to the fight for our civil rights here in Maryland. The reason for that is for the first time in the Maryland Code, and as far as we've been able to determine in any state's law in history, this bill as written will enshrine qualified immunity into state law. Why is that important? Qualified immunity is a doctrine born of racism. It was created in 1967 in a case called Pearson to deny recovery to freedom riders. And it is a doctrine that routinely denies reasonable, fair recovery and only applies when there is a violation of the Constitution. There is an easy fix that will not deny anyone the qualified immunity to which they may now be entitled. And we have submitted written testimony, and we urge an amendment to simply change the law from enshrining qualified immunity to instead stating that someone is entitled to whatever immunity they have at the time the claim is brought, which would include qualified immunity for now. That's incredibly important because new scholarship demonstrates that the original purpose of 42 U.S.C. 1983 excluded any immunities. In other words, there are current challenges in federal courts and in the legislature at the federal level, if I may finish, that might one day finally defeat the racist doctrine of qualified immunity. If we have enshrined it in Maryland law in the meantime, we will be denying our citizens the benefit of that change. And we can save that by simply changing from qualified immunity to you're entitled to whatever immunity is in place at the time. And it doesn't waive anything or make any other change other than avoiding this odious doctrine. Thank you.
Excellent. Thank you.
I almost said good afternoon, but good evening, everybody. Thanks for letting me be here today. My name is Kristen Mack. I am a civil rights attorney based out of Baltimore. I am one of the co-chairs of the Maryland Association for Justice Constitutional Rights section. This is all that we do is constitutional law cases. And I have to echo what Mr. Hansel just said. Qualified immunity, we do not want that written into our laws. We already have enough immunities that we have to overcome to protect people from government overstep. And qualified immunity is definitely not something we want to have to start dealing with for the first time in Maryland. So I think it's just super important. I love the idea of this bill, what we're trying to do. But like Mr. Hansel said, as it's currently written, this will just completely wipe out civil rights law in Maryland. 25, 30 plus years of trying to get the case law on our side, this would just set us back to square one. So I urge a favorable report with amendments. And if you guys have any questions, we are here to answer.
Excellent. Thank you very much. All right. Senator Henson has a question.
Thank you, Mr. Chairman. I'm trying to wrap my brain around the bill. If a person is acting in the scope of their duty and they're a government employee or a government official and they're acting in the scope of the duty, is the bill saying that they should be exposed to civil liability if in the performance of their government duty they violate someone's constitutional right?
Yes, in general. The term in the bill is under color of law. Okay. And sometimes for technical reasons that can be slightly different than the way you framed it. But yes, in general. I think for all relevant purposes, the answer is yes.
Is there not some sort of immunity that says if I am not in my own free will, but if I'm performing a job where I have a superior who's instructed me to do something and I'm simply following a command, that I have some limited form of liability or responsibility?
So not in that sense. There's no Nuremberg defense in America, and thank God for that, right? But there are a raft of about 6 different immunities that the professor could teach a law school class on that already exist here in Maryland, which are not qualified immunity at the state level, which is why we're urging that change to adopt and recognize the immunities that exist at the time the cause of action arises, whatever they may be.
Could you help me understand some of those? Give me a sense, a flavor.
Sure. So there's sovereign immunity, there's governmental immunity, there's public official immunity. Those are the 3 primary ones. There are at least 3 different statutory immunities that this body has passed that would cover, for instance, government employees, police officers, correctional officers, bus drivers, whomever they may be. In general, and this is somewhat of a simplification because otherwise we'd be here all night, but in general, if an individual actor in Maryland acts without malice or gross negligence and is within that color of law or scope of duty, then that individual is generally immunized under Maryland law. But this addresses something else, which is, can we now in Maryland bring what used to be a Bivens action in federal court against federal officers? And so as it relates to those federal officers, they might otherwise enjoy a type of immunity called qualified immunity. I wish Senator West was here, because some of the people he mentioned might enjoy an absolute immunity or other types of immunity, which is why our change is so important, to keep that playing field exactly where it is, and simply, instead of enshrining qualified immunity into Maryland law, say you're entitled to whatever immunity you have. So if you're a judge, you have judicial immunity. If you're a prosecutor, you have absolute immunity. If you're a member of this body, you would keep your legislative immunity with our change, rather than a statute that specifically calls out only 3 types of immunity, qualified immunity being one of them. And so there's this broad panoply of immunity that apply differently depending on whether you're a state or federal official, and depending on your role. And our change is to simply tie those immunities in place as they are, rather than enshrine certain of them in the law, while, as Senator West points out, we ignore other immunities. And that's the import of these changes. And they're critical because that qualified immunity is not one that Maryland's ever recognized. And it's utterly odious, and it's much more difficult than the Maryland immunities to overcome and deal with.
So if the bill overcomes the jurisdictional issue of pulling a federal officer into a state court, and you're able to do that under the bill successfully, and then you still have the layer of figuring out how you penetrate a person's scope of their official duty, and then all the immunities that would apply to that capacity, the work that they're doing there, then we then have that layer of analysis, right?
Correct. If our changes were accepted. If they aren't, then the federal immunities are somewhat collapsed. Other immunities are completely ignored, like this body's judicial immunity is completely ignored. Legislative immunity is completely ignored. Certain aspects of judicial immunity, if they don't comport with absolute immunity here, may be ignored. And that's why our change is so important, which is to change and simply say, any defense of immunity otherwise applicable at the time the action hereunder accrues shall apply. So all of these immunities would remain in place without the evil of Maryland adopting qualified immunity.
You're my immunity expert for the moment, if that's okay.
I'm happy to help in any way I can, Madam Senator.
I'm trying to think about any unintended consequences.
Well, that's what our amendment seeks to avoid.
I want to give a scenario.
So the unintended
Can I give you a scenario?
Oh, my apologies. Yes.
Okay. Let's say I'm a member of the Legislative Black Caucus, and let's say the Legislative Black Caucus has a desire to work with Black-owned businesses. And let's say someone that is not a Black-owned business, or a business that's not owned by a Black person, says, I feel personally aggrieved by that, and I think that my right to equal protection is being violated by this desire and this policy and this, preference for working with Black-owned businesses. Can I then bring a lawsuit against the members of the Legislative Black Caucus under a bill like this that says that if my constitutional right is being violated, and let's say that right is equal protection, does it open the door to bring a lawsuit like that?
I think that case would be frivolous before we got to the question of immunity. But I think it's an important question, because even somebody bringing a frivolous lawsuit might impact your life. So the more important answer, I think, is that with our amendments, your immunity would be just as it is when the cause of action arose. In other words, you would continue to have the current legislative immunity that you enjoy with our amendments. Without them, you'll search the bill for any mention of legislative immunity that you might otherwise assert. Similarly, other state employees and state officers would search the bill in vain, in many cases, for the immunity that they now enjoy. And rather than deny people immunity that this body and the courts have given them here in Maryland, while we pick the worst of federal immunity, this doctrine born in racism, and marry it permanently into Maryland law, we would ask this body instead merely change the language not to list specific communities, absolute, qualified, and sovereign, or what's in the bill now, but to simply say everyone enjoys whatever immunity they had at the time the cause of action arose, and that would allow you to be protected as a legislator. It would allow the people, every single one of the people that Senator West mentioned, to be protected and enjoy the immunity they now enjoy and avoid qualified immunity in Maryland law, so that those of us who fight against it at the federal level, and the professor who's currently speaking federally with members of that legislature, might one day defeat qualified immunity, and that change might be meaningful here in Maryland.
Your point is well taken on the textual change, and you noted that in the written testimony too. And understanding the legislative immunity is obviously of a particular interest to me. Another scenario, a person comments on one of our social media and we block or delete that person on social media, and they say, you violated my right to free speech. This is now the new marketplace of free speech. It is the public arena, and you violated my right by blocking me from this public forum. And now I want to sue the legislator for doing that. In the legislative immunity, I get that it covers us in our official capacity. You cast a green vote, a red vote for a bill, you can't sue me for the ensuing action that results from that policy if it changes your life. But if I, as an individual, am a legislator and I am doing something under the color of my title and my position, would the bill then create a cause of action for someone who wanted to sue me because I blocked them on social media?
Again, and I hate to keep turning back to our change, but this is one of the situations we're worried about. The bill as drafted does not preserve to you, as an employee of Maryland, your statutory immunity, which is over and above and different from your legislative immunity. So under both, for a state employee, it's the Maryland Tort Claims Act. For a local government employee, it's the Local Government Tort Claims Act. And they include within them immunity provisions that would protect you in addition to legislative immunity. This bill only, and again, you'll not find any reference to those immunities here. It only talks about absolute, qualified, or sovereign. So our change, again, would allow you all the immunity you have today without reference to qualified immunity. And so with this change, and it's, again, one of the many reasons we urge it, the example you just gave, you would enjoy the statutory immunity that applies to all state employees.
Got it. Thank you. Thanks, Mr. Chair.
Further questions from the committee? All right, seeing none, thank you both very much. We'll now switch over to another panel with favorable amendments. Mr. Pennick, you're joining us virtually, and we'll roll through the virtual testimony. Mr. Pennick, welcome.
Thank you, Mr. Chair, members of the committee. I am Mark Pennick. I'm the president of Maryland Shall Issue, and I appear in support of the bill with amendments. All I can say is that I've litigated this area for about 3.5 decades when I was at the U.S. Department of Justice, including immunities in U.S. Supreme Court and all the federal courts of appeals in the country. And I wanted to bring to the committee's attention the idea that if you can sue ICE or other federal law enforcement agents under this bill, it's probably going to be preempted by federal law, which is 28 U.S.C. Section 2680H allows federal tort claims suits be brought against federal law enforcement agents for assault, battery, false imprisonment, false arrest, abuse of process, or malicious prosecution. That doesn't cover everything, but it covers that. And under Section 2679 of Title 28, that remedy is exclusive. And there was an act passed by Congress called the Westfall Act that I litigated all the way to the Supreme Court, which held that an individual is individually immunized from further liability if it can be suit can be brought under the Federal Tort Claims Act. So the individual officer is going to be protected to that extent. Now, as to qualified immunity, let me join with Mr. Hansel, who, in full disclosure, has represented MSI in the past. I agree entirely with his suggestion of an amendment. Qualified immunity is an abomination. It's court-created. It's not found in any statute. It's certainly not found in any part of Section 1983, which, by the way, Senator Wallstreicher, that was enacted in 1871 as part of the Ku Klux Klan Act. So April 20th, you see the citation in my written testimony. So the idea that you can, there's a lot of immunities involved here. So let me turn to why are you forgetting to mention the rights secured by the Maryland Constitution? You should expand the bill to include that. I'm happy to take questions.
Thank you very much, Mr. Pennick. All right. Do we have anyone else in the Zoom room? Okay. Ms. Sample, would you like to come on up? I believe you are the last witness on this bill, so welcome.
All right, good evening, everyone. Thank you for having me. My name is Sarah Sample, here with the Maryland Association of Counties, and we are here to support with amendment this bill. At this late hour, I have also been sent with Maryland Municipal League's proxy on this bill, so they're also support with amendment. I would say that it is more sort of a no position with our amendments. I would say when the bills first started dropping, we started looking into the No Kings Acts in other states and then talking to the sponsors of the bills here in Maryland. And it seemed clear from the start that this was not necessarily supposed to be directed at local governments, and we might have been inadvertently included. In some of those conversations that we have started, we spoke with the House sponsors, and they have asked for our amendments, and they said they'd be willing to consider our amendments to get our concerns addressed, which, as you heard Senator West already mentioned, is mainly the attorney's fees provision. So if you look at our testimony, one of the ways that we suggested that we could potentially be taken out is just a section that says this section doesn't apply to local governments or state governments or their personnel. And I would also add that there is another No Kings Act bill on the House side from Delegate Martinez that I think maybe is a little bit more clear about this being directed at federal agencies and federal actors. So that's another suggestion. But yeah, we are support with amendments, but essentially if we were just carved out, we would turn to no position with amendments.
Thank you very much, Ms. Sample. Questions for Ms. Sample? All right, thank you.
Thank you.
All right, with that, that'll conclude the testimony in the hearing for Senate Bill 346. We'll now move on to Senate Bill 347. Senator Muse.
Thank you, Mr. Chair, Vice Chair. For the record, I'm C. Anthony Muse, representing the 26th Legislative District, Prince George's County. I want to present a bill that we've heard before, Senate Bill 347, which updates Maryland's driver's license suspension law for non-payment of child support. Here on my panel, I have Christopher Dews, representing the Center for Urban Families, and Dewan Burton from Office of Justice. Okay. Federal law requires states to suspend driver's licenses in appropriate cases. Maryland law currently mandates automatic suspension after 120 days of non-payment, without any individualized determination. The process is fully automated, as you know, and it does not consider whether suspension will actually increase compliance or make it harder for someone to pay. As a result, we are seeing licenses suspended for individuals who are making payments, who are not truly in the arrears, who are disabled, or who have primary custody of their children. In those situations, taking a driver's license prevents people from working, which ultimately hurts the very children this system is meant to support. This bill defines suspension as appropriate only when an obligor has the ability to pay, but is willfully choosing not to. It clarifies when suspension is inappropriate, such as when the arrearage is inaccurate, when the obligor is complying with the payment agreement, when suspension would interfere with employment, or when it would cause undue hardship due to disability. This bill does not weaken child support enforcement. It makes it more effective and accurate while keeping Maryland in compliance with federal law. And so for these reasons, I respectfully urge a favorable report from you, the committee. Thank you. After this long day, thank God we made it.
Christopher Dews, representing the Center for Urban Families Workforce Development Program in West Baltimore.
And as the senator said, the purpose of this bill is simply to align Maryland with federal law and establishing a definition of when a license suspension would be appropriate and assist with the implementation of last year's bill. Now, I know you all have probably sick and tired of hearing about license suspensions, as am I. The reasoning why we are looking at this specific issue is because, as the senator mentioned, we are still seeing situations which this is the purpose of the bill to clarify, where individuals have custody of their child, but they're getting licenses suspended. They are disabled, which is supposed to be exempted, but they're getting licenses suspended in plenty of other cases. As was written in Maryland Legal Aid's testimony, since they could not be here to testify, I'll read this quick story from one of their clients. On page 4 of their testimony, it says, Mr. P was also granted custody of his son in the circuit court. The court terminated his obligation to pay child support in light of the change in custody. Mr. P provided copies of both court orders to the child support agency, but his driver's license was still suspended. Mr. P drives a truck for a living, and he had no idea that his license had been suspended until he was out of the state, making a work delivery to a military base. The military base ran a routine background check, which revealed that his license had been suspended, and as a result of the license suspension, Mr. P was terminated from his job with that trucking company. The key thing is that he was granted custody of his son in the circuit court, and the court, court terminated his obligation to pay child support, and his license was still suspended. So we just think that this, the purpose of this bill is to reduce the error rate. What the bill specifically does is it defines when a suspension is appropriate. It provides written and electronic notice to obligors about the license suspensions. And also we added in that it expands that a suspension would not be appropriate if the minor child resides with the obligor. I know that the sponsor on the House side is having conversations with DHS about the fiscal note and everything else. Happy to answer any questions. Thank you.
Good evening. Good night. My name is DeJuan Burton. I am the Deputy Director of Out for Justice, and I stand before you currently in my capacity as a grassroots leader, assisting and advocating for policies that remove harmful barriers for impacted families, but also as a custodial parent. Senate Bill 347 simply clarifies and prevents the act of license suspension by CSA, which up to this point has been arbitrary without due process for the obligor or for the consideration of mitigating factors. When parents have a copacetic relationship and support the needs of their kids, weaponizing a parent's driver's license can cripple a stable, cohesive co-parenting system. License suspension is but one tool that CSA has at their disposal to collect on a child support order. It's not the only tool, yet it is frequently the first one used. This bill simplifies when it is appropriate to suspend a license for common sense purposes. In my personal experience, despite having custody of his other kids, my son's father routinely faced license suspension. This constant threat of suspension, despite numerous attempts to correct the record with CSA, meant he had no method of transportation to get to work, pick up his kids, or the child we shared. Thus, I was left transporting the kids back and forth to school, daycare, and soccer practice, which was a massive disruption to our daily routines. Another Out for Justice member waited 8 months for his final child support hearing, and thus, once the order was finalized in court, that day he was immediately $9,000 in arrears. And without common sense laws like Senate Bill 347 in place, his driver's license which he depended on as an Uber driver, was suspended shortly thereafter. We correct these oversights by passing Senate Bill 347 that provides clear guidance for when license suspension is appropriate for child support arrearages. I urge the committee to codify how Maryland enforces policies by a favorable report on Senate Bill 347. Thank you.
Thank you for your testimony. Questions for the sponsor or this panel? Senator Sidnord.
Thank you very much. Have you all had an opportunity to review the family law sections of MSBA's their testimony?
I do know there was some, I have not had a chance to review it in detail. I just was informed by, I want to say, the House sponsor that there were concerns around the ability to verify the income, which I believe was already just worked on and handled in last year's legislation. However, I will say that the House sponsor is in conversation with DHS about tightening up the language with regards to how they define, like how they discover if a person is making a free and conscious choice. I think that's specifically what their language said.
And I know that those conversations are ongoing. Also, just to highlight that free and conscious choice is also already in current law. I want to say Family Law 12-201 with regards to voluntary impoverishment. I'm sorry if that didn't answer the question, Senator.
Oh, since you mentioned that and you said it's already in the law, I'm just going to read what they have and you can respond accordingly. It says Senate Bill 347 conditions driver's license suspension for child support arrearages on 2 new requirements. 1, that the Child Support Administration verify the obligor is making a free and conscious choice to withhold payment despite having the funds to pay, and 2, that the administration provide mandatory electronic notice to the obligor. While well-intentioned, these provisions create enforcement barriers that risk rendering license suspension largely unworkable. The requirement that the administration determine an obligor is making a free and conscious choice to withhold payment imposes a subjective, intent-based standard that is exceptionally difficult to establish at any level, let alone by an administrative agency. Now, given the testimony you just said, you testified that this free and conscious choice term is language in the law?
It's in other portions of the law, yes. I will say we are happy to remove that specific language was put into the bill so that we would be inconsistent with other statutes in Maryland family law. So again, I think that's a conversation that is currently happening with DHS and the sponsor. But I think that answers the first part of it. I think the second thing you mentioned was electronic notice. I know written notice is already being submitted or supposed to be submitted with regards to notification that your license will be suspended. Also, with the supposed to be submitted as well for the obligor to know that they have the right to request an investigation. Adding an electronic means would simply be, and if this needs to be added into, to be specific, that adding electronic means if they have access to that person's email address or something to that effect, we're happy to add that language.
Thank you very much.
Thank you, sir.
Thank you. Seeing no further questions for this panel, thank you so much. We will now move to the opposition to the bill, Mr. Madden. Brendan Madden from the Family Law.
It is the end of a long day, so I will be brief. The MSBA opposes this bill, and as the senator shared, to some extent, our focus is on the imposition of these new requirements for suspending a driver's license. And fortunately, it was brought up in the questions, but Mr. Dews in his testimony didn't make any mention of this free and conscious choice requirement. To the MSBA, we are familiar with that. It is the language of voluntary impoverishment, which is a decision and determination that's made by a judge in an adjudicative proceeding. DHS and the Child Support Administration, that's not something they're equipped to handle. It's not something that they are equipped to determine. And the practical effect is if something like that is a threshold determination before this very effective penalty can be utilized, the effect will be that it won't be utilized at all. Similarly, with the requirement for written and electronic notice, and I do appreciate Mr. Dews' concession that maybe there could be an amendment, conditioning on the availability of an email, but the concern would be that an obligor doesn't provide an email, or intentionally or not. Maybe they never gave one. Maybe it's an out-of-date email, and all of a sudden we have another hurdle to utilizing one of the most effective remedies for the collection and enforcement of child support. And whether anyone has a personal feeling on that, the federal government certainly feels that it is an effective and useful tool for child support enforcement, and federal funding is conditioned on the implementation of effective driver's license suspension programs, is my understanding. So any bill like this that would potentially curtail the entire system and put a roadblock up for implementation would risk the most crucial part of our entire child support system, which is to maintain that access to the federal funding and, of course, support the best interest of children.
Thank you, Mr. Madden. Any questions for the opposition? All right, seeing no question, that completes the hearing for Senate Bill 347. Thank you, Senator Muse, and that completes our hearings for today. Don't forget, tomorrow's schedule is a little different. State of the State, I think we're on the floor at 11.
Let's get this bill voted on.